Chapter 12 of an Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Claude Banta. An Introduction to the Principles of Morals and Legislation, Chapter 12 of the Consequences of a Mischievous Act. Shapes in which the mischief of an act may show itself. Hitherto we have been speaking of the various articles or objects on which the consequences or tendency of an act may depend, of the bare act itself, of the circumstances it may have been or may have been supposed to be accompanied with, of the consciousness a man may have had with respect to any such circumstances, of the intentions that may have preceded the act, of the motives that may have given birth to those intentions, and of the disposition that may have been indicated by the connection between such intentions and such motives. We now come to speak of the consequences or tendency, an article which forms the concluding link in all this chain of causes and effects, involving in it the materiality of the whole. Now, such part of this tendency as is of a mischievous nature is all that we have any direct concern with. To that, therefore, we shall here confine ourselves. The tendency of an act is mischievous when the consequences of it are mischievous. That is to say, either the certain consequences or the probable. The consequences, how many and whatsoever there may be of an act of which the tendency is mischievous, may such of them as are mischievous be conceived to constitute one aggregate body, which may be termed the mischief of the act. This mischief may frequently be distinguished, as it were, into two shares or parcels, the one containing what may be called the primary mischief, the other what may be called the secondary. That share may be termed the primary, which is sustained by an assignable individual or a multitude of assignable individuals. That share may be termed the secondary, which is taking its origin from the former, extends itself over the whole community, or over some other multitude of unassignable individuals. The primary mischief of an act may again be distinguished into two branches, 1. The original, and 2. The derivative. By the original branch, I mean that which alights itself upon and is confined to any person who is a sufferer in the first instance, and on his own account. The person, for instance, who is beaten, robbed, or murdered. By the derivative branch, I mean any share of mischief which may befall any other assignable persons in consequence of his being a sufferer, and no otherwise. These persons must, of course, be persons who in some way or other are connected with him. Now, the ways in which one person may be connected with another have been already seen. They may be connected in the way of interest, meaning self-regarding interest, or merely in the way of sympathy. And again, persons connected with a given person in the way of interest may be connected with him either by affording support to him or by deriving it from him. The secondary mischief, again, may frequently be seen to consist of two other shares or parcels, the first consisting of pain, the other of danger. The pain which it produces is a pain of apprehension, a pain grounded on the apprehension of suffering such mischiefs or inconveniences, whatever they may be, as it is the nature of the primary mischief to produce. It may be styled, in one word, the alarm. The danger is the chance, whatever it may be, which the multitude it concerns may in consequence of the primary mischief stand exposed to, of suffering such mischiefs or inconveniences, for danger is nothing but the chance of pain, or, what comes to the same thing, the loss of pleasure. An example may serve to make this clear. A man attacks you on the road and robs you. You suffer a pain on the occasion of losing so much money. You also suffered a pain at the thoughts of the personal ill treatment you apprehended he might give you in case of your not happening to satisfy his demands. These together constitute the original branch of the primary mischief, resulting from the act of the robbery. A creditor of yours, who expected you to pay him with part of that money, and a son of yours, who expected you to have given him another part, are in consequence disappointed. You are obliged to have recourse to the bounty of your father to make good part of the deficiency. These mischiefs together make up the derivative branch. The report of this robbery circulates from hand to hand and spreads itself in the neighborhood. It finds its way into the newspapers and is propagated over the whole country. Various people on this occasion call to mind the danger which they and their friends, as it appears from this example, stand exposed to in traveling, especially such as may have occasion to travel the same road. On this occasion they naturally feel a certain degree of pain, slighter or heavier, according to the degree of ill treatment they may understand you to have received. The frequency of the occasion each person may have to travel in that same road or its neighborhood, the vicinity of each person to the spot, his personal courage, the quantity of money he may have occasion to carry about with him, and a variety of other circumstances. This constitutes the first part of the secondary mischief, resulting from the act of robbery, viz., the alarm. But people, of one description or another, not only are disposed to conceive themselves to incur a chance of being robbed, in consequence of the robbery committed upon you, but, as will be shown presently, they do really incur such a chance. And it is this chance which constitutes the remaining part of the secondary mischief of the act of robbery, viz., the danger. Let us see what this chance amounts to, and whence it comes. How is it, for instance, that one robbery can contribute to produce another? In the first place, it is certain that it cannot create any direct motive. A motive must be the prospect of some pleasure or other advantage to be enjoyed in future. But the robbery in question is past, nor would it furnish any such prospect were it to come, for it is not one robbery that will furnish pleasure to him who may be about to commit another robbery. The consideration that is to operate upon a man as a motive or inducement to commit a robbery must be the idea of the pleasure he expects to derive from the fruits of that very robbery. But this pleasure exists independently of any other robbery. The means, then, by which one robbery tends, as it should seem, to produce another robbery are two. 1. By suggesting to a person exposed to the temptation the idea of committing such another robbery, accompanied perhaps with a belief of its facility. In this case the influence it exerts applies itself in the first place to the understanding. 2. By weakening the force of the tutelary motives which tend to restrain him from such an action, and thereby adding to the strength of the temptation. In this case the influence applies itself to the will. These forces are, 1. The motive of benevolence, which acts as a branch of the physical sanction. 2. The motive of self-preservation, an agent of the punishment that may stand provided by the political sanction. 3. The fear of shame, a motive belonging to the moral sanction. 4. The fear of the divine displeasure, a motive belonging to the religious sanction. On the first and the last of these forces it has perhaps no influence worth insisting on, but it has on the other two. The way in which a past robbery may weaken the force with which the political sanction tends to prevent a future robbery may be thus conceived. The way in which this sanction tends to prevent a robbery is by denouncing some particular kind of punishment against any who shall be guilty of it, the real value of which punishment will of course be diminished by the real uncertainty, as also, if there be any difference, the apparent value by the apparent uncertainty. Now this uncertainty is proportionally increased by every instance in which a man is known to commit the offense without undergoing the punishment. This, of course, will be the case with every offense for a certain time, in short, until the punishment allotted to it takes place. If punishment takes place at last, this branch of the mischief of the offense is taken at last, but not till then put a stop to. The way in which a past robbery may weaken the force with which the moral sanction tends to prevent a future robbery may be thus conceived. The way in which the moral sanction tends to prevent a robbery is by holding forth the indignation of mankind, as ready to fall upon him who shall be guilty of it. Now this indignation will be the more formidable according to the number of those who join in it. It will be the less so, the fewer they are who join in it. But there cannot be a stronger way of showing that a man does not join in whatever indignation may be entertained against a practice than the engaging in it himself. It shows not only that he himself feels no indignation against it, but that it seems to him there is no sufficient reason for apprehending what indignation may be felt against it by others. Accordingly, where robberies are frequent and unpunished, robberies are committed without shame. It was thus against the Grecians formerly, it is thus among the Arabs still. In whichever way, then, a past offense tends to pave the way for the commission of a future, hence, whether by suggesting the idea of committing it, or by adding to the strength of the temptation, in both cases it may be said to operate by the force or influence of example. The two branches of the secondary mischief of an act, the alarm and the danger, must not be confounded. Though intimately connected, they are perfectly distinct. Either may subsist without the other. The neighborhood may be alarmed with the report of a robbery, when in fact no robbery either has been committed or is in a way to be committed. A neighborhood may be on the point of being disturbed by robberies without knowing anything of the matter. Accordingly, we shall soon perceive that some acts produce alarm without danger, others danger without alarm. As well the danger as the alarm may again be divided, each of them into two branches, the first consisting of so much of the alarm or danger as may be apt to result from the future behavior of the same agent, the second consisting of so much as they may be apt to result from the behavior of other persons, such others to wit as may come to engage in acts of the same sort and tendency. The distinction between the primary and the secondary consequences of an act must be carefully attended to. It is so, just that the latter may often be a directly opposite nature to be the former. In some cases, where the primary consequences of an act are attended with a mischief, the secondary consequences may be beneficial, and that to such a degree as even greatly to outweigh the mischief of the primary. This is the case, for instance, with all acts of punishment when properly applied. Of these, the primary mischief never intended to fall but upon such persons as may happen to have committed some act which it is expedient to prevent. The secondary mischief, that is, the alarm and the danger, extends no further than to such persons as are under temptation to commit it, in which case, in as far as it tends to restrain them from committing such acts, it is of a beneficial nature. Thus much with regard to acts that produce positive pain, and that immediately. This case, by reason of its simplicity, seemed the fittest to take the lead. But acts may produce mischief in various other ways, which, together with those already specified, may all be comprised by the following abridged analysis. Mischief may admit a division in any one of 3 points of view: 1. According to its own nature, 2. According to its cause, 3. According to the person or other party who is the object of it. With regards to its nature, it may be either simple or complex. When simple, it may either be positive or negative. Positive, consisting of actual pain; negative, consisting of the loss of pleasure. Whether simple or complex, positive or negative, it may be either certain or contingent. When it is negative, it consists of the loss of some benefit or advantage. This benefit may be material in both or either of two ways: 1. By affording actual pleasure, or 2. By averting pain or danger, which is the chance of pain, that is, by affording security. In as far, then, as the benefit which a mischief tends to avert is productive of security, the tendency of such mischief is to produce insecurity. With regard to its cause, mischief may be produced either by one single action, or not without the concurrence of other actions. If not without the concurrence of other actions, these others may be the actions either of the same person or of other persons. In either case, they may be either acts of the same kind as that in question, or of other kinds. Lastly, with regard to the party who is the object of the mischief, or in other words, who is in a way to be affected by it, such party may be either an assignable individual, or assemblage of individuals, or else a multitude of unassignable individuals. When the object is an assignable individual, this individual may either be the person himself who is the author of the mischief, or some other person. When the individuals who are the objects of it are an unassignable multitude, this multitude may be either the whole political community or state, or some subordinate division of it. Now, when the object of the mischief is the author himself, it may be styled self-regarding. When any other party is the object, extra-regarding. When such other party is an individual, it may be styled private. When a subordinate branch of the community, semi-public. When the whole community, public. Here, for the present, we must stop. To pursue this subject through its inferior distinctions will be the business of the chapter which exhibits the division of offenses. The cases which have been already illustrated are those in which the primary mischief is not necessarily otherwise than a simple one, and that positive, present, and therefore certain, producible by a single action without any necessity of the concurrence of any other action, either on the part of the same agent or of others, and having for its object an assignable individual, or by accident an assemblage of assignable individuals, extra-regarding therefore and private. This primary mischief is accompanied by a secondary, the first branch of which is sometimes contingent and sometimes certain, the other never otherwise than contingent, both extra-regarding and semi-public, in other respects pretty much upon a par with the primary mischief, except that the first branch, viz. The alarm, though inferior in magnitude to the primary, is in point of extent, and therefore upon the whole, in point of magnitude much superior. 2 instances more will be sufficient to illustrate the most material of the modifications above exhibited. A man drinks a certain quantity of liquor and intoxicates himself. The intoxication, in this particular instance, does him no sort of harm, or what comes to the same thing, none that is perceptible. But it is probable, and indeed next to certain, that a given number of acts of the same kind would do him a very considerable degree of harm, more or less according to his constitution and other circumstances, for this is no more than what experience manifests every day. It is also certain that one act of this sort, by one means or another, tends considerably to increase the disposition of a man, may be to practice other acts of the same sort, for this also is verified by experience. This, therefore, is one instance where the mischief producible by the act is contingent, in other words, in which the tendency of the act is no otherwise mischievous than in virtue of its producing a chance of mischief. This chance depends upon the concurrence of other acts of the same kind, and those such as must be practiced by the same person. The object of the mischief is that very person himself who is the author of it, and he only, unless by accident. The mischief is therefore private and self-regarding. As to its secondary mischief, alarm, it produces none. It produces indeed a certain quantity of danger by the influence of example, but it is not often that this danger will amount to a quantity worth regarding. Again, a man omits paying his share to a public tax. This, we see, is an act of the negative kind. Is this then to be placed upon the list of mischievous acts? Yes, certainly. Upon what grounds? Upon the following. To defend the community against its external as well as its internal adversaries are tasks, not to mention others of a less indispensable nature, which cannot be fulfilled but at a considerable expense. But whence is the money for defraying this expense to come? It can be obtained in no other manner than by contributions to be collected from individuals, in a word, by taxes. The produce then of these taxes is to be looked upon as a kind of benefit which it is necessary the governing part of the community should receive for the use of the whole. This produce, before it can be applied to its destination, requires that there should be certain persons commissioned to receive and to apply it. Now, if these persons, had they received it, would have applied to it its proper destination, it would have been a benefit. The not putting them in a way to receive it is then a mischief. But it is possible that if received, it might not have been applied to its proper destination, or that the service, in consideration of which it was bestowed, might not have been performed. It is possible that the under-officer who collected the produce of the tax might not have paid it over to his principal. It is possible that the principal might not have forwarded it on according to its farther destination. To the judge, for instance, who is to protect the community against its clandestine enemies from within, or the soldier who is to protect it against its open enemies from without. It is possible that the judge or the soldier, had they received it, would not, however, have been induced by it to fulfill their respective duties. It is possible that the judge would not have sat for the punishment of criminals and the decision of controversies. It is possible that the soldier would not have drawn his sword in the defense of the community. These, together with an infinity of other intermediate acts, which for the sake of brevity I pass over, form a connected chain of duties, the discharge of which is necessary to the preservation of the community. They must, every one of them, be discharged, ere the benefit to which they are contributory can be produced. If they are all discharged, in that case the benefit subsists, and any act, by tending to intercept that benefit, may produce a mischief. But if any one of them are not, the benefit fails. It fails of itself. It would not have subsisted, although the act in question, the act of non-payment, had not been committed. The benefit is therefore contingent, and, accordingly, upon a certain supposition, the act which consists in the averting of it is not a mischievous one. But this supposition, in any tolerably ordered government, will rarely indeed be verified. In the very worst ordered government that exists, the greatest part of the duties that are levied are paid over according to their destination, and with regard to any particular sum that is attempted to be levied upon any particular person upon any particular occasion, it is therefore manifest that unless it be certain that it will not be so disposed of, the act of withholding it is a mischievous one. The act of payment, when referable to any particular sum, especially if it be a small one, might also have failed of proving beneficial on another ground, and consequently, the act of non-payment, of proving mischievous. It is possible that the same services precisely might have been rendered without the money as with it, if, then speaking of any small limited sum, such as the greatest which any one person is called upon to pay at a time, a man were to say that the non-payment of it would be attended with mischievous consequences. This would be far from certain, but what comes to the same thing, as if it were, it is perfectly certain when applied to the whole. It is certain that if all of a sudden the payment of all taxes was to cease, there would no longer be anything effectual done, either for the maintenance of justice or for the defense of the community against its foreign adversaries; that therefore the weak would presently be oppressed and injured in all manner of ways by the strong at home, and both together overwhelmed by oppressors abroad. Upon the whole, therefore, it is manifest that in this case, though the mischief is remote and contingent, though in its first appearance it consists of nothing more than the interception of a benefit, and though the individuals in whose favor that benefit would have been reduced into the explicit form of pleasure or security are altogether unassignable, yet the mischievous tendency of the act is not on all these accounts the less indisputable. The mischief, in point of intensity and duration, is indeed unknown. It is uncertain, it is remote, but in point of extent it is immense, and in point of fecundity pregnant to a degree that baffles calculation. It may now be time to observe that it is only in the case where the mischief is extra-regarding, and has an assignable person or persons for its object, that so much of the secondary branch of it as consists in alarm can have place. When the individuals it affects are uncertain and altogether out of sight, no alarm can be produced, as there is nobody whose sufferings you can see. There is nobody whose sufferings you can be alarmed at. No alarm, for instance, is produced by non-payment to a tax. If, at any distance and uncertain period of time, such offense should chance to be productive of any kind of alarm, it would appear to proceed, as indeed immediately it would proceed, from a very different cause. It might be immediately referable, for example, to the act of a legislator, who should deem it necessary to lay on a new tax in order to make up for the deficiency occasioned in the produce of the old one; or it might be referable to the act of an enemy, who, under favor of a deficiency thus created in the fund allotted for defense, might invade the country, and exact from it much heavier contributions than those which had been thus withholden from the sovereign. As to any alarm which such an offense might raise, among the few who might chance to regard the matter with the eyes of a statesman, it is of too slight and uncertain a nature to be worth taking into the account. Section 2. How intentionality, etc., may influence the mischief of an act. We have seen the nature of the secondary mischief, which is apt to be reflected, as it were, from the primary, in the cases where the individuals who are the objects of the mischief are assignable. It is now time to examine into circumstances upon which the production of such secondary mischief depends. These circumstances are no others than the 4 articles which have formed the subjects of the 4 last preceding chapters, viz. 1. The intentionality, 2. The consciousness, 3. The motive, 4. The disposition. It is to be observed all along that it is only the danger that is immediately governed by the real state of the mind in respect to those articles. It is by the apparent state of it that the alarm is governed. It is governed by the real only in as far as the apparent happens, as, in most cases, it may be expected to do, to quadrate the real. The different influences of the articles of intentionality and consciousness may be represented in the several cases following. Case 1. Where the act is so completely unintentional as to be altogether involuntary. In this case it is attended with no secondary mischief at all. A bricklayer is at work upon a house. A passenger is walking in the street below. A fellow workman comes and gives the bricklayer a violent push, in consequence of which he falls upon the passenger and hurts him. It is plain there is nothing in this event that can give other people, who may happen to be in the street, the least reason to apprehend anything in future on the part of the man who fell, whatever there may be with regard to the man who pushed him. Case 2. Where the act, though not intentional, is unadvised, insomuch that the mischievous part of the consequence is unintentional, but the unadvisedness is attended with heedlessness. In this case the act is attended with some small degree of secondary mischief, in proportion to the degree of heedlessness. A groom, being on horseback, and riding through a frequented street, turns a corner at full pace, and rides over a passenger, who happens to be going by. It is plain, by this behavior of the groom some degree of alarm may be produced, less or greater according to the degree of heedlessness betrayed by him, according to the quickness of his pace, the fullness of the street, and so forth. He has done mischief, it may be said, by his carelessness, already. Who knows but on the other occasions the like cause may produce the like effect. Case 3. Where the act is misadvised with respect to a circumstance, which, had it existed, would fully have excluded, or, what comes to the same thing, outweighed the primary mischief, and there is no rashness in the case. In this case the act attended with no secondary mischief at all. It is needless to multiply examples any further. Case 4. Where the act is misadvised with respect to a circumstance which would have excluded or counterbalanced the primary mischief in part but not entirely, and still there is no rashness. In this case the set is attended with some degree of secondary mischief, in proportion to that part of the primary which remains unexcluded or uncounterbalanced. Case 5. Where the act is misadvised with respect to a circumstance which, had it existed, would have excluded or counterbalanced the primary mischief entirely or in part, and there is a degree of rashness in the supposal. In this case the act is also attended with a farther degree of secondary mischief, in proportion to the degree of rashness. Case 6. Where the consequences are completely intentional, and there is no missupposal in the case. In this case the secondary mischief is at the highest. This much with regard to intentionality and consciousness. We now come to consider in what manner the secondary mischief is affected by the nature of the motive. Where an act is pernicious in its primary consequences, the secondary mischief is not obliterated by the goodness of the motive, though the motive be of the best kind. For notwithstanding the goodness of the motive, an act of which the primary consequences are pernicious is produced by it in the instance in question by the supposition. It may therefore, in other instances, although this is not so likely to happen from a good motive as from a bad one, An act which, though pernicious in its primary consequences, is rendered in other respects beneficial upon the whole by virtue of its secondary consequences, is not changed back again and rendered pernicious upon the whole by the badness of the motive, although the motive be of the worst kind. But when not only the pernicious consequences of an act are pernicious, but in other respects the secondary likewise, the secondary mischief may be aggravated by the nature of the motive, so much of that mischief, to wit, as respects the future behavior of the same person. It is not from the worst kind of motive, however, that the secondary mischief of an act receives its greatest aggravation. The aggravation which the secondary mischief of an act, in as far as it respects the future behavior of the same person, receives from the nature of a motive in an individual case, is as the tendency of the motive to produce on the part of the same person acts of the like bad tendency with that of the act in question. The tendency of a motive to produce acts of the like kind on the part of any given person is as the strength and constancy of its influence on that person as applied to the production of such effects. The tendency of a species of motive to give birth to acts of any kind among persons in general is as the strength, constancy, and extensiveness of its influence as applied to the production of such effects. Now the motives, whereof the influence is at once most powerful, most constant, and most extensive, are the motives of physical desire, the love of wealth, the love of ease, the love of life, and the fear of pain, all of them self-regarding motives. The motive of displeasure, whatever it may be in point of strength and extensiveness, is not near so constant in its influence, the case of mere antipathy excepted, as any of the other three. A pernicious act, therefore, when committed through vengeance or otherwise through displeasure, is not near so mischievous as the same pernicious act when committed by force of any one of those other motives. As to the motive of religion, whatever it may sometimes prove to be in point of strength and constancy, it is not in point of extent so universal, especially in its application to acts of a mischievous nature, as any of the three preceding motives. It may, however, be as universal in a particular state or in a particular district of a particular state. It is liable, indeed, to be very irregular in its operations. It is apt, however, to be frequently as powerful as the motive of vengeance, or indeed any other motive whatsoever. It will sometimes even be more powerful than any other motive. It is, at any rate, much more constant. A pernicious act, therefore, when committed through the motive of religion, is more mischievous than when committed through the motive of ill will. Lastly, the secondary mischief, to wit, so much of it as hath respect to the future behavior of the same person, is aggravated or lessened by the apparent depravity or beneficence of his disposition, and that in the proportion of such apparent depravity of beneficence. The consequences we have hitherto been speaking of are the natural consequences, of which the act and the other articles we have been considering are the causes, consequences that result from the behavior of the individual who is the offending agent without the interference of political authority. We now come to speak of punishment, which, in the sense in which it is here considered, is an artificial consequence, annexed by political authority to an offensive act, in one instance, in the view of putting a stop to the production of events similar to the obnoxious part of its natural consequences in other instances. End of chapter 12.
Chapter 13 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Gary Gilbert. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 13. Cases unmeet for punishment. Section 1. General view of cases unmeet for punishment. 1. The general object which all laws have, or ought to have, in common, is to augment the total happiness of the community, and therefore, in the first place, to exclude, as far as may be, everything that tends to subtract from that happiness; in other words, to exclude mischief. 2. But all punishment is mischief. All punishment in itself is evil. Upon the principle of utility, if it ought at all to be admitted, it ought only to be admitted in as far as it promises to exclude some greater evil. What follows, relative to the subject of punishment, ought regularly to be preceded by a distinct chapter on the ends of punishment. But having little to say on that particular branch of the subject which has not been said before, it seems better, in a work which will at any rate be but too voluminous, to omit this title, reserve it for another, hereafter to be published, entitled The Theory of Punishment. This is the work which, from the author's papers, has since been published by Mr. Dumont in French, in company with The Theory of Reward, and added to it, for the purpose of mutual illustration. It is in contemplation to publish them both in English, from the author's manuscripts, with the benefit of any amendments that have been made by Mr. Dumont. Note to edition of 1823. To the same work I must refer the analysis of the several possible modes of punishment, a particular and minute examination of the nature of each, and of its advantages and disadvantages, the various other disquisitions, which did not seem absolutely necessary to be inserted here. A very few words, however, concerning the ends of punishment can scarcely be dispensed with. The immediate principal end of punishment is to control action. This action is either that of the offender or of others. That of the offender it controls by its influence either on his will, in which case it is said to operate in the way of reformation, or on his physical power, in which case it is said to operate by disablement. That of others it can influence otherwise than by its influence over their wills, in which case it is said to operate in the way of example. A kind of collateral end, which it has a natural tendency to answer, is that of affording a pleasure or satisfaction to the party injured, where there is one, and, in general, to parties whose ill will, whether on a self-regarding account, or on the account of sympathy or antipathy, has been excited by the offence. This purpose, as far as it can be answered gratis, is a beneficial one. But no punishment ought to be allotted merely to this purpose, because, setting aside its effects in the way of control, no such pleasure is ever produced by punishment as can be equivalent to the pain. The punishment, however, which is allotted to the other purpose, ought, as far as it can be done without expense, to be accommodated to this. Satisfaction thus administered to a party injured, in the shape of a dissocial pleasure, may be styled a vindictive satisfaction, or compensation; as a compensation administered in the shape of self-regarding profit, or stock of pleasure, may be styled a lucrative one. Example is the most important end of all, in proportion as the number of the persons under temptation to be offended is to one. 3. It is plain, therefore, that in the following cases punishment ought not to be inflicted: 1. Where it is groundless, where there is no mischief for it to prevent, the act not being mischievous upon the whole. 2. Where it is ineffectuous, where it cannot act so as to prevent the mischief. 3. Where it is unprofitable or too expensive, where the mischief it would produce would be greater than that what it prevented. 4. Where it is needless, where the mischief may be prevented, or cease of itself, without it, that is, at a cheaper rate. Section 2. Causes in which punishment is groundless. These are: 4. 1. Where there has never been any mischief, where no mischief has been produced to anybody by the act in question. Of this number are those in which the act was such as might, on some occasions, be mischievous or disagreeable, but the person whose interest it concerns gave his consent to the performance of it. This consent, provided it be free and fairly obtained, is the best proof that can be produced that, to the person who gives it, no mischief, at least no immediate mischief, upon the whole, is done. For no man can be so good a judge as the man himself. What it is gives him pleasure or displeasure. 5. 2. Where the mischief was outweighed, although a mischief was produced by the act, yet the same act was necessary to the production of a benefit which was of greater value than the mischief. This may be the case with anything that is done in the way of precaution against instant calumny, as also with anything that is done in the exercise of the several sorts of powers necessary to be established in every community, to wit, domestic, judicial, military, and supreme. 6. 3. Where there is a certainty of an adequate compensation, and that in all cases where the offence can be committed. This supposes two things: 1. That the offence is such as admits of an adequate compensation. 2. That such a compensation is sure to be forthcoming. Of these suppositions, the latter will be found to be a merely ideal one, a supposition that cannot, in the universality here given to it, be verified by fact. It cannot, therefore, in practice, be numbered amongst the grounds of absolute impunity. It may, however, be admitted as a ground for an abatement of that punishment which other considerations, standing by themselves, would seem to dictate. This, for example, seems to have been one ground, at least, of the favour shown by perhaps all systems of laws to such offenders as stand upon a footing of responsibility; shown, not directly, indeed, to the persons themselves, but to such offences as none but responsible persons are likely to have the opportunity of engaging in. In particular, this seems to be the reason why embezzlement, in certain cases, has not commonly been punished upon the footing of theft, nor mercantile frauds upon that of common sharping. Section 3. Causes in which punishment must be ineffectuous. These are: 7. 1. Where the penal provision is not established until after the act is done. Such are the cases: 1. Of an ex post facto law, where the legislator himself appoints not a punishment till after the act is done. 2. Of a sentence beyond the law, where the judge, on his own authority, appoints a punishment which the legislator had not appointed. 8. 2. Where the penal provision, though established, is not conveyed to the notice of the person on whom it seems intended that it should operate. Such is the case where the law has omitted to employ any of the expedients which are necessary to make sure that every person whatsoever who is within the reach of the law be apprised of all the cases whatsoever in which, being in the station of life he is in, he can be subjected to the penalties of the law. 9. 3. Where the penal provision, though it were conveyed to a man's notice, could produce no effect on him with respect to the preventing him from engaging in any act of the sort in question. Such is the case: 1. In extreme infancy, where a man has not yet attained that state or disposition of mind in which the prospect of evils so distant as those which are held forth by law has the effect of influencing his conduct. 2. In insanity, where the person, if he has attained to that disposition, has since been deprived of it through the influence of some permanent though unseen cause. 3. Intoxication, where he has been deprived of it by the transient influence of a visible cause, such as the use of wine or opium or other drugs that act in this manner on the nervous system, which condition is indeed neither more nor less than a temporary insanity produced by an assignable cause. Notwithstanding what is here said, the cases of infancy and intoxication, as we shall see hereafter, cannot be looked upon in practice as affording sufficient grounds for absolute impunity. But this exception in point of practice is no objection to the propriety of the rule in point of theory. The ground of the exception is neither more nor less than the difficulty there is of ascertaining the matter of fact, viz., whether at the requisite point of time the party was actually in the state in question; that is, whether a given case comes really under the rule. Suppose the matter of fact capable of being perfectly ascertained, without danger or mistake, the impropriety of punishment would be as indubitable in those cases as in any other. The reason that is commonly assigned for the establishing an exception from punishment in favour of infants, insane persons, and persons under intoxication is either false in fact, or confusedly expressed. The phrase is that the will of these persons concurs not with the act, that they have no vicious will, or that they have not the free use of their will. But suppose all this to be true, what is it to the purpose? Nothing, except in as far as it implies the reason given in the text. 10. For, where the penal provision, although being conveyed to the party's notice, it might very well prevent his engaging in acts of the sort in question, provided he knew that it related to those acts, could not have this effect with regard to the individual act he is about to engage in, to wit, because he knows not that it is of the number of those to which the penal provision relates. This may happen, 1. In the case of unintentionality, where he intends not to engage, and thereby knows not that he is about to engage in the act in which eventually he is about to engage. 2. In the case of unconsciousness, where, although he may know that he is about to engage in the act itself, yet, from not knowing all the material circumstances attending it, he knows not of the tendency it has to produce that mischief, in contemplation of which it has been made penal in most instances. 3. In the case of missupposal, where, although he may know of the tendency the act has to produce that degree of mischief, he supposes it, though mistakenly, to be attended with some circumstance or set of circumstances, which, if it had been attended with, it would either not have been productive of that mischief, or have been productive of such a greater degree of good as has determined the legislator in such cases not to make it penal. 5. Where, though the penal clause might exercise a full and prevailing influence where it is to act alone, yet by the predominant influence of some opposite cause upon the will, it must necessarily be ineffectual, because the evil which he sets himself about to undergo in the case of his not engaging in the act is so great that the evil denounced by the penal clause in case of his engaging in it cannot appear greater. This may happen, 1. In the case of physical danger, where the evil is such as appears likely to be brought about by the unassisted powers of nature; 2. In the case of a threatened mischief, where it is such as appears likely to be brought about through the intentional and conscious agency of man. The influences of the moral and religious sanctions, or in other words, of the motives of love of reputation and religion, are other causes, the force of which may, upon particular occasions, come to be greater than that of any punishment which the legislature is able, or at least which we will think proper, to apply. These, therefore, it will be proper for him to have his eye upon. But the force of these influences is variable and different in different times and places. The force of the foregoing influences is constant and the same at all times and everywhere. These, therefore, it can never be proper to look upon as safe grounds for establishing absolute impunity, owing, as in the above mentioned cases of infancy and intoxication, to the impracticality of ascertaining the matter of fact. 12. 6. where, though the penal clause may exert a full and prevailing influence over the will of the party, yet his physical faculties, owing to the predominant influence of some physical cause, are not in a condition to follow the determination of the will, insomuch that the act is absolutely involuntary. Such is the case of physical compulsion or restraint, by whatever means brought about, where the man's hand, for instance, is pushed against some object which his will disposes him not to touch, or tied down from touching some object which his will disposes him to touch. Section 4. Cases where punishment is unprofitable. These are 13. 1. Where on the one hand the nature of the offence, on the other hand that of the punishment, are, in the ordinary state of things, such that when compared together, the evil of the latter will turn out to be greater than that of the former. 14. Now evil of the punishment divides itself into 4 branches, by which so many different sets of persons are affected. 1. The evil of coercion or restraint, or the pain which it gives a man not to be able to do the act, whatever it be, which by the apprehension of the punishment he is deterred from doing. This is felt by those by whom the law is observed. 2. The evil of apprehension, or the pain which a man who has exposed himself to punishment feels at the thoughts of undergoing it. This is felt by those by whom the law has been broken, and who feel themselves in danger of its being executed upon them. 3. The evil of sufferance, or the pain which a man feels, in virtue of the punishment itself, from the time when he begins to undergo it. This is felt by those by whom the law is broken, and upon whom it comes actually to be executed. 4. The pain of sympathy, and the other derivative evils resulting to the persons who are in connection with the several classes of original sufferers just mentioned. Now of these 4 lots of evil, the first will be greater or less according to the nature of the act from which the party is restrained; the second and third according to the nature of the punishment which stands annexed to the offence. 15. On the other hand, as to the evil of the offence, this will also of course be greater or less according to the nature of each offence. The proposition between the one evil and the other will therefore be different in the case of each particular offence. These cases, therefore, where punishment is unprofitable on this ground, can by no other means be discovered than by an examination of each particular offence, which is what will be the business of the body of the work. 16. 2. Where, although in the ordinary state of things the evil resulting from the punishment is not greater than the benefit which is likely to result from the force with which it operates, during the same space of time, towards the excluding the evil of the offences, yet it may have been rendered so by the influence of some occasional circumstances. In the number of these circumstances may be 1. The multitude of delinquents at a particular juncture, being such as would increase beyond the ordinary measure the quantum of the second and third lots, and thereby also of a part of the fourth lot, in the evil of the punishment. 2. The extraordinary value of the services of someone delinquent, in the case where the effect of the punishment would be to deprive the community of the benefit of those services. 3. The displeasure of the people, that is, of an indefinite number of the members of the same community, in cases where, owing to the influence of some occasional incident, they happen to conceive that the offence or the offender ought not to be punished at all, or at least ought not to be punished in the way in question. 4. The displeasure of foreign powers, that is, of the governing body, or a considerable number of the members of some foreign community or communities with which the community in question is connected. Section 5. Cases where punishment is needless. These are 17. 1. Where the purpose of putting an end to the practice may be attained as effectually at a cheaper rate by instruction, is, for instance, as well as by terror, by informing the understanding, as well as by exercising an immediate influence on the will. This seems to be the case with respect to all those offences which consist in the disseminating pernicious principle in matters of duty, of whatever kind the duty may be, whether political or moral or religious; and this, whether such principles be disseminated under, or even without, a sincere persuasion of their being beneficial. I say even without, for though in such a case it is not instruction that can prevent the writer from endeavouring to inculcate his principles, yet it may the readers from adopting them, without which his endeavouring to inculcate them will do no harm. In such a case, the sovereign will commonly have little need to take an active part. If it be the interest of one individual to inculcate principles that are pernicious, it will as surely be the interest of other individuals to expose them. But if the sovereign must needs take a part in the controversy, the pen is the proper weapon to combat error with, not the sword. End of chapter 13. Recording by Gary Gilbert.
Chapter 14 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Sean Michael Hogan. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 14. Of the Proportion between Punishments and Offences. Roman 1. We have seen that the general object of all laws is to prevent mischief, that is to say, when it is worth while, but that, where there are no other means of doing this than punishment, there are 4 cases in which it is not worth while. Roman 2. When it is worth while, there are 4 subordinate designs or objects, which, in the course of his endeavours to compass, as far as may be, that one general object, a legislator, whose views are governed by the principle of utility, comes naturally to propose to himself. Roman 3. 1. His first, most extensive, and most eligible object is to prevent, in as far as it is possible, and worth while, all sorts of offences whatsoever. In other words, so to manage that no offence whatsoever may be committed. Footnote 1. By offences, I mean, at present, acts which appear to him to have a tendency to produce mischief. End footnote 1. Roman 4. 2. But if a man must needs commit an offence of some kind or other, the next object is to induce him to commit an offence less mischievous, rather than one more mischievous. In other words, to choose always the least mischievous of 2 offences that will either of them suit his purpose. Roman 5. 3. When a man has resolved upon a particular offence, the next object is to dispose him to do no more mischief than is necessary to his purpose. In other words, to do as little mischief as is consistent with the benefit he has in view. Romans 6. 4. The last object is, whatever the mischief be which it is proposed to prevent it at as cheap a rate as possible. Romans 7. Subservient to these 4 objects or purposes must be the rules or canons by which the proportion of punishments to offences is to be governed. Footnote 2. The same rules, it is to be observed, may be applied with little variation to rewards as well as punishment; in short, to motives in general, which, according as they are of the pleasurable or painful kind, are of the nature of reward or punishment; and, according as the act they are applied to produce is of the positive or negative kind, are styled impelling or restraining. See Chapter 10, Motives, 43. End footnote 2. Roman 8. Rule 1. The first object, it has been seen, is to prevent, in as far as it is worth while, all sorts of offences. Therefore, the value of the punishment must be not less in any case than what is sufficient to outweigh that of the profit of the offence. Footnote 3. By the profit of an offence it is to be understood not merely the pecuniary profit, but the pleasure or advantage, of whatever kind it be, which as a man reaps or expects to reap from the gratification of the desire which prompted him to engage in the offence. Footnote 23. See Chapter 9, Motives, Section 1. End footnote 23. It is the profit, that is, the expectation of the profit, of the offence that constitutes the impelling motive, or, where there are several, the sum of the impelling motives, by which a man is prompted to engage in the offence. It is the punishment, that is, the expectation of the punishment, that constitutes the restraining motive, which, either by itself or in conjunction with others, is to act upon him in a contrary direction, so as to induce him to abstain from engaging in the offence. Accidental circumstances apart, the strength of the temptation is as the force of the seducing, that is, of the impelling motive or motives. To say, then, as authors of great merit and great name have said, that the punishment ought not to increase with the strength of the temptation, is as much as to say in mechanics that the moving force or momentum of the power need not increase in proportion to the momentum of the burden. End footnote 3. Footnote 4. Beccaria Dei Deleti, section 6, id trad par morale, section 23. End footnote 4. If it be, the offence, unless some other considerations independent of the punishment should intervene and operate efficaciously in the character of tutelary motives, will be sure to be committed notwithstanding, the whole lot of punishment will be thrown away, it will be altogether inefficacious. Footnote 5. See Chapter 11, Dispositions, 29. End footnote 5. Footnote 6. It is a well-known adage, though it is to be hoped not a true one, that every man has his price. It is commonly meant of a man's virtue. This saying, though in a very different sense, was strictly verified by some of the Anglo-Saxon laws, by which a fixed price was set, not upon a man's virtue indeed, but upon his life, that of the sovereign himself among the rest. For 200 shillings you might have killed a peasant, for 6 times as much a nobleman, for 36 times as much you might have killed the king. Footnote 24. Wilkins' Legislation of the Anglo-Saxons, pages 71, 72. See Hume, Volume 1, Appendix 1, page 219. End footnote 24. A king in those days was worth exactly 7,200 shillings. If then the heir to the throne, for example, grew weary of waiting for it, he had a secure and legal way of gratifying his impatience. He had but to kill the king with one hand, and pay himself with the other, and all was right. An Earl Godwin or a Duke Strahan could have bought the lives of a whole dynasty. It is plain that if ever a king in those days died in his bed, he must have had something else besides this law to thank for it. This being the production of a remote and barbarous age, the absurdity of it is presently recognized, but upon examination it would be found that the freshest laws of the most civilized nations are continually falling into the same error. Footnote 25. See in particular the English statute laws throughout, Bonaparte's Penal Code, and the recently enacted or not enacted Spanish Penal Code. Note by the author, July 1822. End footnote 25. This, in short, is the case wheresoever the punishment is fixed, while the profit of delinquency is indefinite, or, to speak more precisely, where the punishment is limited to such a mark that the profit of delinquency may reach beyond it. End footnote 6. Footnote 7. See Chapter 13, Cases unmeet, Section 1. End footnote 7. Roman 9. The above rule has been often objected to, on account of its seeming harshness, but this can only have happened for want of its being properly understood. The strength of the temptation, ceteris paribus, is as the profit of the offence. The quantum of the punishment must rise with the profit of the offence. Ceteris paribus, it must therefore rise with the strength of the temptation. This there is no disputing. True it is that the stronger the temptation, the less conclusive is the indication which the act of delinquency affords of the depravity of the offender's disposition. Footnote 8. See Chapter 11, Dispositions, 42. End footnote 8. So far then as the absence of any aggravation arising from extraordinary depravity of disposition may operate, or at the utmost, so far as the presence of a ground of extenuation, resulting from the innocence or beneficence of the offender's disposition, can operate, the strength of the temptation may operate in abatement of the demand for punishment. But it can never operate so far as to indicate the propriety of making the punishment ineffectual, which it is sure to be when brought below the level of the apparent profit of the offence. The partial benevolence which would prevail for the reduction of it below this level would counteract as well those purposes which such a motive would actually have in view, as those more extensive purposes which benevolence ought to have in view. It would be cruelty not only to the public, but to the very persons in whose behalf it pleads, in its effects, I mean, however opposite in its intention. cruelty to the public, that is, cruelty to the innocent, by suffering them for want of an adequate protection to lie exposed to the mischief of the offence, cruelty even to the offender himself, by punishing him to no purpose, and without the chance of compassing that beneficial end, by which alone the introduction of the evil of punishment is to be justified. X. Rule 2. But whether a given offence shall be prevented in a given degree by a given quantity of punishment is never anything better than a chance, for the purchasing of which, whatever punishment is employed is so much expended into advance. However, for the sake of giving it the better chance of outweighing the profit of the offence, the greater the mischief of the offence, the greater is the expense which it may be worth while to be at in the way of punishment. Footnote 9. For example, if it can ever be worth while to be at the expense of so horrible a punishment as that of burning alive, it will be more so in the view of preventing such a crime as that of murder or incendiarism than in the view of preventing the uttering of a piece of bad money. See B. 1, titled Defraudment touching the coin and incendiarism. End footnote 9. XI. Rule 3. The next object is to induce a man to choose always the least mischievous of two offences. Wherefore, where two offences come in competition, the punishment for the greater offence must be sufficient to induce a man to prefer the less. Footnote 10. Esprit des lois 50, 6, c. 16. End footnote 10. XII. Rule 4. When a man has resolved upon a particular offence, the next object is to induce him to do no more mischief than what is necessary for his purpose. Therefore, the punishment should be adjusted in such manner to each particular offence, that for every part of the mischief there may be a motive to restrain the offender from giving birth to it. Footnote 11. If any one have any doubt of this, let him conceive the offence to be divided into as many separate offences as there are distinguishable parcels of mischief that result from it. Let it consist, for example, in a man's giving you 10 blows, or stealing from you 10 shillings. If, then, for giving you 10 blows he is punished no more than for giving you 5, the giving you 5 of these 10 blows is an offence for which there is no punishment at all, which being understood, as often as a man gives you 5 blows, he will be sure to give you 5 more, since he may have the pleasure of giving you these 5 for nothing. In like manner, if for stealing from you 10 shillings he is punished no more than for stealing 5, the stealing of the remaining 5 of those 10 shillings is an offence for which there is no punishment at all. This rule is violated in almost every page of every body of laws I have ever seen. The profit, it is to be observed, though frequently, is not constantly proportionate to the mischief. For example, where a thief, along with the things he covets, steals others which are of no use to him. This may happen through wantonness, indolence, precipitation, etc., etc. End footnote 11. XIII. Rule 5. The last object is, whatever mischief is guarded against, to guard against it at as cheap a rate as possible. Therefore, the punishment ought in no case to be more than what is necessary to bring it into conformity with the rules here given. XIV. Rule 6. It is further to be observed that owing to the different manners and degrees in which persons under different circumstances are affected by the same exciting cause, a punishment which is the same in name will not always either really produce, or even so much as appear to others to produce, in two different persons the same degree of pain. Therefore, that the quantity actually indicted on each individual offender may correspond to the quantity intended for similar offenders in general, the several circumstances influencing sensibility ought always to be taken into account. Footnote 12. See Chapter 6, Sensibility, end footnote 12. XV. Of the above rules of proportion, the first 4, we may perceive, serve to mark out limits on the side of diminution, the limits below which a punishment ought not to be diminished. The 5th, the limits on the side of increase, the limits above which it ought not to be increased. The 5 first are calculated to serve as guides to the legislator. The 6th is calculated in some measure indeed to the same purpose, but principally for guiding the judge in his endeavours to conform, on both sides, to the intentions of the legislator. XVI. Let us look back a little. The first rule, in order to render it more conveniently applicable to practice, may need perhaps to be a little more particularly unfolded. It is to be observed, then, that for the sake of accuracy it was necessary, instead of the word quantity, to make use of the less perspicuous term value. For the word quantity will not properly include in the circumstances either of certainty or proximity, circumstances which, in estimating the value of a lot of pain or pleasure, must always be taken into the account. Footnote 13. See Chapter 4, Value. End footnote 13. Now, on the one hand, a lot of punishment is a lot of pain. On the other hand, the profit of an offence is a lot of pleasure, or what is equivalent to it. But the profit of the offence is commonly more certain than the punishment, or, what comes to the same thing, appears so at least to the offender. It is at any rate commonly more immediate. It follows, therefore, that in order to maintain its superiority over the profit of the offence, the punishment must have its value made up in some other way, in proportion to that whereby it falls short in the 2 points of certainty and proximity. Now there is no other way in which it can receive any addition to its value, but by receiving an addition in point of magnitude. Wherever then the value of the punishment falls short, either in point of certainty or of proximity, of that of the profit of the offence, it must receive a proportional addition in point of magnitude. Footnote 14. It is for this reason, for example, that simple compensation is never looked upon as sufficient punishment for theft or robbery. End footnote 14. Romans 17. Yet farther. To make sure of giving the value of the punishment the superiority over that of the offence, it may be necessary, in some cases, to take into account the profit not only of the individual offence to which the punishment is to be annexed, but also of such other offences of the same sort as the offender is likely to have already committed without detection. This random mode of calculation, severe as it is, it will be impossible to avoid having recourse to, in certain cases. In such, to wit, in which the profit is pecuniary, the chance of detection very small, and the obnoxious act of such a nature as indicates a habit. For example, in the case of frauds against the coin. If it be not recurred to, the practice of committing the offence will be sure to be, upon the balance of the account, a gainful practice. That being the case, the legislator will be absolutely sure of not being able to suppress it, and the whole punishment that is bestowed upon it will be thrown away. In a word, to keep to the same expressions we set out with, that whole quantity of punishment will be inefficacious. Roman 18. Rule 7. These things being considered, the 3 following rules may be laid down by way of supplement and explanation to Rule 1. To enable the value of the punishment to outweigh that of the profit of the offence, it must be increased in point of magnitude in proportion as it falls short in point of certainty. Roman 19. Rule 8. Punishment must be further increased in point of magnitude in proportion as it falls short in point of proximity. Roman 20. Rule 9. Where the act is conclusively indicative of a habit, such an increase must be given to the punishment as may enable it to outweigh the profit, not only of the individual offence, but of such other like offences as are likely to have been committed with impunity by the same offender. Roman 21. There may be a few other circumstances or considerations which may influence in some small degree the demand for punishment, but as the propriety of these is either not so demonstrable, or not so constant, or the application of them not so determinate as that of the foregoing, it may be doubted whether they are worth putting on a level with the others. Roman 22. Rule 10. When a punishment, which in point of quality is particularly well calculated to answer its intention cannot exist in less than a certain quantity, it may sometimes be of use, for the sake of employing it, to stretch a little beyond that quantity which on other accounts would be strictly necessary. Roman 23. Rule 11. In particular, this may sometimes be the case where the punishment proposed is of such a nature as to be particularly well calculated to answer the purpose of a moral lesson. Footnote 15. A punishment may be said to be calculated to answer the purpose of a moral lesson when, by reason of the ignominy it stamps upon the offence, it is calculated to inspire the public with sentiments of aversion towards those pernicious habits and dispositions with which the offence appears to be connected, and thereby to inculcate the opposite beneficial habits and dispositions. It is this, for example, if anything, that must justify the application of so severe a punishment as the infamy of a public exhibition, hereinafter proposed, for him who lifts up his hand against a woman, or against his father. See B. 1, titled Simp Corporal Injuries. It is partly on this principle, I suppose, that military legislators have justified to themselves the inflicting of death upon the soldier who lifts up his hand against his superior officer. End footnote 15. Roman 24, Rule 12. The tendency of the above considerations is to dictate an augmentation in the punishment. The following rule operates in the way of diminution. There are certain cases, it has been seen, in which by the influence of accidental circumstances punishment may be rendered unprofitable in the whole. In the same cases it may chance to be rendered unprofitable as to a part only. Footnote 16. See Chapter 13, Cases Unmeet, Section 4. End footnote 16. Accordingly, in adjusting the quantum of punishment, the circumstances by which all punishments may be rendered unprofitable ought to be attended to. Roman 25, Rule 13. It is to be observed that the more various and minute any set of provisions are, the greater the chance is that any given article in them will not be borne in mind, without which no benefit can ensue from it. Distinctions which are more complex than what the conceptions of those whose conduct it is designed to influence can take in, will even be worse than useless. The whole system will present a confused appearance, and thus the effect, not only of the proportions established by the articles in question, but of whatever is connected with them, will be destroyed. Footnote 17. See B. 2, titled Purposes, Appendix titled Composition. End footnote 17. To draw a precise line of direction in such case seems impossible. However, by way of memento it may be of some use to subjoin the following rule. Among provisions designed to perfect the proportion between punishments and offences, if any occur, which by their own particular good effects would not make up for the harm they would do by adding to the intricacy of the code, they should be omitted. Footnote 18. Notwithstanding this rule, my fear is that in the ensuing model I may be thought to have carried my endeavours at proportionality too far. Hitherto scarce any attention has been paid to it. Montesquieu seems to have been almost the first who has had the least idea of any such thing. In such a matter, therefore, excess seemed more eligible than defect. The difficulty is to invent. That done, if anything seems superfluous, it is easy to retrench. End footnote 18. Roman 26. It may be remembered that the political sanction, being that to which the sort of punishment belongs, which in this chapter is all along in view, is but one of 4 sanctions, which may all of them contribute their share towards producing the same effects. It may be expected, therefore, that in adjusting the quantity of political punishment, allowance should be made for the assistance it may meet with from those other controlling powers. True it is that from each of these several sources a very powerful assistance may sometimes be derived. But the case is that, setting aside the moral sanction, in the case where the force of it is expressly adopted into and modified by the political, the force of those other powers is never determinate enough to be depended upon. Footnote 19. See B. 1, titled Punishments. End footnote 19. It can never be reduced, like political punishment, into exact lots, nor meted out in number, quantity, and value. The legislator is therefore obliged to provide the full complement of punishment, as if he were sure of not receiving any assistance whatever from any of those quarters. If he does, so much the better. But lest he should not, it is necessary he should, at all events, make that provision which depends upon himself. Roman 27. It may be of use, in this place, to recapitulate the several circumstances which, in establishing the proportion betwixt punishments and offences, are to be attended to. These seem to be as follows. 1. On the part of the offence. 1. The profit of the offence. 2. The mischief of the offence. 3. The profit and mischief of other greater or lesser offences of different sorts, which the offender may have to choose out of. 4. The profit and mischief of other offences of the same sort, which the same offender may probably have been guilty of already. 2. On the part of the punishment. 5. The magnitude of the punishment, composed of its intensity and duration. 6. The deficiency of the punishment in point of certainty. 7. The deficiency of the punishment in point of proximity. 8. The quality of the punishment. 9. The accidental advantage in point of quality of the punishment, not strictly needed in point of quantity. 10. The use of a punishment of a particular quality in the character of a moral lesson. 3. On the part of the offender. 11. The responsibility of the class of persons in a way to offend. 12. The sensibility of each particular offender. 13. The particular merits or useful qualities of any particular offender, in case of a punishment which might deprive the community of the benefit of them. 14. The multitude of offenders on any particular occasion. 4. On the part of the public at any particular conjuncture. 15. The inclinations of the people for or against any quantity or mode of punishment. 16. The inclinations of foreign powers. 5. On the part of the law, that is, of the public, for a continuance. 17. The necessity of making small sacrifices in point of proportionality for the sake of simplicity. XXVIII. There are some, perhaps, who at first sight may look upon the nicety employed in the adjustment of such rules as so much labour lost. For gross ignorance, they will say, never troubles itself about laws, and passion does not calculate. But the evil of ignorance admits of cure, and as to the proposition that passion does not calculate, this, like most of these very general and oracular propositions, is not true. Footnote 20. See Appendix titled Promulgation. End footnote 20. When matters of such importance as pain and pleasure are at stake, and these in the highest degree, the only matters, in short, that can be of importance, who is there that does not calculate? Men calculate, some with less exactness indeed, some with more, but all men calculate. I would not say that even a madman does not calculate. Footnote 21. There are few madmen but what are observed to be afraid of the strait waistcoat. End footnote 21. Passion calculates more or less in every man, in different men according to the warmth or coolness of their dispositions, according to the firmness or irritability of their minds, according to the nature of the motives by which they are acted upon. Happily, of all passions, that is the most given to calculation, from the excesses of which, by reason of its strength, constancy, and universality, society has most to apprehend. I mean that which corresponds to the motive of pecuniary interest, so that these niceties, if such they are to be called, have the best chance of being efficacious, where efficacy is of the most importance. Footnote 22. See Chapter 12, Consequences, 33. End footnote 22. End of Chapter 14. Recording by Sean Michael Hogan, St. John's, Newfoundland, Canada.
Chapter 15 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Anna Simon. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 15. Of the properties to be given to a lot of punishment. It has been shown what the rules are, which ought to be observed in adjusting the proportion between the punishments and the offence. The properties to be given to a lot of punishment in every instance will of course be such as it stands in need of, in order to be capable of being applied in conformity to those rules. The quality will be regulated by the quantity. The first of those rules, we may remember, was, that the quantity of punishment must not be less in any case than what is sufficient to outweigh the profit of the offence, since, as often as it is less, the whole lot, unless by accident the deficiency should be supplied from some of the other sanctions, is thrown away, it is inefficacious. The fifth was, that the punishment ought in no case to be more than what is required by the several other rules, since if it be, all that is above that quantity is needless. The fourth was, that the punishment should be adjusted in such manner to each individual offence, that every part of the mischief of that offence may have a penalty, that is, a tutelary motive, to encounter it. Otherwise, with respect to so much of the offence as has not a penalty to correspond to it, it is as if there were no punishment in the case. Now to none of those rules can a lot of punishment be conformable unless, for every variation in point of quantity, in the mischief of the species of offence to which it is annexed, such lot of punishment admits of a correspondent variation. To prove this, let the profit of the offence admit of a multitude of degrees. Suppose it then at any one of these degrees. If the punishment be less than what is suitable to that degree, it will be inefficacious, it will be so much thrown away. If it be more, as far as the difference extends, it will be needless. It will therefore be thrown away also in that case. The first property, therefore, that ought to be given to a lot of punishment is that of being variable in point of quantity, in conformity to every variation which can take place in either the profit or mischief of the offence. This property might perhaps be termed in a single word variability. A second property, intimately connected with the former, may be styled equability. It will avail but little that a mode of punishment, proper in all other respects, has been established by the legislator, and that capable of being screwed up or let down to any degree that can be required, if, after all, whatever degree of it be pitched upon, that same degree shall be liable, according to circumstances, to produce a very heavy degree of pain, or a very slight one, or even none at all. In this case, as in the former, if circumstances happen one way, there will be a great deal of pain produced which will be needless; if the other way, there will be no pain at all applied, or none that will be efficacious. A punishment, when liable to this irregularity, may be styled an unequable one; when free from it, an equable one. The quantity of pain produced by the punishment will, it is true, depend in a considerable degree upon circumstances distinct from the nature of the punishment itself, upon the condition which the offender is in with respect to the circumstances by which a man's sensibility is liable to be influenced. But the influence of these very circumstances will in many cases be reciprocally influenced by the nature of the punishment. In other words, the pain which is produced by any mode of punishment will be the joint effect of the punishment which is applied to him and the circumstances in which he is exposed to it. Now there are some punishments of which the effect may be liable to undergo a greater alteration by the influence of such foreign circumstances than the effect of other punishments is liable to undergo. So far then as this is the case, equability or unequability may be regarded as properties belonging to the punishment itself. An example of a mode of punishment which is apt to be unequable is that of banishment, when the locus a quo, or place the party is banished from, is some determinate place appointed by the law, which perhaps the offender cares not whether he ever see or know. This is also the case with pecuniary or quasi-pecuniary punishment, when it respects some particular species of property, which the offender may have been possessed of or not, as it may happen. All these punishments may be split down into parcels and measured out with the utmost nicety, being divisible by time at least, if by nothing else. They are not, therefore, any of them defective in point of variability, and yet in many cases this defect in point of equability may make them as unfit for use as if they were. The third rule of proportion was, that where two offences come in competition, the punishment for the greater offences must be sufficient to induce a man to prefer the less. Now, to be sufficient for this purpose, it must be evidently and uniformly greater not in the eyes of some men only, but of all men who are liable to be in a situation to take their choice between the two offences, that is, in effect, of all mankind. In other words, the two punishments must be perfectly commensurable. Hence arises a third property, which may be termed commensurability, to wit, with reference to other punishments. But punishments of different kinds are in very few instances uniformly greater one than another, especially when the lowest degrees of that which is ordinarily the greater are compared with the highest degrees of that which is ordinarily the less. In other words, punishments of different kinds are in few instances uniformly commensurable. The only certain and universal means of making two lots of punishment perfectly commensurable is by making the lesser an ingredient in the composition of the greater. This may be done in either of two ways: 1. By adding to the lesser punishment another quantity of punishment of the same kind; 2. By adding to it another quantity of a different kind. The latter mode is not less certain than the former, for though one cannot always be absolutely sure that to the same person a given punishment will appear greater than another given punishment, yet one may be always absolutely sure that any given punishment, so as it does but come into contemplation, will appear greater than none at all. Again, punishment cannot act any farther than in as far as the idea of it and of its connection with the offence is present in the mind. The idea of it, if not present, cannot act at all, and then the punishment itself must be inefficacious. Now, to be present it must be remembered, and to be remembered it must have been learned. But of all punishments that can be imagined, there are none of which the connection with the offence is either so easily learned or so efficaciously remembered as those of which the idea is already in part associated with some part of the idea of the offence, which is the case when the one and the other have some circumstance that belongs to them in common. When this is the case with a punishment and an offence, the punishment is said to bear an analogy to, or to be characteristic of, the offence. Characteristicalness is, therefore, a fourth property, which on this account ought to be given, whenever it can conveniently be given, to a lot of punishment. It is obvious that the effect of this contrivance will be the greater as the analogy is the closer. The analogy will be the closer, the more material that circumstance is which is in common. Now the most material circumstance that can belong to an offence and a punishment in common is the hurt or damage which they produce. The closest analogy, therefore, that can subsist between an offence and the punishment annexed to it is that which subsists between them when the hurt or damage they produce is of the same nature, in other words, that which is constituted by the circumstance of identity in point of damage. Accordingly, the mode of punishment which of all others bears the closest analogy to the offence is that which in the proper and exact sense of the word is termed retaliation. Retaliation, therefore, in the few cases in which it is practicable and not too expensive, will have one great advantage over every other mode of punishment. Again, it is the idea only of the punishment, or in other words, the apparent punishment, that really acts upon the mind. The punishment itself, the real punishment, acts not any farther than as giving rise to that idea. It's the apparent punishment, therefore, that does all the service, I mean in the way of example, which is the principal object. It is the real punishment that does all the mischief. Now, the ordinary and obvious way of increasing the magnitude of the apparent punishment is by increasing the magnitude of the real. The apparent magnitude, however, may to a certain degree be increased by other less expensive means. Whenever, therefore, at the same time that these less expensive means would have answered their purpose, an additional real punishment is employed, this additional real punishment is needless. As to these less expensive means, they consist, 1. In the choice of a particular mode of punishment, a punishment of a particular quality, independent of the quantity. 2. In a particular set of solemnities distinct from the punishment itself, and accompanying the execution of it. A mode of punishment, according as the appearance of it bears a greater proportion to the reality, may be said to be the more exemplary. Now as to what concerns the choice of the punishment itself, there is not any means by which a given quantity of punishment can be rendered more exemplary than by choosing it of such a sort as shall bear an analogy to the offence. Hence another reason for rendering the punishment analogous to, or in other words characteristic of, the offence. Punishment, it is still to be remembered, is in itself an expense. It is in itself an evil. Accordingly, the fifth rule of proportion is, not to produce more of it than what is demanded by the other rules. But this is the case as often as any particle of pain is produced, which contributes nothing to the effect proposed. Now, if any mode of punishment is more apt than another to produce any such superfluous and needless pain, it may be styled unfrugal. If less, it may be styled frugal. Frugality, therefore, is a sixth property to be wished for in a mode of punishment. The perfection of frugality in a mode of punishment is where not only no superfluous pain is produced on the part of the person punished, but even that same operation by which he is subjected to pain is made to answer the purpose of producing pleasure on the part of some other person. Understand a profit or stock of pleasure of the self-regarding kind, for a pleasure of the dissocial kind is produced almost of course on the part of all persons in whose breasts the offence has excited the sentiment of ill will. Now this is the case with pecuniary punishment, as also with such punishments of the quasi-pecuniary kind as consist in the subtraction of such a species of possession as is transferable from one party to another. The pleasure, indeed, produced by such an operation is not in general equal to the pain. It may, however, be so in particular circumstances, as where he from whom the thing is taken is very rich, and he to whom it is given very poor, and, be it what it will, it is always so much more than can be produced by any other mode of punishment. The properties of exemplarity and frugality seem to pursue the same immediate end, though by different courses. Both are occupied in diminishing the ratio of the real suffering to the apparent, but exemplarity tends to increase the apparent, frugality to reduce the real. Thus much concerning the properties to be given to punishments in general, to whatsoever offences they are to be applied. Those which follow are of less importance, either as referring only to certain offences in particular, or depending upon the influence of transitory and local circumstances. In the first place, the four distinct ends into which the main and general end of punishment is divisible may give rise to so many distinct properties, according as any particular mode of punishment appear to be more particularly adapted to the compassing of one or of another of those ends. To that of example, as being the principal one, a particular property has already been adapted. There remains the three inferior ones of reformation, disablement, and compensation. A seventh property, therefore, to be wished for in a mode of punishment is that of subserviency to reformation, or reforming tendency. Now, any punishment is subservient to reformation in proportion to its quantity. Since the greater the punishment a man has experienced, the stronger is the tendency it has to create in him an aversion towards the offence which was the cause of it, and that with respect to all offences alike. But there are certain punishments which, with regard to certain offences, have a particular tendency to produce that effect by reason of their quality, and where this is the case, the punishments in question, as applied to the offences in question, will pro tanto have the advantage over all others. This influence will depend upon the nature of the motive which is the cause of the offence. The punishment most subservient to reformation will be the sort of punishment that is best calculated to invalidate the force of that motive. Thus, in offences originating from the motive of ill will, that punishment has the strongest reforming tendency which is best calculated to weaken the force of the irascible affections; and more particularly in that sort of offence which consists in an obstinate refusal on the part of the offender to do something which is lawfully required of him, and in which the obstinacy is in great measure kept up by his resentment against those who have an interest in forcing him to compliance. The most efficacious punishment seems to be that of confinement to spare diet. Thus also in offences which owe their birth to the joint influence of indolence and pecuniary interest, that punishment seems to possess the strongest reforming tendency which is best calculated to weaken the force of the former of those dispositions; and more particularly in the cases of theft, embezzlement, and every species of defraudment, the mode of punishment best adapted to this purpose seems in most cases to be that of penal labour. An eighth property to be given to a lot of punishment in certain cases is that of efficacy with respect to disablement, or, as it might be styled more briefly, disabling efficacy. This is a property which may be given in perfection to a lot of punishment, and that with much greater certainty than the property of subserviency to reformation. The inconvenience is that this property is apt, in general, to run counter to that of frugality, there being, in most cases, no certain way of disabling a man from doing mischief without, at the same time, disabling him, in a great measure, from doing good, either to himself or to others. The mischief, therefore, of the offence must be so great as to demand a very considerable lot of punishment, for the purpose of example, before it can warrant the application of a punishment equal to that which is necessary for the purpose of disablement. The punishment of which the efficacy in this way is the greatest is evidently that of death. In this case the efficacy of it is certain. This accordingly is the punishment peculiarly adapted to those cases in which the name of the offender, so long as he lives, may be sufficient to keep a whole nation in a flame. This will now and then be the case with competitors for the sovereignty, and leaders of the factions in civil wars, though when applied to offences of so questionable a nature, in which the question concerning criminality turns more upon success than anything else, an infliction of this sort may seem more to savour of hostility than punishment. At the same time, this punishment, it is evident, is in an eminent degree unfrugal, which forms one among the many objections there are against the use of it, in any but very extraordinary cases. In ordinary cases the purpose may be sufficiently answered by one or other of the various kinds of confinement and banishment, of which imprisonment is the most strict and efficacious. For when an offence is so circumstanced that it cannot be committed but in a certain place, as is the case for the most part with offences against the person, all the law has to do, in order to disable the offender from committing it, is to prevent his being in that place. In any of the offences which consist in the breach or the abuse of any kind of trust, the purpose may be compassed at a still cheaper rate, merely by forfeiture of the trust. And in general, in any of those offences which can only be committed under favour of some relation in which the offender stands with reference to any person or sets of persons, merely by forfeiture of that relation, that is, of the right of continuing to reap the advantages belonging to it. This is the case, for instance, with any of those offences which consist in an abuse of the privileges of marriage, or of the liberty of carrying on any lucrative or other occupation. The ninth property is that of subserviency to compensation. This property of punishment, if it be vindictive compensation that is in view, will, with little variation, be in proportion to the quantity. If lucrative, it is the peculiar and characteristic property of pecuniary punishment. In the rear of all these properties may be introduced that of popularity, a very fleeting and indeterminate kind of property, which may belong to a lot of punishment one moment and be lost by it the next. By popularity is meant the property of being acceptable, or rather not unacceptable, to the bulk of the people among whom it is proposed to be established. In strictness of speech it should rather be called absence of unpopularity, for it cannot be expected, in regard to such a matter as punishment, that any species or lot of it should be positively acceptable and grateful to the people. It is sufficient, for the most part, if they have no decided aversion to the thoughts of it. Now the property of characteristicalness, above noticed, seems to go as far towards conciliating the approbation of the people to a mode of punishment as any, insomuch that popularity may be regarded as a kind of secondary quality, depending upon that of characteristicalness. The use of inserting this property in the catalogue is chiefly to make it serve by way of memento to the legislator not to introduce, without a cogent necessity, any mode or lot of punishment towards which he happens to perceive any violent aversion entertained by the body of the people. The effects of unpopularity in a mode of punishment are analogous to those of unfrugality. The unnecessary pain which denominates a punishment unfrugal is most apt to be that which is produced on the part of the offender. A portion of superfluous pain is in like manner produced when the punishment is unpopular, but in this case it is produced on the part of persons altogether innocent, the people at large. This is already one mischief, and another is the weakness which it is apt to introduce into the law. When the people are satisfied with the law, they voluntarily lend their assistance in the execution. When they are dissatisfied, they will naturally withhold that assistance. It is well if they do not take a positive part in raising impediments. This contributes greatly to the uncertainty of the punishment, by which, in the first instance, the frequency of the offence receives an increase. In process of time that deficiency, as usual, is apt to draw on an increase in magnitude, an addition of a certain quantity which otherwise would be needless. This property, it is to be observed, necessarily supposes on the part of the people some prejudice or other which it is the business of the legislator to endeavour to correct. For if the aversion to the punishment in question were grounded on the principle of utility, the punishment would be such as, on other accounts, ought not to be employed, in which case its popularity or unpopularity would never be worth drawing into question. It is properly therefore a property not so much of the punishment as of the people, a disposition to entertain an unreasonable dislike against an object which merits their approbation. It is the sign also of another property, to wit indolence or weakness on the part of the legislator, in suffering the people for the want of some instruction which ought to be and might be given them, to quarrel with their own interest. Be this as it may, so long as any such dissatisfaction subsists, it behoves the legislator to have an eye to it, as much as if it were ever so well grounded. Every nation is liable to have its prejudices and its caprices, which it is the business of the legislator to look out for, to study, and to cure. The 11th and last of all the properties that seem to be requisite in a lot of punishment is that of remissibility. The general presumption is, that when punishment is applied, punishment is needful; that it ought to be applied, and therefore cannot want to be remitted. But in very particular, and those always very deplorable cases, it may by accident happen otherwise. It may happen that punishment shall have been inflicted, where, according to the intention of the law itself, it ought not to have been inflicted; that is, where the sufferer is innocent of the offence. At the time of the sentence passed he appeared guilty, but since then accident has brought his innocence to light. This being the case, so much of the destined punishment as he has suffered already there is no help for. The business is then to free him from as much as is yet to come. But is there any yet to come? There is very little chance of there being any, unless it be so much as consists of chronical punishment, such as imprisonment, banishment, penal labour, and the like; so much as consists of acute punishment, to wit, where the penal process itself is over presently, however permanent the punishment may be in its effects, may be considered as irremissible. This is the case, for example, with whipping, branding, mutilation, and capital punishment. The most perfectly irremissible of any is capital punishment. For though other punishments cannot, when they are over, be remitted, they may be compensated for; and although the unfortunate victim cannot be put into the same condition, yet possibly means may be found of putting him into as good a condition as he would have been in if he had never suffered. This may in general be done very effectually where the punishment has been no other than pecuniary. There is another case in which the property of remissibility may appear to be of use. This is where, although the offender has been justly punished, yet on account of some good behaviour of his, displayed at a time subsequent to that of the commencement of the punishment, it may seem expedient to remit a part of it. But this it can scarcely be if the proportion of the punishment is, in other respects, what it ought to be. The purpose of example is the more important object in comparison of that of reformation. It is not very likely that less punishment should be required for the former purpose than for the latter. For it must be rather an extraordinary case if a punishment, which is sufficient to deter a man who has only thought of it for a few moments, should not be sufficient to deter a man who has been feeling it all the time. Whatever, then, is required for the purpose of example must abide at all events. It is not any reformation on the part of the offender that can warrant the remitting of any part of it. If it could, a man would have nothing to do but to reform immediately, and so free himself from the greatest part of that punishment which was deemed necessary. In order, then, to warrant the remitting of any part of a punishment upon this ground, it must first be supposed that the punishment at first appointed was more than was necessary for the purpose of example, and consequently that a part of it was needless upon the whole. This, indeed, is apt enough to be the case, under the imperfect systems that are as yet on foot, and therefore during the continuance of those systems the property of remissibility may, on this second ground likewise as well as on the former, be deemed a useful one. But this would not be the case in any new constructed system, in which the rules of proportion above laid down should be observed. In such a system, therefore, the utility of this property would rest solely on the former ground. Upon taking a survey of the various possible modes of punishment, it will appear evidently that there is not any one of them that possesses all the above properties in perfection. To do the best that can be done in the way of punishment, it will therefore be necessary, upon most occasions, to compound them, and make them into complex lots, each consisting of a number of different modes of punishment put together, the nature and proportions of the constituent parts of each lot being different, according to the nature of the offence which it is designed to combat. It may not be amiss to bring together and exhibit in one view the 11 properties above established. They are as follows. 2 of them are concerned in establishing a proper proportion between a single offence and its punishment, that is, 1. Variability, 2. Equability. 1. In establishing a proportion between more offences than one and more punishments than one, that is, 3. commensurability. A fourth contributes to place the punishment in that situation in which alone it can be efficacious, and at the same time to be bestowing on it the two farther properties of exemplarity and popularity, viz., 4. Characteristicalness. Two others are concerned in excluding all useless punishment, the one indirectly, by heightening the efficacy of what is useful, the other in a direct way, viz., 5. Exemplarity, 6. Frugality. Three others contribute severally to the three inferior ends of punishment, viz., 7. Subserviency to reformation, 8. Efficacy in disabling, 9. Subserviency to compensation. Another property tends to exclude a collateral mischief which a particular mode of punishment is liable accidentally to produce, viz., 10. Popularity. The remaining property tends to palliate a mischief which all punishment, as such, is liable accidentally to produce, viz., 11. Remissibility. The properties of commensurability, characteristicalness, exemplarity, subserviency to reformation, and efficacy in disabling are more particularly calculated to augment the profit which is to be made by punishment. Frugality, subserviency to compensation, popularity, and remissibility to diminish the expense. Variability and equability are alike subservient to both those purposes. We now come to take a general survey of the system of offences, that is, of such acts to which, on account of the mischievous consequences they have a natural tendency to produce, and in the view of putting a stop to those consequences, it may be proper to annex a certain artificial consequence, consisting of punishment, to be inflicted on the authors of such acts, according to the principles just established. End of chapter 15.
Jeremy Bentham, The Principles of Morals and Legislation, Chapter 16. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Please note that in the following recording, footnotes have been omitted for the sake of intelligibility. Division of Offenses. Section 1. Classes of Offenses. 1. It is necessary, at the outset, to make a distinction between such acts as are or may be, and such as ought to be offenses. An act may be an offense, which they whom the community are in the habit of obeying shall be pleased to make one. That too is, any act which they shall be pleased to prohibit or to punish. But upon the principle of utility, such acts alone ought to be made offenses, as the good of the community requires should be made so. 2. The good of the community cannot require that any act should be made an offense, which is not liable, in some way or other, to be detrimental to the community. For in the case of such an act, all punishment is groundless. 3. But if the whole assemblage of any number of individuals be considered as constituting an imaginary compound body, a community or political state, any act that is detrimental to any one or more of those members is, as to so much of its effects, detrimental to the state. 4. An act cannot be detrimental to a state, but by being detrimental to some one or more of the individuals that compose it. But these individuals may be either assignable or unassignable. 5. When there is any assignable individual to whom an offense is detrimental, that person may either be a person other than the offender or the offender himself. 6. Offenses that are detrimental, in the first instance, to assignable persons other than the offender, may be termed by one common name offenses against individuals. And of these may be composed the first class of offenses. To contrast them with offenses of the second and fourth classes, it may also sometimes be convenient to style them private offenses, to contrast them at the same time with offenses of the third class, they may be styled private extra-regarding offences. When it appears, in general, that there are persons to whom the act in question may be detrimental, but such persons cannot be individually assigned, the circle within which it appears that they may be found is either of less extent than that which comprises the whole community, or not. If of less, the persons comprised within this lesser circle may be considered for this purpose as composing a body of themselves, comprised within, but distinguishable from, the greater body of the whole community. The circumstance that constitutes the union between the members of this lesser body may be either their residence within a particular place, or, in short, any other less explicit principle of union, which may serve to distinguish them from the remaining members of the community. In the first case, the act may be styled an offense against a neighborhood; in the second, an offense against a particular class of persons in the community. Offenses, then, against a class or neighborhood may together constitute the second class of offenses. To contrast them with private offenses on the one hand and public on the other, they may also be styled semi-public offenses. 8. Offenses, which in the first instance are detrimental to the offender himself and to no one else, unless it be by their being detrimental to himself, may serve to compose a third class. To contrast them the better with offenses of the first, second, and fourth classes, all which are of transitive nature, they might be styled intransitive offenses, but better still, self-regarding. 9. The fourth class may be composed of such acts as ought to be made offenses on account of the distant mischief which they threaten to bring upon unassignable indefinite multitude of the whole number of individuals of which the community is composed, although no particular individual should appear more likely to be a sufferer by them than another. These may be called public offenses, or offenses against the state. 10. A fifth class, or appendix, may be composed of such acts as, according to the circumstances in which they are committed, or, and more particularly, according to the purposes to which they are applied, may be detrimental to any one of the ways in which the act of one man can be detrimental to another. These may be termed multiform or heterogeneous offenses. Offenses that are in this case may be reduced to two great heads. First, offenses by falsehood, and second, offenses against trust. End of chapter 16, section 1. Chapter 16. Section 2, Part A. The Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Principles of Morals and Legislation. Jeremy Bentham, Chapter 16. Divisions and Subdivisions. Section 2, Part A. 11. Let us see by what method these classes may be farther subdivided. First, then, with regard to offenses against individuals. In the present period of existence, a man's being and well-being, his happiness and his security, in a word, his pleasures and his immunity from pains, are all dependent, more or less, in the first place, upon his own person, and in the next place, upon the exterior objects that surround him. These objects are either things or other persons. Under one or other of these classes must evidently be comprised every sort of exterior object, by means of which his interest can be affected. If, then, by means of any offense, a man should on any occasion become a sufferer, it must be in one or other of two ways. One, absolutely, to wit, immediately in his own person, in which case the offense may be said to be an offense against his person, or two, relatively, by reason of some material relation which the before-mentioned exterior objects may happen to bear in the way of causality to his happiness. Now, in as far as a man is in a way to derive either happiness or security from any object which belongs to the class of things, such thing is said to be his property, or at least he is said to have a property or an interest therein. An offense, therefore, which tends to lessen the facility he might otherwise have of deriving happiness or security from an object which belongs to the class of things may be styled an offense against his property. With regard to persons, in as far as from objects of this class, a man is in a way to derive happiness or security, it is in virtue of their services, in virtue of some services which, by one sort of inducement or another, they may be disposed to render him. Now then, take any man, by way of example, and the disposition, whatever it may be, which he may be in to render you service, either has no other connection to give birth or support to it than the general one that binds him to the whole species, or it has some connection more particular. In the latter case, such a connection may be spoken of as constituting, in your favor, a kind of fictitious or incorporeal object of property, which is styled your condition. An offense, therefore, the tendency of which is to lessen the facility you might otherwise have of deriving happiness from the services of a person thus specially connected with you, may be styled an offense against your condition in life, or simply against your condition. Conditions in life must evidently be as various as the relations by which they are constituted. This will be seen more particularly farther on. In the meantime, those of husband, wife, parent, child, master, servant, citizen of such or such a city, natural-born subject of such or such a country, may answer the purposes of example. Where there is no such particular connection, or, what comes to the same thing, where the disposition, whatever it may be, which a man is to render you service is not considered as depending upon such connection, but simply upon the goodwill he bears to you, in such case, in order to express what chance you have of deriving a benefit from his services, a kind of fictitious object of property is spoken of, as being constituted in your favor, and is called your reputation. An offense, therefore, the tendency of which is to lessen the facility you might otherwise have had of deriving happiness or security from the services of persons at large, whether connected with you or not by a special tie, may be styled an offense against your reputation. It appears, therefore, that if by any offense an individual becomes a sufferer, it must be in one or other of the 4 points above mentioned, viz., his person, his property, his condition in life, or his reputation. These sources of distinction, then, may serve to form as so many subordinate divisions. If any offenses should be found to affect a person in more than one of these points at the same time, such offenses may respectively be put under so many separate divisions, and such compound divisions may be subjoined to the preceding simple ones. The several divisions, simple and compound together, which are hereinafter established, stand as follows: 1. Offenses against person. 2. Offenses against reputation. 3. Offenses against property. 4. Offenses against condition. 5. Offenses against person and property together. 6. Offenses against person and reputation together. 12. Next, with regard to semi-public offenses. Pain, considered with reference to the time of the act from which it is liable to issue, must, it is evident, be either present, past, or future. In as far as it is either present or past, it cannot be the result of any act which comes under the description of a semi-public offense. For if it be present or past, the individuals who experience or have experienced it are assignable. There remains that sort of mischief which, if it ever came to exist at all, is as yet but future, Mischief, thus circumstance, takes the name of danger. Now then, when by means of the act of any person a whole neighborhood or other class of persons are exposed to danger, this danger must either be intentional on his part or unintentional. If unintentional, such danger, when it is converted into actual mischief, makes the name of a calamity. Offenses productive of such danger may be styled semi-public offenses operating through calamity, or more briefly, offenses through calamity. If the danger be intentional, insomuch as it might be produced and might convert itself into actual mischief without the concurrence of any calamity, it may be said to originate in mere delinquency. Offenses, then, which, without the concurrence of any calamity, tend to produce such danger as disturbs the security of a local or other subordinate class of persons, may be styled semi-public offenses operating merely by delinquency, or more briefly, offenses of mere delinquency. 13. With regard to any farther subdivisions, offenses through calamity will depend upon the nature of the several calamities to which man, and the several things that are of use to him, stand exposed. These will be considered in another place. 14. Semi-public offenses of mere delinquency will follow the method of division applied to offenses against individuals. It will easily be conceived that whatever pain or inconvenience any given individual may be made to suffer, to the danger of that pain or inconvenience may any number of individuals, assignable or not assignable, be exposed. Now, there are 4 points or articles, as we have seen, in respect to which an individual may be made to suffer pain or inconvenience. If, then, with respect to any one of them, the connection of causes and effects is such that to the danger of suffering in that article a number of persons, who individually are not assignable, may, by the delinquency of one person, be exposed, such article will form a ground of distinction on which a particular subdivision of semi-public offenses may be established. If, with respect to any such article, no such effect can take place, that ground of distinction will lie for the present unoccupied, ready, however, upon any change of circumstances, or in the manner of viewing the subject, to receive a correspondent subdivision of offenses if ever it should seem necessary that any such offenses should be created. 15. We come next to self-regarding offenses, or more properly, to acts productive in the first instance of no other than a self-regarding mischief, acts which, if in any instance it be thought fit to constitute them offenses, will come under the denomination of offenses against one's self. This class will not for the present give us much trouble, for it is evident that in whatever points a man is vulnerable by the hand of another, in the same points may he be conceived to be vulnerable by his own. Whatever divisions, therefore, will serve for the first class, the same will serve for this. As to the questions, what acts are productive of a mischief of this stamp, and among such are, which it may, and which it may not be worth while to treat upon the footing of offenses. These are points, the latter of which, at least, is too unsettled and too open to controversy to be laid down with that degree of confidence which is implied in the exhibition of properties which are made use of as the groundwork of an arrangement. Properties for this purpose ought to be such as show themselves at first glance, and appear to belong to the subject beyond dispute. 16. Public offenses may be distributed under 11 divisions. First, offenses against external security. Second, offenses against justice. Third, offenses against the preventive branch of the police. Fourth, offenses against the public force. Fifth, offenses against the positive increase of the national felicity. Sixth, offenses against the public wealth. Seventh, offenses against population. Eighth, offenses against the national wealth. Ninth, offenses against the sovereignty. 10th, offenses against religion. 11th, offenses against the national interest in general. The way in which these several sorts of offenses connect with each other, and with the interest of the public, that is, of an unassignable multitude of the individuals of which that body is composed, may thus be conceived. 17. Mischief by which the interest of the public, as above defined, may be effected, must, if produced at all, be produced either by means of an influence exerted on the operations of government, or by other means without the exertion of such influence. To begin with the latter case, mischief, be it what it will, and let it happen to whom it will, must be produced either by the unassisted powers of the agent in question, or by the instrumentality of some other agents. In the latter case, these agents will be either persons or things. Persons, again, must be either not members of the community in question, or members. Mischief produced by the instrumentality of persons may accordingly be produced by the instrumentality either of external or of internal adversaries. Now, when it is produced by the agent's own unassisted powers, or by the instrumentality of internal adversaries, or only by the instrumentality of things, it is seldom that it can show itself in any other shape, setting aside any influence it may exert on the operations of government, than either that of an offense against assignable individuals, or that of an offense against a local or other subordinate class of persons. If there should be a way in which mischief can be produced, by any of these means, to individuals altogether unassignable, it will scarcely be found conspicuous or important enough to occupy a title by itself. It may accordingly be referred to the miscellaneous head of offenses against the national interest in general. The only mischief, of any considerable amount, which can be made to impend indiscriminately over the whole number of members in the community, is that complex kind of mischief which results from a state of war, and is produced by the instrumentality of external adversaries, by their being provoked, for instance, or invited, or encouraged to invasion. In this way may a man very well bring down a mischief, and that a very heavy one, upon the whole community in general, and that without taking a part in any of the injuries which came in consequence to be offered to particular individuals. Next, with regard to the mischief which an offense may bring upon the public by its influence on the operations of the government. This it may occasion either, first, in a more immediate way, by its influence on those operations themselves; second, in a more remote way, by its influence on the instruments by or by the help of which those operations should be performed; or third, in a more remote way still, by its influence on the sources from whence such instruments are to be derived. First, then, as to the operations of government, the tendency of these, in as far as it is conformable to what on the principle of utility it ought to be, is in every sense either to avert mischief from the community, or to make an addition to the sum of positive good. Now mischief, we have seen, must come either from external adversaries, from internal adversaries, or from calamities. With regard to mischief from external adversaries, there requires no further division. As to mischief from internal adversaries, the expedients employed for averting it may be distinguished into such as may be applied before the discovery of any mischievous design in particular, and such as cannot be employed but in consequence of the discovery of some such design. The former of these are commonly referred to a branch which may be styled the preventive branch of the police, the latter to that of justice. Secondly, as to the instruments which government, whether in the averting of evil or in the producing of positive good, can have to work with, these must be either persons or things. Those which are destined to the particular function of guarding against mischief from adversaries in general, but more particularly from external adversaries, may be distinguished from the rest under the collective appellation of the public military force, and for conciseness' sake, the military force. The rest may be characterized by the collective appellation of the public wealth. Thirdly, with regard to the sources or funds from whence these instruments, however applied, must be derived, such of them as come under the denomination of persons must be taken out of the whole number of persons that are in the community, that is, out of the total population of the state, so that the greater the population, the greater the ceteris paribus be this branch of the public wealth, and the less, the less. In like manner, such as come under the denomination of things may be, and most of them commonly are, taken out of the sum total of those things which are the separate properties of the several members of the community, the sum of which properties may be termed the national wealth, so that the greater the national wealth, the greater ceteris paribus may be this remaining branch of the public wealth, and the less, the less. It is here to be observed that if the influence exerted on any occasion by any individual over the operations of the government be pernicious, it must be in one or other of two ways. 1. By causing, or tending to cause, operations not to be performed which ought to be performed, in other words, by impeding the operations of government. Or 2. By causing operations to be performed which ought not to be performed, in other words, by misdirecting them. Lastly, to the total assemblage of the persons by whom the several political operations above mentioned come to be performed, we set out with applying the collective appellation of the government. Among these persons there commonly is some one person, or body of persons, whose office it is to assign and distribute to the rest their several departments, to determine the conduct to be pursued by each in the performance of the particular set of operations that belongs to him, and even upon occasion to exercise his function in his stead. Where there is any such person or body of persons, he or it may, according to the turn of the phrase requires, be termed the sovereign or the sovereignty. Now it is evident that to impede or misdirect the operations of the sovereign, as here described, may be to impede or misdirect the operations of the several departments of government, as described above. From this analysis, by which the connection between several above-mentioned heads of offences is exhibited, we may now collect a definition for each article. By offences against external security, we may understand such offences whereof the tendency is to bring upon the public a mischief resulting from the hostilities of foreign adversaries. By offences against justice, such offences whereof the tendency is to impede or misdirect the operations of that power which is employed in the business of guarding the public against the mischiefs resulting from the delinquency of internal adversaries, as far as it is to be done by expedients, which do not come to be applied in any case till after the discovery of some particular design of the sort of those which they are calculated to prevent. By offences against the preventive branch of the police, such offences whereof the tendency is to impede or misdirect the operations of that power which is employed in guarding against mischiefs resulting from the delinquency of internal adversaries, by expedients that come to be applied beforehand, or of that which is employed in guarding against the mischiefs that might be occasioned by physical calamities. By offences against the public force, such offences whereof the tendency is to impede or misdirect the operations of that power which, destined to guard the public from the mischiefs which may result from the hostility of foreign adversaries, and, in case of necessity, in the capacity of ministers of justice, from mischiefs of the number of those which result from the delinquency of internal adversaries. By offences against the increase of the national felicity, such offences whereof the tendency is to impede or misapply the operations of those powers that are employed in the conducting of various establishments, which are calculated to make, in so many different ways, a positive addition to the stock of public happiness. By offences against the public wealth, such offences whereof the tendency is to diminish the amount or misdirect the application of the money and other articles of wealth which the government reserves as a fund, out of which the stock of instruments employed in the service above mentioned may be kept up. By offences against population, such offences whereof the tendency is to diminish the numbers or impair the political value of the sum total of the members of the community. By offences against the national wealth, such offences whereof the tendency is to diminish the quantity or impair the value of the things which compose the separate properties or estates of the several members of the community. 18. In this deduction, it may be asked, what place is left for religion? This we shall see presently. For combating the various kinds of offences above enumerated, that is, for combating all the offences, those not excepted which we are now about considering, which it is in man's nature to commit, the state has two great engines, punishment and reward. Punishment, to be applied to all, and upon all ordinary occasions. Reward, to be applied to a few, for particular purposes, and upon extraordinary occasions. But whether or no a man has done the act which renders him an object meet for punishment or reward, the eyes of those whosoever they be, to whom the management of these engines is entrusted, cannot always see, nor, where it is punishment that is to be administered, can their hands be always sure to reach him. To supply these deficiencies in point of power, it is thought necessary, or at least useful, without which the truth of the doctrine would be nothing to the purpose, to inculcate into the minds of the people the belief of the existence of a power applicable to the same purposes and not liable to the same deficiencies, the power of a supreme invisible being, to whom a disposition of contributing to the same ends to which the several institutions already mentioned are calculated to contribute, must for this purpose be ascribed. It is of course expected that this power will, at one time or other, be employed in the promoting of those ends, and to keep up and strengthen this expectation among men, it is spoken of as being the employment of a kind of allegorical personage, feigned, as before, for convenience of discourse, and styled religion. To diminish, then, or misapply the influence of religion, is pro tanto to diminish or misapply what power the state has of combating with effect any of the before enumerated kinds of offenses, that is, all kinds of offenses whatsoever. Acts that appear to have this tendency may be styled offenses against religion. Of these, then, may be composed the 10th division of the class of offenses against the state. 19. If there be any acts which appear liable to affect the state in any one or more of the above ways, by operating in prejudice of the external security of the state, or of its internal security, of the public force, of the increase of the national felicity, of the public wealth, of the rational population, of the national wealth, of the sovereignty, or of religion, at the same time that it is not clear in which of all these ways they will affect it most, nor but that, according to contingencies, they may affect it in one of these ways only, or in another. Such acts may be collected under a miscellaneous division by themselves, and styled offenses against the national interest in general. Of these, then, may be composed the 11th and last division of the class of offenses against the state. 20. We come now to class the 5th, consisting of multiform offenses. These, as has been already intimated, are either offenses by falsehood or offenses concerning trust. Under the head of offenses by falsehood may be comprehended simple falsehoods, forgery, personation, perjury. Let us observe in what particulars the four kinds of falsehood agree, and in what they differ. 21. Offenses by falsehood, however diversified in other particulars, have this in common, that they consist in some abuse of the faculty of discourse, or rather, as we shall see hereafter, of the faculty of influencing the sentiment of belief in other men, whether by discourse or otherwise. The use of discourse is to influence belief, and that in such manner as to give other men to understand that things are as they are really. Falsehoods, of whatever kind they be, agree in this, that they give men to understand that things are otherwise than they in reality they are. 22. Personation, forgery, and perjury are each of them distinguished from other modes of uttering falsehood by certain special circumstances. When a falsehood is not accompanied by any of those circumstances, it may be styled simple falsehood. These circumstances are, first, the form in which the falsehood is uttered; the second, the circumstance of its relating or not to the identity of the person of him who utters it; and third, the solemnity of the occasion on which it is uttered. The particular application of these distinctive characters may more commodiously be reserved for another place. 23. We come now to the subdivisions of offences by falsehood. These will bring us back into the regular track of analysis pursued without deviation through the four preceding classes. By whatever means a mischief is brought about, whether falsehood be or be not of the number, the individuals liable to be affected by it must either be assignable or unassignable. If assignable, there are but four material articles in respect to which they can be affected, to wit, their persons, their properties, their reputations, and their conditions in life. The case is the same if, though unassignable, they are comprisable in any class subordinate to that which is composed of the whole number of members of the state. If the falsehood tend to the detriment of the whole state, it can only be by operating in one or other of the characters which every act that is an offense against the state must assume, i.e., that of an offense against external security, against justice, against the preventive branch of the police, against the public force, against the increase of the national felicity, against the public wealth, against the national population, against the national wealth, against the sovereignty of the state, or against its religion. 24. It is the common property, then, of the offences that belong to this division to run over the same ground that is occupied by those of the preceding classes. But some of them, as we shall see, are apt, on various occasions, to drop or change the names which bring them under this division. This is chiefly the case with regard to simple falsehoods. Others retain their names unchanged, and even thereby supersede the names which would otherwise belong to the offences which they denominate. This is clearly the case with regard to personation, forgery, and perjury. When this circumstance, then, the circumstance of falsehood, intervenes, in some cases the name which takes the lead is that which indicates the offense by its effect. In other cases, it is that which indicates the expedient or instrument, as it were, by the help of which the offense is committed. Falsehood, take it by itself, consider it as not being accompanied by any other material circumstances, nor therefore productive of any material effects, can never, upon the principle of utility, constitute any offense at all. Combined with other circumstances, there is scarce any sort of pernicious effect which it may not be instrumental in producing. It is therefore rather in compliance with the laws of language, than in consideration of the nature of the things themselves, that falsehoods are made separate mention of under the name and in the character of distinct offences. All this would appear plain enough, if it were now a time for entering into particulars, but that is what cannot be done consistently with any principle of order or convenience, until the inferior divisions of those other classes shall have been previously exhibited. End of Chapter 16, Section 2, Part A.
Chapter 16, Paragraph 2, Part B, of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Anna Simon. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16. Division of Offences. Paragraph 2. Divisions and Subdivisions. Part B. We come now to offences against trust. A trust is, where there is any particular act which one party, in the exercise of some power or some right, which is conferred on him, is bound to perform for the benefit of another. Or, more fully, thus: a party is said to be invested with a trust, when, being invested with a power, or with a right, there is a certain behaviour which, in the exercise of that power, or of that right, he is bound to maintain for the benefit of some other party. In such case, the party first mentioned is styled a trustee. For the other party, no name has ever yet been found. For want of a name, there seems to be no other resource than to give a new and more extensive sense to the word beneficiary, or to say at length the party to be benefited. The trustee is also said to have a trust conferred or imposed upon him, to be invested with the trust, to have had a trust given him to execute, to perform, to discharge, or to fulfill. The party to be benefited is said to have a trust established or created in his favour, and so on through a variety of other phrases. Now it may occur that a trust is oftentimes spoken of as a species of condition, that a trust is also spoken of as a species of property, and that a condition itself is also spoken of same light. It may be thought, therefore, that in the first class the division of offences against condition should have been included under that of the offences against property, and that at any rate so much of the fifth class now before us as contains offences against trust should have been included under one or other of those two divisions of the first class. But upon examination it will appear that no one of these divisions could with convenience, nor even perhaps with propriety, have been included under either of the other two. It will appear at the same time that there is an intimate connection subsisting amongst them all, insomuch that of the lists of the offences to which they are respectively exposed, any one may serve in great measure as a model for any other. There are certain offences to which all trusts as such are exposed. To all these offences every sort of condition will be found exposed, at the same time that particular species of the offences against trust will, upon their application to particular conditions, receive different particular denominations. It will appear also that of the two groups of offences into which the list of those against trust will be found naturally to divide itself, there is one, and but one, to which property, taken in its proper and more confined sense, stands exposed, and that these in their application to the subject of property will be found susceptible of distinct modifications, to which the usage of language and the occasion there is for distinguishing them in point of treatment make it necessary to find names. In the first place, as there are, or at least may be, as we shall see, conditions which are not trusts, so there are trusts of which the idea would not be readily and naturally understood to be included under the word condition. Add to which that of those conditions which do include a trust, the greater number include other ingredients along with it, so that the idea of a condition, if on the one hand it stretches beyond the idea of a trust, does on the other hand fall short of it. Of the several sorts of trusts, by far the most important are those in which it is the public that stands in the relation of beneficiary. Now these trusts, it should seem, would hardly present themselves at first view upon the mention of the word condition. At any rate, what is more material, the most important of the offences against these kinds of trust would not seem to be included under the denomination of offences against condition. The offences which by this latter appellation would be brought to view would be such only as seem to affect the interests of an individual, of him, for example, who is considered as being invested with that condition. But in offences against public trust, it is the influence they have on the interests of the public that constitutes by much the most material part of their pernicious tendency. The influence they have on the interests of any individual, the only part of their influence which would be readily brought to view by the appellation of offences against condition, is comparatively as nothing. The word trust directs the attention at once to the interests of that party for whom the person in question is trustee, which party, upon the addition of the epithet public, is immediately understood to be the body composed of the whole assemblage, or an indefinite portion of the whole assemblage of the members of the State. The idea presented by the words public trust is clear and unambiguous. It is but an obscure and ambiguous garb that idea could be expressed in by the words public condition. It appears, therefore, that the principal part of the offences included under the denomination of offences against trust could not, commodiously at least, have been included under the head of offences against condition. It is evident enough that for the same reasons neither could they have been included under the head of offences against property. It would have appeared preposterous, and would have argued a total inattention to the leading principle of the whole work, the principle of utility, to have taken the most mischievous and alarming part of the offences to which the public stands exposed, and forced them into the list of offences against the property of an individual, of that individual, to wit, who in that case would be considered as having in him the property of that public trust which by the offences in question is affected. Nor would it have been less improper to have included conditions, all of them, under the head of property, and thereby the whole catalogue of offences against condition under the catalogue of offences against property. True it is that there are offences against condition which, perhaps with equal propriety and without any change in their nature, might be considered in the light of offences against property. So extensive and so vague are the ideas that are wont to be annexed to both these objects. But there are other offences which, though with unquestionable propriety they might be referred to the head of offences against condition, could not, without the utmost violence done to language, be forced under the appellation of offences against property. Property, considered with respect to the proprietor, implies invariably a benefit, and nothing else. Whatever obligations or burthens may by accident stand annexed to it, yet in itself it can never be otherwise than beneficial. On the part of the proprietor it is created not by any commands that are laid on him, but by his being left free to do with such or such an article as he likes. The obligations it is created by are in every instance laid upon other people. On the other hand, as to conditions, there are several which are of a mixed nature, importing as well as a burden to him who stands invested with them, as a benefit, which indeed is the case with those conditions which we hear most of under that name, and which make the greatest figure. There are even conditions which import nothing but burden, without any spark of benefit. Accordingly, when between two parties there is such a relation that one of them stands in the place of an object of property with respect to the other, the word property is applied only on one side, but the word condition is applied alike to both. It is but one of them that is said on that account to be possessed of property, but both of them are alike spoken of as being possessed of or being invested with a condition. It is the master alone that is considered as possessing a property, of which the servant, in virtue of the services he is bound to render, is the object. But the servant, not less than the master, is spoken of as possessing or being invested with a condition. The case is that if a man's condition is ever spoken of as constituting an article of his property, it is in the same loose and indefinite sense of the word in which almost every other offense that could be imagined might be reckoned into the list of offences against property. If the language indeed were in every instance in which it made use of the phrase object of property, perspicuous enough to point out under that appellation the material and really existent body, the person or the thing in which those acts terminate, by the performance of which the property is said to be enjoyed; if, in short, in the import given to the phrase object of property, it made no other use of it than the putting it to signify what is now called a corporeal object, this difficulty and this confusion would not have occurred. But the import of the phrase object of property, and in consequence the import of the word property, has been made to take a much wider range. In almost every case in which the law does anything for a man's benefit or advantage, men are apt to speak of it on some occasion or other as conferring on him a sort of property. At the same time, for one reason or other, it has in several cases been not practicable or not agreeable to bring to view, under the appellation of the object of his property, the thing in which he acts. by the performance of which the property is said to be enjoyed, have their termination, or the person in whom they have their commencement. Yet something which could be spoken of under that appellation was absolutely requisite. The expedient then has been to create, as it were, on every occasion, an ideal being, and to assign to a man this ideal being for the object of his property. And these are the sort of objects to which men of science, in taking a view of the operations of the law in this behalf, came, in process of time, to give the name of incorporeal. Now of this incorporeal object of property, the variety is prodigious. Fictitious entities of this kind have been fabricated almost out of everything, not conditions only, that of a trustee included, but even reputation have been of the number. Even liberty has been considered in this same point of view, and though on so many occasions it is contrasted with property, yet on other occasions, being reckoned into the catalogue of possessions, it seems to have been considered as a branch of property. Some of these applications of the words property, object of property, the last for instance, are looked upon, indeed, as more figurative, and less proper than the rest. But since the truth is, that where the immediate object is incorporeal, they are all of them improper, it is scarce practicable anywhere to draw the line. Notwithstanding all this latitude, yet, among the relations in virtue of which you are said to be possessed of a condition, there is one at least which can scarcely, by the most forced construction, be said to render any other man, or any other thing, the object of your property. This is the right of persevering in a certain course of action, for instance in the exercising of a certain trade. Now, to confer on you this right, in a certain degree at least, the law has nothing more to do than barely to abstain from forbidding you to exercise it. Were it to go farther, and, for the sake of enabling you to exercise your trade to the greater advantage, prohibit others from exercising the like, then, indeed, persons might be found who, in a certain sense, and by a construction rather forced than otherwise, might be spoken of as being the objects of your property, that is, by being made to render you that sort of negative service which consists in the forbearing to do those acts which would lessen the profits of your trade. But the ordinary right of exercising any such trade or profession, as is not the object of a monopoly, imports no such thing, and yet by possessing this right a man is said to possess a condition, and by forfeiting it to forfeit his condition. After all, it will be seen that there must be cases in which, according to the usage of language, the same offence may, with more or less appearance of propriety, be referred to the head of offences against condition, or that of offences against property, indifferently. In such cases the following rule may serve for drawing the line. Wherever, in virtue of your possessing a property, or being the object of a property possessed by another, you are characterized, according to the usage of language, by a particular name, such as master, servant, husband, wife, steward, agent, attorney, or the like, there the word condition may be employed in exclusion of the word property, and an offence in which, in virtue of your bearing such relation, you are concerned, either in the capacity of an offender or in that of a party injured, may be referred to the head of offences against condition, and not to that of offences against property. To give an example: being bound, in the capacity of land steward to a certain person, to oversee the repairing of a certain bridge, you forbear to do so. In this case, as the services you are bound to render are of the number of those which give occasion to the party from whom they are due to be spoken of under a certain generical name, that is, that of land steward, the offence of withholding them may be referred to the class of offences against condition. But suppose that, without being engaged in that general and miscellaneous course of service, which with reference to a particular person would denominate you his land steward, you are bound, whether by usage or by contract, to render him that single sort of service which consists in the providing, by yourself or by others, for the repairing of that bridge. In this case, as there is not any such current denomination to which, in virtue of your being bound to render this service, you stand aggregated, for that of architect, mason, or the like is not here in question, the offence you commit by withholding such service cannot with propriety be referred to the class of offences against condition. it can only therefore be referred to the class of offences against property. By way of further distinction, it may be remarked that where a man, in virtue of his being bound to render, or of others being bound to render him, certain services, is spoken of as possessing a condition, the assemblage of services is generally so considerable, in point of duration, as to constitute a course of considerable length, so as on a variety of occasions to come to be varied and repeated, and in most cases, when the condition is not of a domestic nature, sometimes for the benefit of one person, sometimes for that of another. Services which come to be rendered to a particular person on a particular occasion, especially if they be of short duration, have seldom the effect of occasioning either party to be spoken of as being invested with a condition. The particular occasional services which one man may come, by contract or otherwise, to be bound to render to another, are innumerably various, but the number of conditions which have names may be counted and are comparatively but few. If, after all, notwithstanding the rule here given for separating conditions from articles of property, any object should present itself which should appear to be referable, with equal propriety, to either head, the inconvenience would not be material, since in such cases, as will be seen a little farther on, whichever appellation were adopted, the list of the offences to which the object stands exposed would be substantially the same. These difficulties being cleared up, we now proceed to exhibit an analytical view of the several possible offences against trust. Offences against trust may be distinguished, in the first place, into such as concern the existence of the trust in the hands of such or such a person, and such as concern the exercise of the functions that belong to it. First, then, with regard to such as relate to its existence. An offence of this description, like one of any other description, if an offence it ought to be, must to some person or other import a prejudice. This prejudice may be distinguished into two branches. 1. That which may fall on such persons as are or should be invested with the trust. 2. That which may fall on the persons for whose sake it is or should be instituted, or on other persons at large. To begin with the former of these branches. Let any trust be conceived. The consequences which it is in the nature of it to be productive of to the possessor must, in as far as they are material, be either of an advantageous or of a disadvantageous nature. In as far as they are advantageous, the trust may be considered as a benefit or privilege. In as far as they are disadvantageous, it may be considered as a burden. To consider it then upon the footing of a benefit. The trust either is of the number of those which ought by law to subsist, that is, which the legislator meant should be established, or is not. If it is, the possession which at any time you may be deprived of with respect to it must at that time be either present or to come. If to come, in which case it may be regarded either as certain or as contingent, the investitive event, or event from whence your possession of it should have taken its commencement, was either an event in the production of which the will of the offender should have been instrumental, or any other event at large. In the former case the offence may be termed wrongful non-investment of trust; in the latter case, wrongful interception of trust. If at the time of the offence whereby you are deprived of it, you were already in possession of it, the offence may be styled wrongful divestment of trust. In any of these cases the effect of the offence is either to put somebody else into the trust or not. If not, it is wrongful divestment, wrongful interception, or wrongful divestment, and nothing more. If it be, the person put in possession is either the wrongdoer himself, in which case it may be styled usurpation of trust, or some other person, in which case it may be styled wrongful investment or attribution of trust. If the trust in question is not of the number of those which ought to subsist, it depends on the manner in which one man deprives another of it, whether such deprivation shall or shall not be an offence, and, accordingly, whether non-investment, interception, or divestment shall or shall not be wrongful. But the putting any body into it must at any rate be an offence, and this offence may be either usurpation or wrongful investment, as before. In the next place, to consider it upon the footing of a burden. In this point of view, if no other interests than that of the persons liable to be invested with it were considered, it is what ought not upon the principle of utility to subsist. If it ought, it can only be for the sake of the persons in whose favour it is established. If then it ought not on any account to subsist, neither non-investment, interception, nor divestment can be wrongful with relation to the persons first mentioned, whatever they may be on any other account, in respect of the manner in which they happen to be performed. For usurpation, though not likely to be committed, there is the same room as before; so likewise is there for wrongful investment, which, in as far as the trust is considered as a burden, may be styled wrongful imposition of trust. If the trust, being still of the burdensome kind, is of the number of those which ought to subsist, any offence that can be committed with relation to the existence of it must consist either in causing a person to be in possession of it who ought not to be, or in causing a person not to be in possession of it who ought to be. In the former case it must be either usurpation or wrongful divestment as before; in the latter case, the person who is caused to be not in possession is either the wrongdoer himself or some other. If the wrongdoer himself, either at the time of the offence he was in possession of it, or he was not. If he was, it may be termed wrongful abdication of trust; if not, wrongful detractation, or non-assumption. If the person whom the offence causes not to be in the trust is any other person, the offence must be either wrongful divestment, wrongful non-investment, or wrongful interception, as before; in any of which cases to consider the trust in the light of a burden, it might also be styled wrongful exemption from trust. Lastly, with regard to the prejudice which the persons for whose benefit the trust is instituted, or any other persons whose interests may come to be affected by its existing or not existing in such or such hands, are liable to sustain. Upon examination it will appear that by every sort of offence whereby the persons who are or should be in possession of it are liable, in that respect, to sustain a prejudice, the persons now in question are also liable to sustain a prejudice. The prejudice in this case is evidently of a very different nature from what it was of in the other, but the same general names will be applicable in this case as in that. If the beneficiaries, or persons whose interests are at stake upon the exercise of the trust, or any of them, are liable to sustain a prejudice resulting from the quality of the person by whom it may be filled, such prejudice must result from the one or the other of two causes: 1. From a person's having the possession of it who ought not to have it; or 2. From a person's not having it who ought. Whether it be a benefit or burden to the possessor is a circumstance that to this purpose makes no difference. In the first of these cases, the offences from which the prejudice takes its rise are those of usurpation of trust, wrongful attribution of trust, and wrongful imposition of trust. In the latter, wrongful non-investment of trust, wrongful interception of trust, wrongful divestment of trust, wrongful abdication of trust, and wrongful detractation of trust. So much for the offences which concern the existence or possession of a trust. Those which concern the exercise of the functions that belong to it may be thus conceived. You are in possession of a trust. The time then for your acting in it must, on any given occasion, neglecting for simplicity's sake the then present instant, be either past or yet to come. If past, your conduct on that occasion must have been either conformable to the purposes for which the trust was instituted, or unconformable. If conformable, there has been no mischief in the case. If unconformable, the fault has been either in yourself alone, or in some other person, or in both. In as far as it has lain in yourself, it has consisted either in your not doing something which you ought to do, in which case it may be styled negative breach of trust, or in your doing something which you ought not to do. If in the doing something which you ought not to do, the party to whom the prejudice has accrued is either the same for whose benefit the trust was instituted, or some other party at large. In the former of these cases, the offence may be styled positive breach of trust; in the other, abuse of trust. In as far as the fault lies in another person, the offence on his part may be styled disturbance of trust. Supposing the time for your acting in the trust to be yet to come, the effect of any act which tends to render your conduct Unconformable to the purposes of the trust may be either to render it actually and eventually unconformable, or to produce a chance of its being so. In the former of these cases it can do no otherwise than take one or other of the shapes that have just been mentioned. In the latter case the blame must lie either in yourself alone, or in some other person, or in both together, as before. If in another person, the acts whereby he may tend to render your conduct unconformable must be exercised either on yourself or on other objects at large. If exercised on yourself, the influence they possess must either be such as operates immediately on your body, or such as operates immediately on your mind. In the latter case, again, the tendency of them must be to deprive you either of the knowledge, or of the power, or of the inclination, which would be necessary to your maintaining such a conduct as shall be conformable to the purposes in question. If they be such, of which the tendency is to deprive you of the inclination in question, it must be by applying to your will the force of some seducing motive. Lastly, this motive must be either of the coercive or of the alluring kind. In other words, it must present itself either in the shape of a mischief or of an advantage. Now, in none of all the cases that have been mentioned, except the last, does the offence receive any new denomination. According to the event it is either a disturbance of trust, or an abortive attempt to be guilty of that offence. In this last it is termed bribery, and it is that particular species of it which may be termed active bribery, or bribe-giving. In this case, to consider the matter on your part, either you accept of the bribe or you do not. If not, and you do not afterwards commit, or go about to commit, either a breach or an abuse of trust, there is no offence on your part in the case. If you do accept it, whether you eventually do or do not commit the breach or the abuse which it is the bribe-giver's intention you should commit, you at any rate commit an offence which is also termed bribery, and which, for distinction's sake, may be termed passive bribery or bribe-taking. As to any farther distinctions, they will depend upon the nature of the particular sort of trust in question, and therefore belong not to the present place. And thus we have 13 subdivisions of offences against trust, viz. 1. Wrongful non-investment of trust. 2. Wrongful interception of trust. 3. Wrongful divestment of trust. 4. Usurpation of trust. 5. Wrongful investment or attribution of trust. 6. Wrongful abdication of trust. 7. Wrongful detractation of trust. 8. Wrongful imposition of trust. 9. Negative breach of trust. 10. Positive breach of trust. 11. Abuse of trust. 12. Disturbance of trust. 13. Bribery. From what has been said, it appears that there cannot be any other offences on the part of a trustee by which a beneficiary can receive on any particular occasion any assignable specific prejudice. One sort of acts, however, there are by which a trustee may be put in some danger of receiving a prejudice, although neither the nature of the prejudice nor the occasion on which he is in danger of receiving it should be assignable. These can be no other than such acts, whatever they may be, as dispose the trustee to be acted upon by a given bribe with greater effect than any with which he could otherwise be acted upon; or, in other words, which place him in such circumstances as have a tendency to increase the quantum of his sensibility to the action of any motive of the sort in question. Of these acts there seem to be no others that will admit of a description applicable to all places and times alike than acts of prodigality on the part of the trustee. But in acts of this nature the prejudice to the beneficiary is contingent only and unliquidated, while the prejudice to the trustee himself is certain and liquidated. If therefore on any occasion it should be found advisable to treat it on the footing of an offence, it will find its place more naturally in the class of self-regarding ones. As to the subdivisions of offences against trust, these are perfectly analogous to those of offences by falsehood. The trust may be private, semi-public, or public; it may concern property, person, reputation, or condition, or any two or more of those articles at a time, as will be more particularly explained in another place. Here too the offence, in running over the ground occupied by the three prior classes, will in some instances change its name, while in others it will not. Lastly, if it be asked, what sort of relation there subsists between falsehoods on one hand, and offences concerning trust on the other hand, the answer is, they are altogether disparate. Falsehood is a circumstance that may enter into the composition of any sort of offence, those concerning trust as well as any other; in some as an accidental, in others as an essential instrument. Breach or abuse of trust are circumstances which, in the character of accidental concomitants, may enter into the composition of any other offences (those against falsehood included) besides those to which they respectively give name. Chapter 16, paragraph 2.
Chapter 16 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ruth Golding. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16. Division of Offences. Paragraph 3. Genera of Class 1. Returning now to Class the First, let us pursue the distribution a step farther, and branch out the several divisions of that class as above exhibited into their respective genera, that is, into such minuter divisions as are capable of being characterized by denominations of which a great part are already current among the people. In this place the analysis must stop. To apply it in the same regular form to any of the other classes seems scarcely practicable. To semi-public as also to public offences, on account of the interference of local circumstances, to self-regarding ones, on account of the necessity it would create of deciding prematurely upon points which may appear liable to controversy, to offences by falsehood and offences against trust, on account of the dependence there is between this class and the three former. What remains to be done in this way with reference to these four classes will require discussion, and will therefore be introduced with more propriety in the body of the work than in a preliminary part, of which the business is only to draw outlines. An act by which the happiness of an individual is disturbed is either simple in its effects or complex. It may be styled simple in its effects when it affects him in one only of the articles or points in which his interest, as we have seen, is liable to be affected; complex when it affects him in several of those points at once. Such as are simple in their effects must of course be first considered. In a simple way, that is, in one way at a time, a man's happiness is liable to be disturbed either 1. By actions referring to his own person itself, or 2. By actions referring to such external objects on which his happiness is more or less dependent. As to his own person, it is composed of two different parts, or reputed parts, his body and his mind. Acts which exert a pernicious influence on his person, whether it be on the corporeal or on the mental part of it, will operate thereon either immediately and without affecting his will, or mediately through the intervention of that faculty, viz., by means of the influence which they cause his will to exercise over his body. If with the intervention of his will, it must be by mental coercion, that is, by causing him to will to maintain, and thence actually to maintain, a certain conduct which it is disagreeable, or in any other way pernicious, to him to maintain. This conduct may either be positive or negative. When positive, the coercion is styled compulsion or constraint; when negative, restraint. Now, the way in which the coercion is disagreeable to him may be by producing either pain of body or only pain of mind. If pain of body is produced by it, the offence will come as well under this as under other denominations, which we shall come to presently. Moreover, the conduct which a man by means of the coercion is forced to maintain will be determined either specifically and originally by the determination of the particular acts themselves which he is forced to perform or to abstain from, or generally and incidentally by means of his being forced to be or not to be in such or such a place. But if he is prevented from being in one place, he is confined thereby to another. For the whole surface of the earth, like the surface of any greater or lesser body, may be conceived to be divided into two, as well as into any other number of parts or spots. If the spot, then, which he is confined to, be smaller than the spot which he is excluded from, his condition may be called confinement; if larger, banishment. Whether an act, the effect of which is to exert a pernicious influence on the person of him who suffers by it, operates with or without the intervention of an act of his will, the mischief it produces will either be mortal or not mortal. If not mortal, it will either be reparable, that is temporary, or irreparable, that is perpetual. If reparable, the mischievous act may be termed a simple corporal injury; if irreparable, an irreparable corporal injury. Lastly, a pain that a man experiences in his mind will either be a pain of actual sufferance or a pain of apprehension. If a pain of apprehension, either the offender himself is represented as intending to bear a part in the production of it, or he is not. In the former case, the offence may be styled menacement; in the latter case, as also where the pain is a pain of actual sufferance, a simple mental injury. And thus we have 9 genera or kinds of personal injuries, which, when ranged in the order most commodious for examination, will stand as follows, viz. 1. Simple corporal injuries. 2. Irreparable corporal injuries. 3. Simple injurious restrainment. 4. Simple injurious compulsion. 5. Wrongful confinement. 6. Wrongful banishment. 7. Wrongful homicide. 8. Wrongful menacement. 9. Simple mental injuries. We come now to offences against reputation merely. These require but few distinctions. In point of reputation there is but one way of suffering, which is by losing a portion of the goodwill of others. Now, in respect of the goodwill which others bear you, you may be a loser in either of two ways: one, by the manner in which you are thought to behave yourself; and two, by the manner in which others behave, or are thought to behave, towards you. To cause people to think that you yourself have so behaved as to have been guilty of any of those acts which cause a man to possess less than he did before of the good will of the community, is what may be styled defamation. But such is the constitution of human nature, and such the force of prejudice, that a man merely by manifesting his own want of good will towards you, though ever so unjust in itself, and ever so unlawfully expressed, may, in a manner, force others to withdraw from you a part of theirs. When he does this by words, or by such actions as have no other effect than in as far as they stand in the place of words, the offence may be styled vilification. When it is done by such actions as, besides their having this effect, are injuries to the person, the offence may be styled a personal insult. If it has got the length of reaching the body, a corporal insult. If it stopped short before it reached that length, it may be styled insulting menacement. and thus we have two genera or kinds of offences against reputation merely, to wit, 1. Defamation, and 2. Vilification or revilement. As to corporal insults and insulting menacement, they belong to the compound title of offences against person and reputation, both together. If the property of one man suffers by the delinquency of another, such property either was in trust with the offender or it was not. If it was in trust, the offence is a breach of trust, and of whatever nature it may be in other respects, may be styled dissipation in breach of trust, or dissipation of property in trust. This is a particular case; the opposite one is the more common. In such case the several ways in which property may, by possibility, become the object of an offence, may be thus conceived. Offences against property, of whatever kind it be, may be distinguished, as hath been already intimated, into such as concern the legal possession of it, or right to it, and such as concern only the enjoyment of it, or, what is the same thing, the exercise of that right. Under the former of these heads come, as hath been already intimated, the several offences of wrongful non-investment, wrongful interception, wrongful divestment, usurpation, and wrongful attribution. When in the commission of any of these offences a falsehood has served as an instrument, and that, as it is commonly called, a wilful, or as it might more properly be termed, an advised one, the epithet fraudulent may be prefixed to the name of the offence, or substituted in the room of the word wrongful. The circumstance of fraudulency then may serve to characterize a particular species, comprisable under each of those generic heads. In like manner the circumstance of force, of which more a little farther on, may serve to characterize another. With respect to wrongful interception in particular, the investitive event, by which the title to the thing in question should have accrued to you, and for want of which such title is, through the delinquency of the offender, as it were, intercepted, is either an act of his own, expressing it as his will that you should be considered by the law as the person who is legally in possession of it, or it is any other event at large. In the former case, if the thing of which you should have been put into possession is a sum of money to a certain amount, the offence is that which has received the name of insolvency; which branch of delinquency, in consideration of the importance and extent of it, may be treated on the footing of a distinct genus of itself. Next, with regard to such of the offences against property as concern only the enjoyment of the object in question. This object must be either a service or set of services, which should have been rendered by some person, or else an article belonging to the class of things. In the former case, the offence may be styled wrongful withholding of services. In the latter case, it may admit of farther modifications, which may be thus conceived: when any object which you have had the physical occupation or enjoyment of ceases, in any degree, in consequence of the act of another man, and without any change made in so much of that power as depends upon the intrinsic physical condition of your person, to be subject to that power. This cessation is either owing to change in the intrinsic condition of the thing itself, or in its exterior situation with respect to you, that is, to its being situated out of your reach. In the former case, the nature of the change is either such as to put it out of your power to make any use of it at all, in which case the thing is said to be destroyed, and the offence whereby it is so treated may be termed wrongful destruction, or such only as to render the uses it is capable of being put to of less value than before, in which case it is said to be damaged, or to have sustained damage, and the offence may be termed wrongful endamagement. Moreover, in as far as the value which a thing is of to you is considered as being liable to be in some degree impaired by any act on the part of any other person exercised upon that thing, although on a given occasion no perceptible damage should ensue, the exercise of any such act is commonly treated on the footing of an offence, which may be termed wrongful using or occupation. If the cause of the thing's failing in its capacity of being of use to you lies in the exterior situation of it with relation to you, the offence may be styled wrongful detainment. Wrongful detainment or detention during any given period of time may either be accompanied with the intention of detaining the thing for ever, that is, for an indefinite time, or not. If it be, and if it be accompanied at the same time with the intention of not being amenable to law for what is done, it seems to answer to the idea commonly annexed to the word embezzlement, an offence which is commonly accompanied with breach of trust. In the case of wrongful occupation, the physical faculty of occupying may have been obtained with or without the assistance or consent of the proprietor, or other person appearing to have a right to afford such assistance or consent. If without such assistance or consent, and the occupation be accompanied with the intention of detaining the thing for ever, together with the intention of not being amenable to law for what is done, the offence seems to answer to the idea commonly annexed to the word theft or stealing. If in the same circumstances a force is put upon the body of any person who uses or appears to be disposed to use any endeavours to prevent the act, this seems to be one of the cases in which the offence is generally understood to come under the name of robbery. If the physical faculty in question was obtained with the assistance or consent of a proprietor or other person above spoken of, and still the occupation of the thing is an offence, it may have been either because the assistance or consent was not fairly, or because it was not freely obtained. If not fairly obtained, it was obtained by falsehood, which, if advised, is in such a case termed fraud, and the offence, if accompanied with the intention of not being amenable to law, may be termed fraudulent obtainment or defraudment. If not freely obtained, it was obtained by force, to wit, either by a force put upon the body which has been already mentioned, or by a force put upon the mind. If by a force put upon the mind, or in other words by the application of coercive motives, it must be by producing the apprehension of some evil, which evil, if the act is an offence, must be some evil to which on the occasion in question the one person has no right to expose the other. This is one case in which, if the offence be accompanied with the intention of detaining the thing for ever, whether it be or be not accompanied with the intention of not being amenable to law, it seems to agree with the idea of what is commonly meant by extortion. Now, the part a man takes in exposing another to the evil in question must be either a positive or a negative part. In the former case, again, the evil must either be present or distant. In the case, then, where the assistance or consent is obtained by a force put upon the body, or where, if by a force put upon the mind, the part taken in the exposing a man to the apprehension of the evil is positive, the evil present, and the object of it his person, and if at any rate the extortion thus applied be accompanied with the intention of not being amenable to law, it seems to agree with the remaining case of what goes under the name of robbery. As to dissipation in breach of trust, this, when productive of a pecuniary profit to the trustee, seems to be one species of what is commonly meant by peculation. Another, and the only remaining one, seems to consist in acts of occupation exercised by the trustee upon the things which are the objects of the fiduciary property, for his own benefit and to the damage of the beneficiary. As to robbery, this offence, by the manner in which the assistance or consent is obtained, becomes an offence against property and person at the same time. Dissipation in breach of trust and peculation may perhaps be more commodiously treated of under the head of offences against trust. After these exceptions we have 13 genera or principal kinds of offences against property, which, when ranged in the order most commodious for examination, may stand as follows, viz. 1. Wrongful non-investment of property. 2. Wrongful interception of property. 3. Wrongful divestment of property. 4. Usurpation of property. 5. Wrongful investment of property. 6. Wrongful withholding of services. 7. Wrongful destruction or endamagement. 8. Wrongful occupation. 9. Wrongful detainment. 10. Embezzlement. 11. Theft. 12. Defraudment. 13. Extortion. We proceed now to consider offences which are complex in their effects. Regularly, indeed, we should come to offences against condition, but it will be more convenient to speak first of offences by which a man's interest is affected in two of the preceding points at once. First, then, with regard to offences which affect person and reputation together. When any man, by a mode of treatment which affects the person, injures the reputation of another, his end and purpose must have been either his own immediate pleasure, or that sort of reflected pleasure which in certain circumstances may be reaped from the suffering of another. Now, the only immediate pleasure worth regarding, which any one can reap from the person of another, and which at the same time is capable of affecting the reputation of the latter, is the pleasure of the sexual appetite. This pleasure, then, if reaped at all, must have been reaped either against the consent of the party or with consent. If with consent, the consent must have been obtained either freely and fairly both, or freely but not fairly, or else not even freely, in which case the fairness is out of the question. If the consent be altogether wanting, the offence is called rape. If not fairly obtained, seduction simply. If not freely, it may be called forcible seduction. In any case, either the offence has gone the length of consummation, or has stopped short of that period. If it has gone that length, it takes one or other of the names just mentioned. If not, it may be included alike in all cases under the denomination of a simple lascivious injury. Lastly, to take the case where a man injuring you in your reputation, by proceedings that regard your person, does it for the sake of that sort of pleasure which will sometimes result from the contemplation of another's pain. Under these circumstances, either the offence has actually gone the length of a corporal injury, or it has rested in menacement. In the first case it may be styled a corporal insult. In the other it may come under the name of insulting menacement. And thus we have 6 genera or kind of offences against person and reputation together, which, when ranged in the order most commodious for consideration, will stand thus: 1. Corporal insults. 2. Insulting menacement. 3. Seduction. 4. Rape. 5. Forcible seduction. 6. Simple lascivious injuries. Secondly, with respect to those which affect person and property together, that a force put upon the person of a man may be among the means by which the title to property may be unlawfully taken away or acquired has been already stated. A force of this sort, then, is a circumstance which may accompany the offences of wrongful interception, wrongful divestment, usurpation, and wrongful investment. But in these cases the intervention of this circumstance does not happen to have given any new denomination to the offence. In all or any of these cases, however, by prefixing the epithet forcible, we may have so many names of offences which may either be considered as constituting so many species of the genera belonging to the division of offences against property, or as so many genera belonging to the division now before us. Among the offences that concern the enjoyment of the thing, the case is the same with wrongful destruction and wrongful endamagement, as also with wrongful occupation and wrongful detainment. As to the offence of wrongful occupation, it is only in the case where the thing occupied belongs to the class of immovables that, when accompanied by the kind of force in question, has obtained a particular name which is in common use. In this case it is called forcible entry. Forcible detainment, as applied also to immovables, but only to immovables, has obtained, among lawyers at least, the name of forcible detainer. And thus we may distinguish 10 genera or kinds of offences against person and property together, which, omitting for conciseness' sake the epithet wrongful, will stand thus: 1. Forcible interception of property. 2. Forcible divestment of property. 3. Forcible usurpation. 4. Forcible investment. 5. Forcible destruction or endamagement. 6. Forcible occupation of movables. 7. Forcible entry. 8. Forcible detainment of movables. 9. Forcible detainment of immovables. 10. Robbery. We come now to offences against condition. A man's condition or station in life is constituted by the legal relation he bears to the persons who are about him. That is, as we have already had occasion to show, by duties, which by being imposed on one side give birth to rights or powers on the other. These relations, it is evident, may be almost infinitely diversified. Some means, however, may be found of circumscribing the field within which the varieties of them are displayed. In the first place, they must either be such as are capable of displaying themselves within the circle of a private family, or such as require a larger space. The conditions constituted by the former sort of relations may be styled domestic, those constituted by the latter civil. As to domestic conditions, the legal relations by which they are constituted may be distinguished into 1. Such as are superadded to relations purely natural, and 2. Such as, without any such natural basis, subsist purely by institution. By relations purely natural, I mean those which may be said to subsist between certain persons in virtue of the concern which they themselves, or certain other persons, have had in the process which is necessary to the continuance of the species. These relations may be distinguished in the first place into contiguous and uncontiguous. The uncontiguous subsist through the intervention of such as are contiguous. The contiguous may be distinguished in the first place into connubial and postconnubial. Those which may be termed connubial are 2. 1. That which the male bears towards the female. 2. That which the female bears to the male. The postconnubial are either productive or derivative. The productive is that which the male and female above mentioned bear each of them towards the children who are the immediate fruit of their union. This is termed the relation of parentality. Now, as the parents must be, so the children may be, of different sexes. Accordingly, the relation of parentality may be distinguished into 4 species. 1. That which a father bears to his son. This is termed paternity. 2. That which a father bears to his daughter. This also is termed paternity. 3. That which a mother bears to her son. This is called maternity. 4. That which a mother bears to her daughter. This also is termed maternity. Uncontiguous natural relations may be distinguished into immediate and remote. Such as are immediate are what one person bears to another in consequence of their bearing each of them one simple relation to some third person. Thus the paternal grandfather is related to the paternal grandson by means of the 2 different kinds which together they bear to the father. The brother on the father's side to the brother by means of the 2 relations of the same kind which together they bear to the father. In the same manner we might proceed to find places in the system for the infinitely diversified relations which result from the combinations that may be formed by mixing together the several sorts of relationships by assent, relationships by dissent, collateral relationships, and relationships by affinity, which latter, when the union between the 2 parties through whom the affinity takes place is sanctioned by matrimonial solemnities, are termed relationships by marriage. But this, as it would be a most intricate and tedious task, so happily is it for the present purpose an unnecessary one. The only natural relations to which it will be necessary to pay any particular attention are those which, when sanctioned by law, give birth to the conditions of husband and wife, the 2 relations comprised under the head of parentality, and the corresponding relations comprised under the head of filiality or filiation. What then are the relations of a legal kind which can be superinduced upon the above-mentioned natural relations? They must be such as it is the nature of law to give birth to and establish. But the relations which subsist purely by institution exhaust, as we shall see, the whole stock of relationships which it is in the nature of the law to give birth to and establish. The relations then which can be superinduced upon those which are purely natural cannot be in themselves any other than what are of the number of those which subsist purely by institution, so that all the difference there can be between a legal relation of the one sort and a legal relation of the other sort is, that in the former case the circumstance which gave birth to the natural relation serves as a mark to indicate where the legal relation is to fix. In the latter case, the place where the legal relation is to attach is determined not by that circumstance but by some other. From these considerations it will appear manifestly enough that for treating of the several sorts of conditions, as well natural as purely conventional, in the most commodious order, it will be necessary to give the precedence to the latter. Proceeding throughout upon the same principle, we shall all along give the priority not to those which are first by nature, but to those which are most simple in point of description. There is no other way of avoiding perpetual anticipations and repetitions. End of chapter 16, paragraph 3, part A.
Chapter 16, Part 3b of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Part 3b. Genera of Class 1. We now come to consider the domestic or family relations, which are purely of legal institution. It is to these, in effect, that both kinds of domestic conditions, considered as the work of law, are indebted for their origin. When the law, no matter for what purpose, takes upon itself to operate in a matter in which it has not operated before, it can only be by imposing obligation. Now, when a legal obligation is imposed on any man, there are but two ways in which it can, in the first instance, be enforced. The one is by giving the power of enforcing it to the party in whose favour it is imposed. The other is by reserving that power to certain third persons, who, in virtue of their possessing it, are styled ministers of justice. In the first case, the party favoured is said to possess not only a right as against the party obliged, but also a power over him. In the second case, a right only, uncorroborated by power. In the first case, the party favoured may be styled a superior, and as they are both members of the same family, a domestic superior with reference to the party obliged, who, in the same case, may be styled a domestic inferior with reference to the party favoured. Now, in point of possibility, it is evident that domestic conditions, or a kind of fictitious possession analogous to domestic conditions, might have been looked upon as constituted as well by rights alone, without powers on either side, as by powers. But in point of utility, it does not seem expedient, and in point of fact probably owing to the invariable perception which men must have of the inexpediency, no such conditions seem ever to have been constituted by such feeble bands. Of the legal relationships, then, which are capable of being made to subsist within the circle of a family, there remain those only in which the obligation is enforced by power. Now, then, wherever such power is conferred, the end or purpose for which it was conferred, unless the legislator can be supposed to act without a motive, must have been the producing of a benefit to somebody. In other words, it must have been conferred for the sake of somebody. The person, then, for whose sake it is conferred, must either be one of the two parties just mentioned, or a third party. If one of those two, it must be either the superior or the inferior. If the superior, such superior is commonly called a master, and the inferior is termed his servant, and the power may be termed a beneficial one. If it be for the sake of the inferior that the power is established, the superior is termed a guardian, and the inferior his ward, and the power, being thereby coupled with a trust, may be termed a fiduciary one. If for the sake of a third party, the superior may be termed a superintendent, and the inferior his subordinate. This third party will either be an assignable individual, or a set of individuals, or a set of unassignable individuals. In this latter case, the trust is either a public or a semi-public one, and the condition which it constitutes is not of the domestic, but of the civil kind. In the former case, this third party or principal, as he may be termed, either has a beneficial power over the superintendent, or he has not. If he has, the superintendent is his servant, and consequently so also is the subordinate. If not, the superintendent is the master of the subordinate, and all the advantage which the principal has over his superintendent is that of possessing a set of rights, uncorroborated by power, and therefore, as we have seen, not fit to constitute a condition of the domestic kind. But be the condition what it may which is constituted by these rights, of what nature can the obligations be, to which the superintendent is capable of being subjected by means of them? They are neither more nor less than those which a man is capable of being subjected to by powers. It follows, therefore, that the functions of a principal and his superintendent coincide with those of a master and his servants, and consequently that the offences relative to the two former conditions will coincide with the offences relative to the two latter. Offences to which the condition of a master, like any other kind of condition, is exposed, may, as hath been already intimated, be distinguished into such as concern the existence of the condition itself, and such as concern the performance of the functions of it, while subsisting. First, then, with regard to such as affect its existence. It is obvious enough that the services of one man may be of benefit to another. The condition of a master may therefore be a beneficial one. It stands exposed, therefore, to the offences of wrongful non-investment, wrongful interception, usurpation, wrongful investment, and wrongful divestment. But how should it stand exposed to the offences of wrongful abdication, wrongful detrication, and wrongful imposition? Certainly it cannot of itself, for services, when a man has the power of exacting them or not, as he thinks fit, can never be a burthen. But if to the powers by which the condition of a master is constituted, the law thinks fit to annex any obligation on the part of the master, for instance that of affording maintenance, or giving wages to the servant, or paying money to anybody else, it is evident that in virtue of such obligation the condition may become a burthen. In this case, however, the condition possessed by the master will not, properly speaking, be the pure and simple condition of a master. It will be a kind of complex object, resolvable into the beneficial condition of a master and the burthensome obligation which is annexed to it. Still, however, if the nature of the obligation lies within a narrow compass, and does not, in the manner of that which constitutes a trust, interfere with the exercise of those powers by which the condition of the superior is constituted, the latter, notwithstanding this foreign mixture, will still retain the name of mastership. In this case, therefore, but not otherwise, the condition of a master may stand exposed to the offences of wrongful abdication, wrongful detrication, and wrongful imposition. Next, as to the behaviour of persons with reference to this condition while considered as subsisting. In virtue of it being a benefit, it is exposed to disturbance. This disturbance will either be the offence of a stranger or the offence of the servant himself. Where it is the offence of a stranger, and is committed by taking the person of the servant, in circumstances in which the taking of an object belonging to the class of things would be an act of theft, or, what is scarcely worth distinguishing from theft, an act of embezzlement, it may be termed servant stealing. Where it is an offence of the servant himself, it is styled breach of duty. Now, the most flagrant species of breach of duty, and that which includes indeed every other, is that which consists in the servant's withdrawing himself from the place in which the duty should be performed. This species of breach of duty is termed elopement. Again, in virtue of the power belonging to this condition, it is liable, on the part of the master, to abuse, but this power is not coupled with a trust. The condition of a master is therefore not exposed to any offence, which is analogous to breach of trust. Lastly, on account of it being exposed to abuse, it may be conceived to stand, in point of possibility, exposed to bribery. But considering how few and how insignificant the persons are who are liable to be the subject to the power here in question, this is an offence which, on account of the want of temptation, there will seldom be any example of in practice. We may therefore reckon 13 sorts of offences to which the condition of a master is exposed, viz. 1. Wrongful non-investment of mastership. 2. Wrongful interception of mastership. 3. Wrongful divestment of mastership. 4. Usurpation of mastership. 5. Wrongful investment of mastership. 6. Wrongful abdication of mastership. 7. Wrongful detraction of mastership. 8. Wrongful imposition of mastership. 9. Abuse of mastership. 10. Disturbance of mastership. 11. Breach of duty in servants. 12. Elopement of servants. 13. Service stealing. As to the power by which the condition of a master is constituted, this may be either limited or unlimited. When it is altogether unlimited, the condition of the servant is styled pure slavery. But as the rules of language are as far as can be conceived from being steady on this head, the term slavery is commonly made use of wherever the limitations prescribed to the power of the master are looked upon as inconsiderable. Whenever any such limitation is prescribed, a kind of fictitious entity is thereby created, and in quality of an incorporeal object of possession is bestowed upon the servant. This object is of the class of those which are called rights, and in the present case is termed in a more particular manner a liberty, and sometimes a privilege, an immunity, or an exemption. Now these limitations on one hand, and these liberties on the other, may, it is evident, be as various as the acts, positive or negative, which the master may or may not have the power of obliging the servants to submit to or to perform. Correspondent then to the infinitude of these liberties is the infinitude of the modification which the condition of mastership, or as it is more common to say in such a case, that of servitude, admits of. These modifications, it is evident, may in different countries be infinitely diversified. In different countries, therefore, the offence characterised by the above names will, if specifically considered, admit of very different descriptions. If there be a spot upon the earth so wretched as to exhibit the spectacle of pure and absolutely unlimited slavery, on that spot there will be no such thing as any abuse of mastership, which means neither more nor less than no abuse of mastership will there be treated on the footing of an offence. As to the question whether any and what modes of servitude ought to be established or kept on foot, this is a question the solution of which belongs to the civil branch of the art of legislation. Next, with regard to the offences that may concern the condition of a servant. It might seem at first sight that a condition of this kind could not have a spark of benefit belonging to it, that it could not be attended with any other consequences than such as rendered it a mere burthen. But a burthen itself may be a benefit, in comparison of a greater burthen. Conceive a man's situation then to be such, that he must, at any rate, be in a state of pure slavery. Still may it be material to him, and highly material, who the person is whom he has for his master. A state of slavery then under one master may be a beneficial state to him, in comparison with a state of slavery under another master. The condition of a servant then is exposed to the several offences to which a condition, in virtue of it being a beneficial one, is exposed. More than this, where the power of the master is limited, and the limitations annexed to it, and hence the liberties of the servant are considerable, the servitude may even be positively eligible. For amongst those limitations may be such as sufficient to enable the servant to possess property of his own. Being capable then of possessing property of his own, he may be capable of receiving it from his master. In short, he may receive wages or other emoluments from his master, and the benefit resulting from these wages may be so considerable as to outweigh the burthen of the servitude, and by that means render that condition more beneficial upon the whole, and more eligible than that of one who is not in any respect under the control of any such person as a master. Accordingly, by these means the condition of the servant may be so eligible that his entrance into it and his continuance in it may have been altogether the result of his own choice. That the nature of the two conditions may be the more clearly understood, it may be of use to show the sort of correspondency there is between the offences which affect the existence of the one and those which affect the existence of the other. That this correspondency cannot but be very intimate is obvious at first sight. It is not, however, that a given offence in the former catalogue coincides with an offence of the same name in the latter catalogue. Usurpation of servantship with usurpation of mastership, for example. But the case is that an offence of one denomination in the one catalogue coincides with an offence of a different denomination in the other catalogue. Nor is the coincidence constant and certain, but liable to contingencies, as we shall see. First, then, wrongful non-investment of the condition of a servant, if it be the offence of one who should have been the master, coincides with wrongful detraction of mastership. If it be the offence of a third person, it involves in it non-investment of mastership, which, provided the mastership be in the eyes of him who should have been master a beneficial thing, but not otherwise, is wrongful. Wrongful interception of the condition of a servant, if it be the offence of him who should have been master, coincides with the wrongful detraction of mastership, if it be the offence of a third person, and the mastership be a beneficial thing, it involves in it wrongful interception of mastership. 3. Wrongful divestment of servantship, if it be the offence of the master but not otherwise, coincides with wrongful abdication of mastership. If it be the offence of a stranger, it involves in it divestment of mastership, which, as in far as the mastership is a beneficial thing, is wrongful. 4. Usurpation of servantship coincides necessarily with wrongful imposition of mastership. It will be apt to involve in it wrongful divestment of mastership, but this only in the case where the usurper, previously to the usurpation, was in a state of servitude under some other master. 5. Wrongful investment of servantship, the servantship being considered as a beneficial thing, coincides with imposition of mastership, which, if in the eyes of the pretended master the mastership should chance to be a burden, will be wrongful. 6. Wrongful abdication of servantship coincides with wrongful divestment of mastership. 7. Wrongful detraction of servantship with wrongful non-investment of mastership. 8. Wrongful imposition of servantship, if it be the offence of the pretended master, coincides with usurpation of mastership. If it be the offence of a stranger, it involves in it imposition of mastership, which, if in the eyes of the pretended master the mastership should be a burthen, will be wrongful. As to abuse of mastership, disturbance of mastership, breach of duty in servants, elopement of servants, and servant stealing, these were offences which, without any change of denomination, bear equal relation to both conditions. And thus we may reckon 13 sorts of offences to which the condition of a servant stands exposed, viz. 1. Wrongful non-investment of servantship. 2. Wrongful interception of servantship. 3. Wrongful divestment of servantship. 4. Usurpation of servantship. 5. Wrongful investment of servantship. 6. Wrongful abdication of servantship. 7. Wrongful detraction of servantship. 8. Wrongful imposition of servantship. 9. Abuse of mastership. 10. Disturbance of mastership. 11. Breach of duty in servants. 12. Elopement of servants. 13. Servant stealing. We now come to the offences to which the condition of a guardian is exposed. A guardian is one who is invested with power over another, living within the compass of the same family, and called a ward, the power being to be exercised for the benefit of the ward. Now then, what are the cases in which it can be for the benefit of one man that another, living within the compass of the same family, should exercise power over him? Consider either of the parties by himself, and suppose him, in point of understanding, to be on the level with the other. It seems evident enough that no such cases can ever exist. To the production of happiness on the part of any given person, in like manner as to the production of any other effect which is the result of human agency, three things it is necessary should concur: knowledge, inclination, and physical power. Now, as there is no man who is so sure of being inclined on all occasions to promote your happiness as you yourself are, so neither is there any man who upon the whole can have had so good opportunities as you must have had for knowing what is most conducive to that purpose. For who should know as well as you what it is that gives you pain or pleasure? Moreover, as to power, it is manifest that no superiority in this respect, on the part of a stranger, could, for constancy, make up for so great a deficiency as he must lie under in respect of two such material points as knowledge and inclination. If then there be a case when it can be for the advantage of one man to be under the power of another, it must be on account of some palpable and very considerable deficiency on the part of the former in point of intellects, or, what is the same thing in other words, in point of knowledge or understanding. Now there are two cases in which such palpable deficiency is known to take place. These are, 1. When a man's intellect is not yet arrived at that state in which it is capable of directing his own inclination in the pursuit of happiness. This is the case of infancy. 2. When by some particular known or unknown circumstance his intellect has either never arrived at that state, or having arrived at it has fallen from it, which is the case of insanity. By which means then is it to be ascertained whether a man's intellect is in that state or no? For exhibiting the quantity of sensible heat in the human body we have a very tolerable sort of instrument, the thermometer. But for exhibiting the quantity of intelligence we have no such instrument. It is evident, therefore, that the line which separates the quantity of intelligence which is sufficient for the purpose of self-government from that which is not sufficient must be, in a great measure, arbitrary. Where the insufficiency is the result of want of age, the sufficient quantity of intelligence, be it what it may, does not accrue to all at the same period of their lives. It becomes therefore necessary for legislators to cut the Gordian knot and fix upon a particular period, at which, and not before, truly or not, every person whatever shall be deemed, as far as depends upon age, to be in possession of this sufficient quantity. In this case, then, a line is drawn which may be the same for every man, and in the description of which, such as it is, whatever persons are concerned may be certain of agreeing, the circumstance of time affording a mark by which the line in question may be traced with the utmost degree of nicety. On the other hand, when the insufficiency is the result of insanity, there is not even this resource, so that here the legislator has no other expedient than to appoint some particular person or persons to give a particular determination of the question, in every instant in which it occurs, according to his or their particular and arbitrary discretion. Arbitrary enough it must be at any rate, since the only way in which it can be exercised is by considering whether the share of intelligence possessed by the individual in question does or does not come up to the loose and indeterminate idea which persons so appointed may chance to entertain with respect to the quantity which is deemed sufficient. The line then being drawn, or supposed to be so, it is expedient to a man who cannot with safety to himself be left in his own power, that he should be placed in the power of another. How long then should he remain so? Just so long as his inability is supposed to continue, that is, in the case of infancy, till he arrives at that period at which the law deems him to be of full age, in the case of insanity, till he be of sound mind and understanding. Now it is evident that this period in the case of infancy may not arrive for a considerable time, and in the case of insanity, perhaps never. The duration of the power belonging to this trust must, therefore, in the one case be very considerable, in the other case indefinite. The next point to consider is what may be the extent of it, for as to what ought to be, that is a matter to be settled, not in a general analytical sketch, but in a particular and circumstantial dissertation. By possibility, then, this power may possess any extent that can be imagined. It may extend to any acts which, physically speaking, it may be in the power of the ward to perform himself, or be the object of if exercised by the guardian. Conceive the power, for a moment, to stand upon this footing. The condition of the ward stands now exactly upon a footing with pure slavery. Add the obligation by which the power is turned into a trust, the limits of the power are now very considerably narrowed. What then is the purport of this obligation? Of what nature is the course of conduct it prescribes? It is such a course of conduct as shall be best calculated for procuring to the ward the greatest quantity of happiness, which his faculties, and the circumstances he is in, will admit of, saving always in the first place the regard which the guardian is permitted to show to his own happiness, and in the second place that which he is obliged as well as permitted to show to that of other men. This is, in fact, no other than the course of conduct which the ward, did he but know how, ought, in point of prudence, to maintain of himself, so that the business of the former is to govern the latter precisely in the manner in which this latter ought to govern himself. Now, to instruct each individual in what manner to govern his own conduct in the details of life is the particular business of private ethics. To instruct individuals in what manner to govern the conduct of those whose happiness during non-age is permitted to their charge is the business of the art of private education. The details, therefore, of the rules to be given for that purpose, any more than the acts which are capable of being committed in violation of those rules, belong not to the art of legislation, since, as will be seen more particularly hereafter, such details could not, with any chance of advantage, be provided for by the legislator. Some general outlines might indeed be drawn by his authority, and in point of fact some are in every civilized state. But such regulations, it is evident, must be liable to great variation, in the first place according to the infinite diversity of civil conditions which a man may stand invested with in any given state. In the next place, according to the diversity of local circumstances that may influence the nature of the conditions which may chance to be established in different states. On this account, the offences which would be constituted by such regulations could not be comprised under any concise and settled denominations, capable of a permanent and extensive application. No place, therefore, can be allotted to them here. End of section 23.
Chapter 16 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ruth Golding. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16. Division of Offences. Paragraph 3. Genera of Class 1. Part C. By what has been said, we are the better prepared for taking an account of the offences to which the condition in question stands exposed. Guardianship, being a private trust, is, of course, exposed to those offences and no others by which a private trust is liable to be affected. Some of them, however, on account of the special quality of the trust, will admit of some further particularity of description. In the first place, breach of this species of trust may be termed mismanagement of guardianship. In the second place, of whatever nature the duties are which are capable of being annexed to this condition, it must often happen that in order to fulfil them, it is necessary the guardian should be at a certain particular place. Mismanagement of guardianship, when it consists in the not being, on the occasion in question, at the place in question, may be termed desertion of guardianship. Thirdly, it is manifest enough that the object which the guardian ought to propose to himself in the exercise of the powers to which those duties are annexed, is to procure for the ward the greatest quantity of happiness which can be procured for him, consistently with the regard which is due to the other interests that have been mentioned. For this is the object which the ward would have proposed to himself, and might and ought to have been allowed to propose to himself had he been capable of governing his own conduct. Now, in order to procure this happiness, it is necessary that he should possess a certain power over the objects on the use of which such happiness depends. These objects are either the person of the ward himself, or other objects that are extraneous to him. These other objects are either things or persons. As to things, then, objects of this class, in so far as a man's happiness depends upon the use of them, are styled his property. The case is the same with the services of any persons over whom he may happen to possess a beneficial power, or to whose services he may happen to possess a beneficial right. Now, when property of any kind which is in trust suffers by the delinquency of him with whom it is in trust, such offence, of whatever nature it is in other respects, may be styled dissipation in breach of trust. And if it be attended with a profit to the trustee, it may be styled peculation. Fourthly, for one person to exercise a power of any kind over another, it is necessary that the latter should either perform certain acts, upon being commanded so to do by the former, or at least should suffer certain acts to be exercised upon himself. In this respect a ward must stand upon the footing of a servant, and the condition of a ward must, in this respect, stand exposed to the same offences to which that of a servant stands exposed. That is, on the part of a stranger, to disturbance, which in particular circumstances will amount to theft; on the part of the ward, to breach of duty, which in particular circumstances may be effected by elopement. Fifthly, there does not seem to be any offence concerning guardianship that corresponds to abuse of trust. I mean in the sense to which the last mentioned denomination has been here confined. The reason is that guardianship, being a trust of a private nature, does not, as such, confer upon the trustee any power, either over the persons or over the property of any party, other than the beneficiary himself. If by accident it confers on the trustee a power over any persons whose services constitute a part of the property of the beneficiary, the trustee becomes thereby, in certain respects, the master of such servants. Sixthly, bribery also is a sort of offence to which, in this case, there is not commonly much temptation. It is an offence, however, which by possibility is capable of taking this direction, and must therefore be aggregated to the number of the offences to which the condition of a guardian stands exposed. And thus we have in all 17 of these offences, viz. 1. Wrongful non-investment of guardianship. 2. Wrongful interception of guardianship. 3. Wrongful divestment of guardianship. 4. Usurpation of guardianship. 5. Wrongful investment of guardianship. 6. Wrongful abdication of guardianship. 7. Detractation of guardianship. 8. Wrongful imposition of guardianship. 9. Mismanagement of guardianship. 10. Desertion of guardianship. 11. Dissipation in prejudice of wardship. 12. Peculation in prejudice of wardship. 13. Disturbance of guardianship. 14. Breach of duty to guardians. 15. Elopement from guardians. 16. Ward stealing. 17. Bribery in prejudice of wardship. Next, with regard to offences to which the condition of wardship is exposed. Those which first affect the existence of the condition itself are as follows. 1. Wrongful non-investment of the condition of a ward. This, if it be the offence of one who should have been guardian, coincides with wrongful detractation of guardianship. If it be the offence of a third person, it involves in it non-investment of guardianship, which, provided the guardianship is, in the eyes of him who should have been guardian, a desirable thing, is wrongful. 2. Wrongful interception of wardship. This, if it be the offence of him who should have been guardian, coincides with wrongful detractation of guardianship. If it be the offence of a third person, it involves in it interception of guardianship, which, provided the guardianship is, in the eyes of him who should have been guardian, a desirable thing, is wrongful. 3. Wrongful divestment of wardship. This, if it be the offence of the guardian, but not otherwise, coincides with wrongful abdication of guardianship. If it be the offence of a third person, it involves in it divestment of guardianship, which, if the guardianship is, in the eyes of the guardian, a desirable thing, is wrongful. 4. Usurpation of the condition of a ward, an offence not very likely to be committed. This coincides at any rate with wrongful imposition of guardianship, and if the usurper were already under the guardianship of another guardian, it will involve in it wrongful divestment of such guardianship. 5. Wrongful investment of wardship, the wardship being considered as a beneficial thing. This coincides with imposition of guardianship, which, if in the eyes of the pretended guardian the guardianship should be a burthen, will be wrongful. 6. Wrongful abdication of wardship. This coincides with wrongful divestment of guardianship. 7. Wrongful detractation of wardship. This coincides with wrongful interception of guardianship. 8. Wrongful imposition of wardship. This, if the offender be the pretended guardian, coincides with usurpation of guardianship. If a stranger, it involves in it wrongful imposition of guardianship. As to such of the offences relative to this condition as concern the consequences of it while subsisting, they are of such a nature that, without any change of denomination, they belong equally to the condition of a guardian and that of a ward. We may therefore reckon 17 sorts of offences relative to the condition of a ward. 1. Wrongful non-investment of wardship. 2. Wrongful interception of wardship. 3. Wrongful divestment of wardship. 4. Usurpation of wardship. 5. Wrongful investment of wardship. 6. Wrongful abdication of wardship. 7. Wrongful detractation of wardship. 8. Wrongful imposition of wardship. 9. Mismanagement of guardianship. 10. Desertion of guardianship. 11. Dissipation in prejudice of wardship. 12. Peculation in prejudice of wardship. 13. Disturbance of guardianship. 14. Breach of duty to guardians. 15. Elopement from guardians. 16. Ward stealing. 17. Bribery in prejudice of wardship. We come now to the offences to which the condition of a parent stands exposed. and first with regard to those by which the very existence of the condition is affected. On this occasion, in order to see the more clearly into the subject, it will be necessary to distinguish between the natural relationship and the legal relationship, which is superinduced, as it were, upon the natural one. The natural one being constituted by a particular event, which either on account of its being already past, or on some other account, is equally out of the power of the law, neither is nor can be made the subject of an offence. Is a man your father? It is not any offence of mine that can make you not his son. Is he not your father? It is not any offence of mine that can render him so. But although he does in fact bear that relation to you, I, by an offence of mine, may perhaps so manage matters that he shall not be thought to bear it, which, with respect to any legal advantages which either he or you could derive from such relationship, will be the same thing as if he did not. In the capacity of a witness, I may cause the judges to believe that he is not your father, and to decree accordingly; or, in the capacity of a judge, I may myself decree him not to be your father. Leaving then the purely natural relationship as an object equally out of the reach of justice and injustice, the legal condition, it is evident, will stand exposed to the same offences, neither more nor less, as every other condition that is capable of being either beneficial or burthensome stands exposed to. Next, with regard to the exercise of the functions belonging to this condition, considered as still subsisting. In parentality there must be two persons concerned, the father and the mother. The condition of a parent includes, therefore, two conditions, that of a father and that of a mother, with respect to such or such a child. Now, it is evident that between these two parties, whatever beneficiary powers and other rights, as also whatever obligations are annexed to the condition of a parent, may be shared in any proportions that can be imagined. But if in these several objects of legal creation each of these two parties have severally a share, and if the interests of all these parties are in any degree provided for, it is evident that each of the parents will stand, with relation to the child, in two several capacities, that of a master and that of a guardian. The condition of a parent, then, in as far as it is the work of law, may be considered as a complex condition, compounded of that of a guardian and that of a master. To the parent, then, in quality of guardian, results a set of duties, involving, as necessary to the discharge of them, certain powers. To the child, in the character of a ward, a set of rights corresponding to the parent's duties, and a set of duties corresponding to his powers. To the parent again, in quality of master, a set of beneficiary powers, without any other necessary limitation, so long as they last, than what is annexed to them by the duties incumbent on him in quality of a guardian. To the child, in the character of a servant, a set of duties corresponding to the parent's beneficiary powers, and without any other necessary limitation, so long as they last, than what is annexed to them by the rights which belong to the child in his capacity of ward. The condition of a parent will therefore be exposed to all the offences to which either that of a guardian or that of a master are exposed. And as each of the parents will partake more or less of both those characters, the offences to which the two conditions are exposed may be nominally, as they will be substantially, the same. Taking them, then, all together, the offences to which the condition of a parent is exposed will stand as follows: 1. Wrongful non-investment of parentality. 2. wrongful interception of parentality. 3. Wrongful divestment of parentality. 4. Usurpation of parentality. 5. Wrongful investment of parentality. 6. Wrongful abdication of parentality. 7. Wrongful detractation of parentality. 8. Wrongful imposition of parentality. 9. Mismanagement of parental guardianship. 10. Desertion of parental guardianship. 11. Dissipation in prejudice of filial wardship. 12. Peculation in prejudice of filial wardship. 13. Abuse of parental powers. 14. Disturbance of parental guardianship. 15. Breach of duty to parents. 16. Elopement from parents. 17. Child stealing. 18. Bribery in prejudice of filial wardship. Next, with regard to the offences to which the filial condition, the condition of a son or daughter, stands exposed. The principles to be pursued in the investigation of offences of this description have already been sufficiently developed. It will be sufficient, therefore, to enumerate them without further discussion. The only peculiarities by which offences relative to the condition in question stand distinguished from the offences relative to all the preceding conditions depend upon this one circumstance, viz., that it is certain every one must have had a father and a mother, at the same time that it is not certain that every one must have had a master, a servant, a guardian, or a ward. It will be observed all along that where a person from whom, if alive, the benefit would be taken, or on whom the burthen would be imposed, be dead, so much of the mischief is extinct along with the object of the offence. There still, however, remains so much of the mischief as depends upon the advantage or disadvantage which might accrue to persons related or supposed to be related in the several remoter degrees to him in question. The catalogue, then, of these offences stands as follows. 1. Wrongful non-investment of filiation. This, if it be the offence of him or her who should have been recognised as the parent, coincides with wrongful detractation of parentality. If it be the offence of a third person, it involves in it non-investment of parentality, which, provided the parentality is, in the eyes of him or her who should have been recognised as the parent, a desirable thing, is wrongful. 2. Wrongful interception of filiation. This, if it be the offence of him or her who should have been recognised as the parent, coincides with wrongful detractation of parentality. If it be the offence of a third person, it involves in it interception of parentality, which, provided the parentality is, in the eyes of him or her who should have been recognised as parent, a desirable thing, is wrongful. 3. Wrongful divestment of filiation. This, if it be the offence of him or her who should be recognised as parent, coincides with wrongful abdication of parentality. If it be the offence of a third person, it involves in it divestment of parentality, to wit, of paternity, or of maternity, or of both, which, if the parentality is, in the eyes of him or her who should be recognised as parent, a desirable thing, are respectively wrongful. 4. Usurpation of filiation. This coincides with wrongful imposition of parentality, to wit, either of paternity, or of maternity, or of both, and necessarily involves in it divestment of parentality, which, if the parentality thus divested were, in the eyes of him or her who are thus divested of it, a desirable thing, is wrongful. 5. Wrongful investment of filiation, the filiation being considered as a beneficial thing. This coincides with imposition of parentality, which, if in the eyes of the pretended father or mother the parentality should be an undesirable thing, will be wrongful. 6. Wrongful abdication of filiation. This necessarily coincides with wrongful divestment of parentality. It also is apt to involve in it wrongful imposition of parentality, though not necessarily either to the advantage or to the prejudice of any certain person. For if a man, supposed at first to be your son, appears afterwards not to be yours, it is certain indeed that he is the son of some other man, but it may not appear who that other man is. 7. Wrongful detractation of filiation. This coincides with wrongful non-investment or wrongful interception of parentality. 8. Wrongful imposition of filiation. This, if it be the offence of the pretended parent, coincides necessarily with usurpation of parentality. If it be the offence of a third person, it necessarily involves imposition of parentality, as also divestment of parentality, either or both of which, according to the circumstance above mentioned, may or may not be wrongful. 9. Mismanagement of parental guardianship. 10. Desertion of parental guardianship. 11. Dissipation in prejudice of filial wardship. 12. Peculation in prejudice of filial wardship. 13. Abuse of parental power. 14. Disturbance of parental guardianship. 15. Breach of duty to parents. 16. Elopement from parents. 17. Child stealing. 18. Bribery in prejudice of parental guardianship. We shall now be able to apply ourselves with some advantage to the examination of the several offences to which the marital condition, or condition of a husband, stands exposed. A husband is a man between whom and a certain woman, who in this case is called his wife, there subsists a legal obligation for the purpose of their living together, and in particular for the purpose of a sexual intercourse to be carried on between them. This obligation will naturally be considered in 4 points of view. 1. In respect of its commencement. 2. In respect of the placing of it. 3. In respect of the nature of it. 4. In respect of its duration. First, then, it is evident that in point of possibility one method of commencement is as conceivable as another. The time of its commencement might have been marked by one sort of event, by one sort of signal, as it may here be called, as well as by another. But in practice the signal has usually been, as in point of utility it ought constantly to be, a contract entered into by the parties, that is, a set of signs pitched upon by the law as expressive of their mutual consent to take upon them this condition. Secondly and thirdly, with regard to the placing of the obligations which are the result of the contract, it is evident that they must rest either solely on one side or mutually on both. On the first supposition, the condition is not to be distinguished from pure slavery. In this case, either the wife must be the slave of the husband, or the husband of the wife. The first of these suppositions has perhaps never been exemplified, the opposing influence of physical causes being too universal to have ever been surmounted. The latter seems to have been exemplified but too often, perhaps among the first Romans, at any rate in many barbarous nations. Thirdly, with regard to the nature of the obligations. If they are not suffered to rest all on one side, certain rights are thereby given to the other. There must therefore be rights on both sides. Now, where there are mutual rights possessed by two persons as against each other, either there are powers annexed to those rights or not. But the persons in question are, by the supposition, to live together, in which case we have shown that it is not only expedient, but in a manner necessary, that on one side there should be powers. Now it is only on one side that powers can be, for suppose them on both sides, and they destroy one another. The question is, then, in which of the parties these powers shall be lodged. We have shown that on the principle of utility they ought to be lodged in the husband. The powers, then, which subsist being lodged in the husband, the next question is, shall the interest of one party only, or of both, be consulted in the exercise of them? It is evident that on the principle of utility the interests of both ought alike to be consulted, since in two persons taken together more happiness is producible than in one. This being the case, it is manifest that the legal relation which the husband will bear to the wife will be a complex one, compounded of that of master and that of guardian. The offences, then, to which the condition of a husband will be exposed will be the sum of those to which the two conditions of master and guardian are exposed. Thus far the condition of a husband, with respect to the general outlines of it, stands upon the same footing as that of a parent. But there are certain reciprocal services, which, being the main subject of the matrimonial contract, constitute the essence of the two matrimonial relations, and which neither a master nor guardian as such, nor a parent at any rate, have usually been permitted to receive. These must of course have been distinguished from the indiscriminate train of services at large which the husband in his character of master is empowered to exact, and of those which in his character of guardian he is bound to render. Being thus distinguished, the offences relative to the two conditions have, in many instances, in as far as they have reference to these peculiar services, acquired particular denominations. In the first place, with regard to the contract, from the celebration of which the legal condition dates its existence. It is obvious that in point of possibility this contract might, on the part of either sex, subsist with respect to several persons of the other sex at the same time. The husband might have any number of wives, the wife might have any number of husbands. The husband might enter into the contract with a number of wives at the same time, or, if with only one at a time, he might reserve to himself a right of engaging in a similar contract with any number, or with only such or such a number of other women afterwards, during the continuance of each former contract. This latter, accordingly, is the footing upon which, as is well known, marriage is and has been established in many extensive countries, particularly in all those which profess the Mahometan religion. In point of possibility, it is evident that the like liberty might be reserved on the part of the wife, though in point of practice no examples of such an arrangement seem ever to have occurred. Which of all these arrangements is in point of utility the most expedient is a question which would require too much discussion to answer in the course of an analytical process like the present, and which belongs indeed to the civil branch of legislation rather than to the penal. In Christian countries the solemnization of any such contract is made to exclude the solemnization of any subsequent one during the continuance of a former, and the solemnization of any such subsequent contract is accordingly treated as an offence under the name of polygamy. Polygamy, then, is at any rate on the part of the man a particular modification of that offence which may be styled usurpation of the condition of a husband. As to its other effects, they will be different, according as it was the man only, or the woman only, or both, that were in a state of matrimony at the time of the commission of the offence. If the man only, then his offence involves in it pro tanto that of wrongful divestment of the condition of a wife, in prejudice of his prior wife. If the woman only, then it involves in it pro tanto that of wrongful divestment of the condition of a husband, in prejudice of her prior husband. If both were already married, it of course involves both the wrongful divestments which have just been mentioned. And on the other hand also, the converse of all this may be observed with regard to polygamy on the part of the woman. Secondly, as the engaging not to enter into any subsequent engagement of the like kind during the continuance of the first is one of the conditions on which the law lends its sanction to the first, so another is the inserting as one of the articles of this engagement an undertaking not to render to or accept from any other person the services which form the characteristic object of it. The rendering or acceptance of any such services is accordingly treated as an offence under the name of adultery, under which name is also comprised the offence of the stranger, who, in the commission of the above offence, is the necessary accomplice. Thirdly, disturbing either of the parties to this engagement in the possession of these characteristic services may, in like manner, be distinguished from the offence of disturbing them in the enjoyment of the miscellaneous advantages derivable from the same condition. And on whichever side the blame rests, whether that of the party or that of a third person, may be termed wrongful withholding of connubial services. And thus we have 21 sorts of offences, to which, as the law stands at present in Christian countries, the condition of a husband stands exposed, viz. 1. Wrongful non-investment of the condition of a husband. 2. Wrongful interception of the condition of a husband. 3. Wrongful divestment of the condition of a husband. 4. Usurpation of the condition of a husband. 5. Polygamy. 6. Wrongful investment of the condition of a husband. 7. Wrongful abdication of the condition of a husband. 8. Wrongful detractation of the condition of a husband. 9. Wrongful imposition of the condition of a husband. 10. Mismanagement of marital guardianship. 11. Desertion of marital guardianship. 12. Dissipation in prejudice of matrimonial wardship. 13. Peculation in prejudice of matrimonial wardship. 14. Abuse of marital power. 15. Disturbance of marital guardianship. 16. Wrongful withholding of connubial services. 17. Adultery. 18. Breach of duty to husbands. 19. Elopement from husbands. 20. Wife stealing. 21. Bribery in prejudice of marital guardianship. End of chapter 6, paragraph 3, part C.
Section 25 of an Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, paragraph 3, part D. Next, with regard to the offences to which the condition of a wife stands exposed. From the patterns that have been exhibited already, the coincidence and associations that takes place between the offences that concern the existence of this condition and those which concern the existence of the condition of a husband may easily enough be apprehended without further repetitions. The catalogue of those now under consideration will be precisely the same in every article as the catalogue last exhibited. Thus much for the several sorts of offences relative to the several sorts of domestic conditions, those which are constituted by such natural relations as are contiguous being included. There remain those which are uncontiguous, of which, after so much has been said of the others, it will naturally be expected that some notice should be taken. These, however, do not afford any of that matter which is necessary to constitute a condition. In point of fact, no power seems ever to be annexed to any of them. A grandfather, perhaps, may be called by the law to take upon him the guardianship of his orphan grandson, but then the power he has belongs to him not as a grandfather, but as a guardian. In point of possibility, indeed, power might be annexed to these relations, just as it might to any other. But still no new sort of domestic condition would result from it, since it has been shown that there can be no others that, being constituted by power, shall be distinct from those which have been already mentioned. Such as they are, however, they have this in common with the before-mentioned relations, that they are capable of importing either benefit or burthen. They therefore stand exposed to the several offences whereby those or any other relations are liable to be affected in point of existence. It may be expected, therefore, that in virtue of these offences they should be added to the list of relations which are liable to be objects of delinquency. But the fact is that they already stand included in it, and although not expressly named, let as effectually as if they were. On the one hand, it is only by affecting such or such a contiguous relation that any offence affecting uncontiguous relations can take place. On the other hand, neither can any offence affecting the existence of the contiguous relations be committed without affecting the existence of an indefinite multitude of such as are uncontiguous. A false witness comes and causes it to be believed that you are the son of a woman who in truth is not your mother. What follows? An endless tribe of other false persuasions, that you are the grandson of the father and of the mother of this supposed mother, that you are the son of some husband of hers, or at least of some man with whom she has cohabited, the grandson of his father and mother, and so on, the brother of their other children, if they have any, the brother-in-law of the husbands and wives of those children, if married, the uncle of the children of those children, and so on. On the other hand, that you are not the son of your real mother, nor of your real father, that you are not the grandson of either of your real grandfathers or grandmothers, and so on without end. All which persuasions result from are included in the one original false persuasion of your being the son of this your pretended mother. It should seem, therefore, at first sight, that none of the offences against these uncontiguous relations could ever come expressly into question. For, by the same rule that one ought, so it might seem ought 1,000 others, the offences against the uncontiguous being merged, as it were, in those which affect the contiguous relations. So far, however, is this from being the case, that in speaking of an offence of this stamp, it is not uncommon to hear a great deal said of this or that uncontiguous relationship which it affects, at the same time as no notice at all shall be taken of any of those which are contiguous. How happens this? Because to the uncontiguous relation are annexed perhaps certain remarkable advantages or disadvantages, while to all the intermediate relations none shall be annexed which are a comparison worth noticing. Suppose Antony or Lepidus to have contested the relationship of Octavius, after Augustus, to Caius Julius Caesar. How could it have been done? It could only have been done by contesting either Octavius being the son of Atia, or Atia being the daughter of Julia, or Julia being the daughter of Lucius Julius Caesar, or Lucius Julius Caesar being the father of Caius. But to have been the son of Atia, or the grandson of Julia, or the great-grandson of Lucius Julius Caesar, was in comparison of small importance. These intervening relationships were, comparatively speaking, of no other use to him than in virtue of there being so many necessary links in the genealogical claim which connected him with the sovereign of the empire. As to the advantages and disadvantages which may happen to be annexed to any of these uncontiguous relationships, we have seen already that no powers over the correlative person, nor any corresponding obligations, are of the number. Of what nature then can they be? They are, in truth, no other than what are a result either of local and accidental institutions, or of some spontaneous bias that has been taken by the moral sanction. It would therefore be to little purpose to attempt tracing them out a priori by any exhaustive process. All that can be done is to pick up and lay together some of the principal articles in each catalogue by way of specimen. The advantages which a given relationship is apt to impart seem to be referable chiefly to the following heads. 1. Chance of succession to the property or a part of the property of the correlative person. 2. Chance of pecuniary support to be yielded by the correlative person, either by appointment of law or by spontaneous donation. 3. Accession of legal rank, including any legal privileges which may happen to be annexed to it, such as capacity of holding such and such beneficial offices, exemption from such and such burthensome obligations, for instance, paying taxes, serving burthensome offices, etc., etc. 4. Accession of rank by courtesy, including the sort of reputation which is customarily and spontaneously annexed to distinguish birth and family alliance, whereon may depend the chance of advancement in the way of marriage, or in 1,000 other ways less obvious. The disadvantages which a given relation is liable to impart seem to be referable chiefly to the following heads. 1. Chance of being obliged, either by law or by force of the moral sanction, to yield pecuniary support to the correlative party. 2. Loss of legal rank, including the legal disabilities, as well as the burthensome obligations which the law is apt to annex, sometimes with injustice enough, to the lower stations. 3. Loss of rank by courtesy, including the loss of the advantages annexed by custom to such rank. 4. Incapacity of contracting matrimony with the correlative person, where the supposed consanguinity or affinity lies within the prohibited degrees. We now come to civil conditions. These, it may well be imagined, may be infinitely various as the acts which a man may be either commanded or allowed, whether for his own benefit or that of others, to abstain from or to perform. As many different denominations as there are of persons distinguished with a view to such commands and allowances, those denominations only excepted which relate to the conditions above spoken of under the names of domestic one, so many civil conditions one might enumerate. Means, however, more or less explicit, may be found out of circumscribing their infinitude. What the materials are, if they so may be called, of which conditions or any other kind of legal possession can be made up, we have already seen. Beneficial powers, fiduciary powers, beneficial rights, fiduciary rights, relative duties, absolute duties. But as many conditions as import a power or right of the fiduciary kind, as possessed by the person whose condition is in question, belong to the head of trusts. The catalogue of the offences to which these conditions are exposed coincides therefore exactly with the catalogue of offences against trust, under which head they have been considered in a general point of view under the head of offences against trust, and such of them as are of a domestic nature in a more particular manner in the character of offences against the several domestic conditions. Conditions constituted by such duties of the relative kind as have for their counterpart trusts constituted by fiduciary powers, as well as rights on the side of the correlative party, and those of a private nature, have also been already discussed under the appellation of domestic conditions. The same observation may be applied to the conditions constituted by such powers of the beneficial kind over persons as of a private nature, as also to the subordinate correlative conditions constituted by the duties corresponding to those rights and powers. As to absolute duties, there is no instance of a condition thus created of which the institution is upon the principle of utility to be justified, unless the several religious conditions of the monastic kind should be allowed of as examples. There remain, as the only materials out of which the conditions which yet remain to be considered can be composed, conditions constituted by beneficial powers over things, conditions constituted by beneficial rights to things, that is, rights to power over things, or by rights to those rights, and so on, conditions constituted by rights to service, and conditions constituted by the duties corresponding to those respective rights. Out of these are to be taken those of which the materials are the ingredients of the several modifications of property, the several conditions of proprietorship. These are the conditions, if such for a moment they may be styled, which, having but here or there any specific names, are not commonly considered on the footing of conditions, so that the acts which if such conditions were recognised might be considered as offences against those conditions, are not wont to be considered in any other light than that of offences against property. Now the case is, as hath been already intimated, that of these civil conditions, those which are wont to be considered under that name are not distinguished by any uniform and explicit line from those of which the materials are wont to be carried to the head of property. A set of rights shall in one instant be considered as constituting an article of property rather than a condition, while in another instance a set of rights of the same stamp is considered as constituting rather a condition than an article of property. This will probably be found to be the case in all languages, and the usage is different again in one language from what it is in another. From these causes it seems to be impracticable to subject the class of civil conditions to any exhaustive method, so that for making a complete collection of them there seems to be no other expedient than that of searching the language through for them and taking them as they come. To exemplify this observation, it may be of use to lay open the structure, as it were, of 2 or 3 of the principal sorts or classes of conditions, comparing them with 2 or 3 articles of property which appear to be nearly of the same complexion. By this means the nature and generation, if one may so call it, of both these classes of ideal objects may be the more clearly understood. The several sorts of civil conditions that are not fiduciary may all, or at least the greater part of them, be comprehended under the head of rank, or that of profession, the latter word being taken in its most extensive sense, so as to include not only what are called the liberal professions, but those also which are exercised by the several sorts of traders, artists, manufacturers, and other persons of whatsoever station who are in the way of making a profit by their labour. Among ranks, then, as well as professions, let us, for the sake of perspicuity, take, for example, such articles as stand the clearest from any mixture of either fiduciary or beneficial power. The rank of knighthood is constituted how? By prohibiting all other persons from performing certain acts, the performance of which is the symbol of the order, at the same time that the knight in question and his companions are permitted, for instance, to wear a ribbon of a certain colour, in a certain manner, call himself by a certain title, to use an armorial seal with a certain mark on it. By laying all persons but the knight under this prohibition, the law subjects them to a set of duties, and since from the discharge of these duties a benefit results to the person in whose favour they are created, to wit, the benefit of enjoying such a share of extraordinary reputation as men are wont to yield to a person thus distinguished, to discharge them is to render him a service and duty, being a duty of the negative class, a duty consisting in the performance of certain acts of the negative kind. The service is what may be called a service of forbearance. It appears, then, that to generate this condition there must be two sorts of services: that which is the immediate cause of it, a service of the negative kind, to be rendered by the community at large; that which is the cause again of this service, a service of the positive kind, to be rendered by the law. The condition of a professional man stands upon a narrower footing. To constitute this condition there needs nothing more than a permission given him on the part of the legislator to perform those acts in the performance of which consists the exercise of his profession, to give or sell his advice or assistance in matters of law or physic, to give or sell his services as employed in the executing or overseeing of a manufacture or piece of work of such or such a kind, to sell a commodity of such or such a sort. Here then we see there is but one sort of service requisite, a service which may be merely of the negative kind, to be rendered by the law, the service of permitting him to exercise his profession, a service which, if there has been no prohibition laid on before, is rendered by simply forbearing to prohibit him. Now the ideal objects, which in the cases above specified are said to be conferred upon a man by the services that are respectively in question, are in both cases not articles of property, but conditions. By such a behaviour on the part of the law as shall be the reverse of that whereby they were respectively produced, a man may be made to forfeit them, and what he is then said to forfeit is in neither case his property, but in one case his rank or dignity, in the other case his trade or his profession, and in both cases his condition. Other cases there are again in which the law, by a process of the same sort with that by which it constituted the former of the two above-mentioned conditions, confers on him an ideal object, which the laws of language have placed under the head of property. The law permits a man to sell books, that is, all sorts of books in general. Thus far all that it has done is to invest him with a condition, and this condition he would equally possess, although every one else in the world were to sell book likewise. Let the law now take an active part in his favour, and prohibit all other persons from selling books of a certain description, he remaining at liberty to sell them as before. It therefore confers on him a sort of exclusive privilege or monopoly, which is called a copyright. But by investing him with this right, it is not said to invest him with any new sort of condition. What it invests him with is spoken of as an article of property, to wit, of that sort of property which is termed incorporeal, and so on in the case of an engraving, a mechanical engine, a medicine, or in short of a saleable article of any other sort. Yet when it gave him an exclusive right of wearing a particular sort of ribbon, the object which it then was considered as conferring on him was not an article of property, but a condition. By forbearing to subject you to certain disadvantages to which it subjects an alien, the law confers on you the condition of a natural-born subject. By subjecting him to them, it imposes on him the condition of an alien. By conferring on you certain privileges or rights, which it denies to roturiers, the law confers on you the condition of a gentilhomme. By forbearing to confer on him those privileges, it imposes on him the condition of a roturier. The rights out of which the two advantageous conditions here exemplified are both of them as it were composed, have for their counterpart a sort of service of forbearance, rendered, as we have seen, not by private individuals but by the law itself. As to the duties which it creates in rendering you these services, they are to be considered as duties imposed by the legislator on the ministers of justice. It may be observed with regard to the greater part of the conditions here comprised under the general appellation of civil, that the relations corresponding to those by which they are respectively constituted are not provided with appellatives. The relation which has a name is that which is borne by the party favoured to the party bound. That which is borne by the party bound to the party favoured has not any. This is a circumstance that may help to distinguish them from those conditions which we have termed domestic. In the domestic conditions, if on one side the party to whom the power is given is called a master, on the other side the party over whom the power is given, the party who is the object of that power, is termed a servant. In the civil conditions this is not the case. On the one side, a man, in virtue of certain services of forbearance which the rest of the community are bound to render him, is denominated a knight of such or such an order. But on the other side, these services do not bestow any particular denomination on the person for whom such services are due. Another man, in virtue of the legislator's rendering that sort of negative service which consists in the not prohibiting him from exercising a trade, invests him at his option with the condition of a trader. It accordingly denominates him a farmer, a baker, a weaver, and so on. But the ministers of the law do not, in virtue of their rendering this man this sort of negative service, acquire for themselves any particular name. Suppose even that the trade you have the right of exercising happens to be the object of a monopoly, and that the legislator, beside rendering you himself those services which you derive from the permission he bestows on you, obliges other persons to render you those farther services which you received from their forbearing to follow the same trade, yet neither do they, in virtue of their being thus bound, acquire any particular name. After what has been said of the nature of the several sorts of civil conditions that have names, the offences to which they are exposed may, without much difficulty, be imagined. Taken by itself, every condition which is thus constituted by a permission granted to the possessor is, of course, of a beneficial nature. It is therefore exposed to all those offences to which the possession of a benefit is exposed. But either on account of a man's being obliged to persevere when once engaged in it, or on account of such other obligations as may stand annexed to the possession of it, or on account of the comparative degree of disrepute which may stand annexed to it by the moral sanction, it may by accident be a burthen. It is on this account liable to stand exposed to the offences to which, as hath been seen, everything that partakes of the nature of a burthen stands exposed. As to any offences which may concern the exercise of the functions belonging to it, if it happens to have any duties annexed to it, such as those, for instance, which are constituted by regulations touching the exercise of a trade, it will stand exposed to so many breaches of duty, and lastly, whatsoever are the functions belonging to it, it will stand exposed at any rate to disturbance. In the forming, however, of the catalogue of these offences, exactness is of less consequence, insomuch as an act, if it should happen not to be comprised in this catalogue, and yet is in any respect of a pernicious nature, will be sure to be found in some other division of the system of offences. If a baker sells bad bread for the price of good, it is a kind of fraud upon the buyer, and perhaps an injury of the simple corporal kind done to the health of an individual or a neighbourhood. If a clothier sells bad cloth for good at home, it is a fraud. If to foreigners abroad, it may, over and above the fraud put upon the foreign purchaser, have pernicious effects, perhaps, in the prosperity of the trade at home, and become thereby an offence against the national wealth. So again with regard to disturbance. If a man be disturbed in the exercise of his trade, the offence will probably be a wrongful interception of the profit he might be presumed to have been in the way to make by it; and were it even to appear in any case that a man exercised a trade, or what is less unlikely, a liberal profession, without having profit in his view, the offence will still be reducible to the head of simple injurious restrainment, or simple injurious compulsion. End of chapter 16.
Chapter 16, paragraph 4 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Anna Simon. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Division of Offences. Paragraph 4. Advantages of the present method. A few words for the purpose of giving a general view of the method of division here pursued, and of the advantages which it possesses, may have their use. The whole system of offences, we may observe, is branched out into 5 classes. In the 3 first, the subordinate divisions are taken from the same source, that is, from the consideration of the different points in respect whereof the interest of an individual is exposed to suffer. By this uniformity, a considerable degree of light seems to be thrown upon the whole system, particularly upon the offences that come under the 3rd class, objects which have never hitherto been brought into any sort of order. With regard to the 4th class, in settling the precedence between its several subordinate divisions, it seemed most natural and satisfactory to place those first, the connection whereof with the welfare of individuals seemed most obvious and immediate. The mischievous effects of those offences which tend in an immediate way to deprive individuals of the protection provided for them against the attacks of one another, and of those which tend to bring down upon them the attacks of foreign assailants, seem alike obvious and palpable. The mischievous quality of such as tend to weaken the force that is provided to combat those attacks, but particularly the latter, though evident enough, is one link farther off in the chain of causes and effects. The ill effects of such offences as are of disservice only by diminishing the particular fund from whence that force is to be extracted, such effects, I say, though indisputable, are still more distant and out of sight. The same thing may be observed with regard to such as are mischievous only by affecting the universal fund. Offences against the sovereignty in general would not be mischievous if offences of the several descriptions preceding were not mischievous. Nor in a temporal view are offences against religion mischievous, except in as far as, by removing, or weakening, or misapplying one of the 3 great incentives to virtue, and checks to vice, they tend to open the door to several mischiefs, which it is the nature of all those other offences to produce. As to the 5th class, this, as hath already been observed, exhibits, at first view, an irregularity which however seems to be unavoidable. But this irregularity is presently corrected, when the analysis returns back, as it does after a step or two, into the path from which the tyranny of language had forced it a while to deviate. It was necessary that it should have 2 purposes in view: the one, to exhibit upon a scale more or less minute a systematical enumeration of the several possible modifications of delinquency, denominated or undenominated; the other, to find places in the list for such names of offences as were in current use. For the first purpose, nature was to set the law; for the other, custom. Had the nature of the things themselves been the only guide, every such difference in the manner of perpetration, and such only, should have served as a ground for a different denomination, as was attended with a difference in point of effect. This, however, of itself would never have been sufficient; for as on one hand the new language, which it would have been necessary to invent, would have been uncouth, and in a manner unintelligible, so on the other hand the names which were before in current use, and which, in spite of all systems, good or bad, must have remained in current use, would have continued unexplained. To have adhered exclusively to the current language would have been as bad on the other side, for in that case the catalogue of offences, when compared to that of the mischiefs that are capable of being produced, would have been altogether broken and incomplete. To reconcile these two objects, in as far as they seem to be reconcilable, the following course has therefore been pursued. The logical whole, constituted by the sum total of possible offences, has been bisected in as many different directions as were necessary, and the process in each direction carried down to that stage at which the particular ideas thus divided found names in current use in readiness to receive them. At that period I have stopped, leaving any minuter distinctions to be enumerated in the body of the work, as so many species of the genus characterized by such or such a name. If in the course of any such process I came to a mode of conduct which, though it required to be taken notice of, and perhaps had actually been taken notice of, under all laws, in the character of an offence, had hitherto been expressed under different laws, by different circumlocutions, without ever having received any name capable of occupying the place of a substantive in a sentence, I have frequently ventured so far as to fabricate a new name for it, such a one as the idiom of the language and the acquaintance I happen to have with it would admit of, these names consisting in most instances, and that unavoidably, of 2 or 3 words brought together, in a language too which admits not, like the German and the Greek, of their being melted into one, can never be upon a par, in point of commodiousness, with those univocal appellatives which make part of the established stock. In the choice of names in current use, care has been taken to avoid all such as have been grounded on local distinctions, ill-founded perhaps in the nation in which they received their birth, and at any rate not applicable to the circumstances of other countries. The analysis, as far as it goes, is as applicable to the legal concerns of one country as of another, and where, if it had descended into further details, it would have ceased to be so, there I have taken care always to stop, and thence it is that it has come to be so much more particular in the class of offences against individuals than in any of the other classes. One use, then, of this arrangement, if it should be found to have been properly conducted, will be its serving to point out in what it is that the legal interests of all countries agree, and in what it is that they are liable to differ, how far a rule that is proper for one will serve and how far it will not serve for another. That the legal interests of different ages and countries have nothing in common, and that they have everything, are suppositions equally distant from the truth. A natural method, such as it hath been here attempted to exhibit, seems to possess 4 capital advantages, not to mention others of inferior note. In the first place, it affords such assistance to the apprehension and to the memory as those faculties would in vain look for in any technical arrangement. That arrangement of the objects of any science may, it should seem, be termed a natural one, which takes such properties to characterize them by, as men in general are, by the common constitution of man's nature, independently of any accidental impressions they may have received from the influence of any local or other particular causes, accustomed to attend to; such, in a word, as naturally, that is, readily and at first sight, engage and firmly fix the attention of any one to whom they have once been pointed out. Now, by what other means should an object engage or fix a man's attention, unless by interesting him? And what circumstance belonging to any action can be more interesting, or rather what other circumstance belonging to it can be at all interesting to him, than that of the influence it promises to have on his own happiness, and the happiness of those who are about him? By what other mark, then, should he more easily find the place which any offence occupies in the system, or by what other clue should he more readily recall it? In the next place, it not only gives at first glance a general intimation of the nature of each division of offences, in as far as that nature is determined by some one characteristic property, but it gives room for a number of general propositions to be formed concerning the particular offences that come under that division, in such manner as to exhibit a variety of other properties that may belong to them in common. It gives room, therefore, for the framing of a number of propositions concerning them, which, though very general, because predicated of a great number of articles, shall be as generally true. In the third place, it is so contrived that the very place which any offence is made to occupy suggests the reason of its being put there. It serves to indicate not only that such and such acts are made offences, but why they ought to be. By this means, while it addresses itself to the understanding, it recommends itself in some measure to the affections. By the intimation it gives of the nature and tendency of each obnoxious act, it accounts for, and in some measure vindicates, the treatment which it may be thought proper to bestow upon that act in the way of punishment. To the subject then it is a kind of perpetual apology, showing the necessity of every defalcation which, for the security and prosperity of each individual, it is requisite to make from the liberty of every other. To the legislator it is a kind of perpetual lesson, serving at once as a corrective to his prejudices and as a check upon his passions. Is there a mischief which has escaped him? In a natural arrangement, if at the same time an exhaustive one, he cannot fail to find it. Is he tempted ever to force innocence within the pale of guilt? The difficulty of finding a place for it advertises him of his error. Such are the uses of a map of universal delinquency, laid down upon the principle of utility. Such the advantages which the legislator as well as the subject may derive from it. Abide by it, and everything that is arbitrary in legislation vanishes. An evil-intentioned or prejudiced legislator dares not look it in the face. He would proscribe it, and with reason. It would be a satire on his laws. In the fourth place, a natural arrangement, governed as it is by a principle which is recognized by all men, will serve alike for the jurisprudence of all nations. In a system of proposed law, framed in pursuance of such a method, the language will serve as a glossary by which all systems of positive law might be explained, while the matter serves as a standard by which they might be tried. Thus illustrated, the practice of every nation might be a lesson to every other, and mankind might carry on a mutual interchange of experiences and improvements as easily in this as in every other walk of science. If any one of these objects should in any degree be attained, the labour of this analysis, severe as it has been, will not have been thrown away. End of Chapter 16, Paragraph 4.
Chapter 16 of an Introduction to the Principles of Morals and Legislation. This is LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by May Lowe. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Section 5. Characters of the Five Classes. It has been mentioned, as an advantage possessed by this method, and not possessed by any other, that the objects comprised under it are cast into groups, to which a variety of propositions may be applied in common. A collection of these propositions, as applied to the several classes, may be considered as exhibiting the distinctive characters of each class. So many of these propositions, as can be applied to the offences belonging to any given class, so many properties are they found to have in common. So many of these common properties as may respectively be attributed to them, so many properties may be set down to serve as characters of the class. A collection of these characters it may here be proper to exhibit. The more of them we can bring together, the more clearly and fully will the nature of the several classes and of the offences they are composed of be understood. Characters of Class 1, composed of private offences, or offences against assignable individuals. 1. When arrived at their last stage, the stage of consummation, they produce, all of them, a primary mischief as well as a secondary. 2. The individuals whom they affect in the first instance are constantly assignable. This extends to all, to attempts and preparations, as well as to such as have arrived at the stage of consummation. 3. Consequently, they admit of compensation, in which they differ from the offences of all the other classes as such. 4. They admit also of retaliation, in which they also differ from the offences of all the other classes. 5. There is always some person who has a natural and peculiar interest to prosecute them. In this they differ from self-regarding offences, also from semi-public and public ones, except in as far as the two latter may chance to involve a private mischief. 6. The mischief they produce is obvious, more so than that of semi-public offences, and still more so than that of self-regarding ones, or even public. 7. They are everywhere, and must ever be, obnoxious to the censure of the world, more so than semi-public offences as such, and still more so than public ones. 8. They are more constantly obnoxious to the censure of the world than self-regarding offences, and would be so universally, were it not for the influence of the two false principles, the principle of asceticism and the principle of antipathy. 9. They are less apt than the semi-public and public offences to require different descriptions in different states and countries, in which respect they are much upon a par with self-regarding ones. 10. By certain circumstances of aggravation, they are liable to be transformed into semi-public offences, and by certain others into public. 11. There can be no ground for punishing them until they can be proved to have occasioned, or to be about to occasion, some particular mischief to some particular individual. In this, they differ from semi-public offences and from public. 12. In slight cases, compensation given to the individual affected by them may be a sufficient ground for remitting punishment. For if the primary mischief has not been sufficient to produce any alarm, the whole of the mischief may be cured by compensation. In this also they differ from semi-public offences and from public ones. Characters of class 2, composed of semi-public offences, or offences affecting a whole subordinate class of persons. 1. As such, they produce no primary mischief. The mischief they produce consists of one or other or both branches of the secondary mischief produced by offences against individuals, without the primary. 2. In as far as they are able to be considered as belonging to this class, the persons whom they affect in the first instance are not individually assignable. 3. They are apt, however, to involve or terminate in some primary mischief of the first order, which, when they do, they advance into the first class and become private offences. 4. They admit not, as such, of compensation. 5. Nor of retaliation. 6. As such, there is never any one particular individual whose exclusive interest it is to prosecute them. A circle of persons may, however, always be marked out, within which may be found some who have a greater interest to prosecute than any who are out of that circle have. 7. The mischief they produce is in general pretty obvious, not so much so indeed as that of private offences, but more so upon the whole than that of self-regarding and public ones. 8. They are rather less obnoxious to the censure of the world than private offences, but they are more so than public ones. They would also be more so than self-regarding ones, were it not for the influence of the two false principles, the principle of sympathy and antipathy, and that of asceticism. 9. They are more apt than private and self-regarding offences to require different descriptions in different countries, but less so than public ones. 10. There may be ground for punishing them before they have been proved to have occasioned, or be about to occasion, mischief to any particular individual, which is not the case with private offences. 11. In no cases can satisfaction given to any particular individual affected by them be a sufficient ground for remitting punishment, for, by such satisfaction, it is but a part of the mischief of them that is cured. In this they differ from private offences, but agree with public. Characters of class 3, consisting of self-regarding offences, offences against oneself. 1. In individual instances, it will often be questionable whether they are productive of any primary mischief at all. Secondary, they produce none. 2. They affect not any other individuals, assignable or non-assignable, except in as far as they affect the offender himself, unless by possibility in particular cases, and in a very slight and distant manner, the whole state. 3. They admit not, therefore, of compensation. 4. Nor of retaliation. 5. No person has naturally any peculiar interest to prosecute them, except in as far as in virtue of some connection he may have with the offender, either in point of sympathy or of interest, a mischief of the derivative kind may happen to devolve upon him. 6. The mischief they produce is apt to be unobvious and in general more questionable than that of any of the other classes. 7. They are, however, apt, many of them, to be more obnoxious to the censure of the world than public offences, owing to the influence of the two false principles, the principle of asceticism and the principle of antipathy. Some of them more even than semi-public or even than private offence. 8. They are less apt than offences of any other class to require different descriptions in different states and countries. 9. Among the inducements to punish them, antipathy against the offender is apt to have a greater share than sympathy for the public. 10. The best plea for punishing them is founded on a faint probability there may be, of their being productive of a mischief, which, if real, will place them in the class of public ones, chiefly in those divisions of it which are composed of offences against population and offences against national wealth. Characters of class 4, consisting of public offences, or offences against the state in general. 1. As such, they produce not any primary mischief, and the secondary mischief they produce, which consists frequently of danger without alarm, though great in value, is in specie very indeterminate. 2. The individuals whom they affect in the first instance are constantly unassignable, except in as far as by accident they happen to involve or terminate in such or such offences against individuals. 3. Consequently, they admit not of compensation. 4. Nor of retaliation. 5. Nor is there any person who has naturally any particular interest to prosecute them, except in as far as they appear to affect the power, or, in any other manner the private interest, of some person in authority. 6. The mischief they produce, as such, is comparatively unobvious, much more so than that of private offences, and more so likewise than that of semi-public ones. 7. They are, as such, much less obnoxious to the censure of the world than private offences, less even than semi-public or even than self-regarding offences, unless in particular cases, through sympathy to certain persons in authority, whose private interests they may appear to affect. 8. They are more apt than any of the other classes to admit of different descriptions in different states and countries. 9. They are constituted, in many cases, by some circumstances of aggravation superadded to a private offence, and therefore, in these cases, involve the mischief and exhibit the other characters belonging to both classes. They are, however, even in such cases, properly enough ranked in the fourth class, inasmuch as the mischief they produce in virtue of the properties which aggregate them to that class, eclipses and swallows up that which they produce in virtue of those properties which aggregate them to the first. 10. There may be sufficient ground for punishing them, without their being proved to have occasioned, or to be about to occasion, any particular mischief to any particular individual. In this they differ from private offences, but agree with semi-public ones. Here, as in semi-public offences, the extent of the mischief makes up for the uncertainty of it. 11. In no case can satisfaction given to any particular individual affected by them be a sufficient ground for remitting punishment. In this they differ from private offences, but agree with semi-public. Characters of class 5, or appendix, composed of multiform or anomalous offences, and containing offences by falsehood and offences concerning trust. 1. Taken collectively, in the parcels marked out by their popular appellations, they are incapable of being aggregated to any systematical method of distribution grounded upon the mischief of the offence. 2. They may, however, be thrown into subdivisions, which may be aggregated to such a method of distribution. 3. These subdivisions will naturally and readily rank under the divisions of the several preceding classes of this system. 4. Each of the two great divisions of this class spreads itself in that manner over all the preceding classes. 5. In some acts of this class, the distinguishing circumstance, which constitutes the essential character of that offence, will, in some instances, enter necessarily, in the character of a criminative circumstance, into the constitution of the offence, insomuch that, without the intervention of this circumstance, no offence at all of that denomination can be committed. In other instances, the offence may subsist without it, and where it interferes, it comes in as an accidental independent circumstance, capable of constituting a ground of aggravation. End of chapter 16. Chapter 17 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by May Lowe. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 17 of the Limits of the Penal Branch of Jurisprudence. Section 1. Limits between private ethics and the art of legislation. So much for the division of offences in general. Now an offence is an act prohibited, or, what comes to the same thing, an act of which the contrary is commanded by the law. And what is it that the law can be employed in doing, besides prohibiting and commanding? It should seem, then, according to this view of the matter, that were we to have settled what may be proper to be done with relation to offences, we should thereby have settled everything that may be proper to be done in the way of law. Yet that branch which concerns the method of dealing with offences, and which is termed sometimes the criminal, sometimes the penal branch, is universally understood to be but one out of two branches which compose the whole subject of the art of legislation, that which is termed the civil being the other. Between these two branches, then, it is evident enough there cannot but be a very intimate connection. So intimate is it, indeed, that the limits between them are by no means easy to mark out. The case is the same in some degree between the whole business of legislation, civil and penal branches taken together, and that of private ethics. Of these several limits, however, it will be, in a manner, necessary to exhibit some idea, lest, on the one hand, we should seem to leave out any part of the subject that does belong to as untouched, or, on the other hand, to deviate on any side into a track which does not belong to us. In the course of this inquiry, that part of it, I mean, which concerns the limits between the civil and the penal branch of law, it will be necessary to settle a number of points, of which the connection with the main question might not at first sight be suspected. To ascertain what sort of a thing a law is, what the parts are that are to be found in it, what it must contain in order to be complete, what the connection is between that part of a body of laws which belongs to the subject of procedure and the rest of the law at large, all these, it will be seen, are so many problems which must be solved before any satisfactory answer can be given to the main question above mentioned. Nor is this their only use, for it is evident enough that the notion of a complete law must first be fixed before the legislator can, in any case, know what it is he has to do, or when his work is done. Ethics at large may be defined the art of directing men's actions to the production of the greatest possible quantity of happiness on the part of those whose interest is in view. What, then, are the actions which it can be in a man's power to direct? They must be either his own actions or those of other agents. Ethics, in as far as it is the art of directing a man's own actions, may be styled the art of self-government, or private ethics. What other agents, then, are there, which, at the same time that they are under the influence of man's direction, are susceptible of happiness? They are of two sorts. One, other human beings who are styled persons. Two, other animals, which, on account of their interests having been neglected by the insensibility of the ancient jurists, stand degraded into the class of things. As to other human beings, the art of directing their actions to the above end is what we mean, or at least the only thing which, upon the principle of utility, we ought to mean by the art of government, which, in as far as the measures it displays itself in are of a permanent nature, is generally distinguished by the name of legislation, as it is by that of administration when they are of a temporary nature, determined by the occurrences of the day. Now human creatures, considered with respect to the maturity of their faculties, are either in an adult or in a non-adult state. The art of government, in as far as it concerns the direction of the actions of persons in a non-adult state, may be termed the art of education. In as far as this business is entrusted with those who, in virtue of some private relationship, are in the main the best disposed to take upon them and the best able to discharge this office, it may be termed the art of private education. In as far as it is exercised by those whose province it is to superintend the conduct of the whole community, it may be termed the art of public education. As to ethics in general, a man's happiness will depend, in the first place, upon such parts of his behaviour as none but himself are interested in. In the next place, upon such parts of it as may affect the happiness of those about him. In as far as his happiness depends upon the first mentioned part of his behaviour, it is said to depend upon his duty to himself. Ethics, then, in as far as it is the art of directing a man's actions in this respect, may be termed the art of discharging one's duty to one's self, and the quality which a man manifests by the discharge of this branch of duty, if duty it is to be called, is that of prudence. In as far as his happiness, and that of any other person or persons whose interests are considered, depends upon such parts of his behaviour as may affect the interests of those about him, it may be said to depend upon his duty to others, or, to use a phrase now somewhat antiquated, his duty to his neighbour. Ethics, then, in as far as it is the art of directing a man's actions in this respect, may be termed the art of discharging one's duty to one's neighbour. Now the happiness of one's neighbour may be consulted in two ways. One, in a negative way, by forbearing to diminish it. Two, in a positive way, by studying to increase it. A man's duty to his neighbour is accordingly partly negative and partly positive. To discharge the negative branch of it is probity. To discharge the positive branch, beneficence. It may here be asked, how is it that upon the principle of private ethics, legislation and religion out of the question, A man's happiness depends upon such parts of his conduct as affect, immediately at least, the happiness of no one but himself. This is as much to ask, what motives, independent of such as legislation and religion may chance to furnish, can one man have to consult the happiness of another, by what motives, or, which comes to the same thing, by what obligations can he be bound to obey the dictates of probity and beneficence? In answer to this, it cannot but be admitted that the only interests which a man at all times and upon all occasions is sure to find adequate motives for consulting are his own. Notwithstanding this, there are no occasions in which a man has not some motives for consulting the happiness of other men. In the first place, he has, on all occasions, the purely social motive of sympathy or benevolence. In the next place, he has, on most occasions, the semi-social motives of love of amity and love of reputation. The motive of sympathy will act upon him with more or less effect, according to the bias of his sensibility. The two other motives, according to a variety of circumstances, principally according to the strength of his intellectual powers, the firmness and steadiness of his mind, the quantum of his moral sensibility, and the characters of the people he has to deal with. Now private ethics has happiness for its end, and legislation can have no other. Private ethics concerns every member, that is, the happiness and actions of every member, of any community that can be proposed, and legislation can concern no more. Thus far, then, private ethics and the art of legislation go hand in hand. The end they have, or ought to have, in view, is of the same nature. The persons whose happiness they ought to have in view, as also the persons whose conduct they ought to be occupied in directing, are precisely the same. The very acts they ought to be conversant about are even in a great measure the same. Where then lies the difference? In that the acts which they ought to be conversant about, though in a great measure, are not perfectly and throughout the same. There is no case in which a private man ought not to direct his own conduct to the production of his own happiness, and that of his fellow creatures. But there are cases in which the legislator ought not, in a direct way at least, and by means of punishment applied immediately to particular individual acts, to attempt to direct the conduct of the several other members of the community. Every act which promises to be beneficial upon the whole to the community, himself included, each individual ought to perform of himself. But it is not every such act that the legislator ought to compel him to perform. Every act which promises to be pernicious upon the whole to the community, himself included, each individual ought to abstain from of him. But it is not every such act that the legislator ought to compel him to abstain from. Where then is the line to be drawn? We shall have not far to seek for it. The business is to give an idea of the cases in which ethics ought, and in which legislation ought not, in a direct manner at least, to interfere. If legislation interferes in a direct manner, it must be by punishment. Now the cases in which punishment, meaning the punishment of the political sanction, ought not to be inflicted, have been already stated. If then there be any of these cases in which, although legislation ought not, private ethics does or ought to interfere, these cases will serve to point out the limits between the two arts or branches of science. These cases, it may be remembered, are of four sorts. 1, where punishment would be groundless. 2, where it would be inefficacious. 3, where it would be unprofitable. 4, where it would be needless. Let us look over all these cases, and see whether in any of them there is room for the interference of private ethics, at the same time that there is none for the direct interference of legislation. 1. First, then, as to the cases where punishment would be groundless. In these cases it is evident that the restrictive interference of ethics would be groundless too. It is because, upon the whole, there is no evil in the act that legislation ought not to endeavour to prevent it. No more, for the same reason, ought private ethics. 2. As to the cases in which punishment would be inefficacious, these, we may observe, may be divided into two sets or classes. The first do not depend at all upon the nature of the act. They turn only upon a defect in the timing of the punishment. The punishment in question is no more than what, for anything that appears, ought to have been applied to the act in question. It ought, however, to have been applied at a different time. Videlicet, not till after it had been properly denounced. These are cases of an ex post facto law, of a judicial sentence beyond the law, and of a law not sufficiently promulgated. The acts here in question then might, for anything that appears, come properly under the department even of coercive legislation. Of course do they under that of private ethics. As to the other set of cases in which punishment would be inefficacious, neither do these depend upon the nature of the act, that is, the sort of act, they turn only upon some extraneous circumstances with which an act of any sort may chance to be accompanied. These, however, are of such a nature as not only to exclude the application of legal punishment, but in general to leave little room for the influence of private ethics. These are the cases where the will could not be deterred from any act, even by the extraordinary force of artificial punishment, as in the cases of extreme infancy, insanity, and perfect intoxication. Of course, therefore, it could not by such slender and precarious force as could be applied by private ethics. The case is in this respect the same, under the circumstances of unintentionality, with respect to the event of the action, unconsciousness with regard to the circumstances, and missupposal with regard to the existence of circumstances which have not existed, as also where the force, even of extraordinary punishment, is rendered inoperative by the superior force of a physical danger or threatened mischief. It is evident that in these cases, if the thunders of the law prove impotent, the whispers of simple morality can have but little influence. 3. As to the cases where punishment would be unprofitable. These are the cases which constitute the great field for the exclusive interference of private ethics. When a punishment is unprofitable, or in other words too expensive, it is because the evil of the punishment exceeds that of the offence. Now the evil of the punishment, we may remember, is distinguishable into 4 branches. 1. The evil of coercion, including constraint or restraint, according as the act commanded is of the positive kind or the negative. 2. The evil of apprehension. 3. The evil of sufferance. 4. The derivative evils resulting to persons in connection with those by whom the 3 above-mentioned original evils are sustained. Now with respect to those original evils, the persons who lie exposed to them may be 2 very different sets of persons. In the first place, persons who may have actually committed or been prompted to commit the acts really meant to be prohibited. In the next place, persons who may have performed or been prompted to perform such other acts as they fear may be in danger of being involved in the punishment designed only for the former. But of these 2 sets of acts, it is the former only that are pernicious. It is, therefore, the former only that it can be the business of private ethics to endeavour to prevent. The latter, being by the supposition not mischievous, to prevent them is what it can no more be the business of ethics to endeavour at than of legislation. It remains to show how it may happen that there should be acts really pernicious, which, although they may very properly come under the censure of private ethics, may yet be no fit objects for the legislator to control. Punishment, then, as applied to delinquency, may be unprofitable in both or either of 2 ways. 1. By the expense it would amount to, even supposing the application of it to be confined altogether to delinquency, 2. By the danger there may be of its involving the innocent in the fate designed only for the guilty. First, then, with regard to the cases in which the expense of the punishment, as applied to the guilty, would outweigh the profit to be made by it. These cases, it is evident, depend upon a certain proportion between the evil of the punishment and the evil of the offence. Now were the offence of such a nature that a punishment which, in point of magnitude, should but just exceed the profit of it, would be sufficient to prevent it, it might be rather difficult, perhaps, to find an instance in which such punishment would clearly appear to be unprofitable. But the fact is that there are many cases in which a punishment, in order to have any chance of being efficacious, must, in point of magnitude, be raised a great deal above that level. Thus it is, wherever the danger of detection is, or, what comes to the same thing, is likely to appear to be so small as to make the punishment appear in a high degree uncertain. In this case, it is necessary, as has been shown, if punishment be at all applied, to raise it in point of magnitude as much as it falls short in point of certainty. It is evident, however, that all this can be but guesswork, and that the effect of such a proportion will be rendered precarious by a variety of circumstances, by the want of sufficient promulgation on the part of the law, by the particular circumstances of the temptation, and by the circumstances influencing the sensibility of the several individuals who are exposed to it. Let the seducing motives be strong, the offence, then, will at any rate be frequently committed. Now and then, indeed, owing to a coincidence of circumstances more or less extraordinary, it will be detected, and by that means punished. But for the purpose of example, which is the principal one, an act of punishment considered in itself is of no use. What use it can be of depends altogether upon the expectation it raises of similar punishment in future cases of similar delinquency. But this future punishment, it is evident, must always depend upon detection. If, then, the want of detection is such as must in general, especially to eyes fascinated by the force of the seducing motives, appear too improbable to be reckoned upon, the punishment, though it should be inflicted, may come to be of no use. Here, then, will be two opposite evils running on at the same time, yet neither of them reducing the quantum of the other, the evil of the disease and the evil of the painful and inefficacious remedy. It seems to be partly owing to some such considerations that fornication, for example, or the illicit commerce between the sexes, has commonly either gone altogether unpunished, or been punished in a degree inferior to that in which, on other accounts, legislators might have been disposed to punish it. Secondly, with regard to the cases in which political punishment, as applied to delinquency, may be unprofitable, in virtue of the danger that there may be of its involving the innocent in the fate designed only for the guilty. Whence should this danger then arise? From the difficulty there may be of fixing the idea of the guilty action, that is, of subjecting it to such a definition as shall be clear and precise enough to guard effectively against misapplication. This difficulty may arise from either of two sources, the one permanent, to wit, the nature of the actions themselves, the other occasional, I mean the qualities of the men who may have to deal with those actions in the way of government. In as far as it arises from the latter of these sources, it may depend partly upon the use which the legislator may be able to make of language, partly upon the use which, according to the apprehension of the legislators, the judge may be disposed to make of it. As far as legislation is concerned, it will depend upon the degree of perfecting to which the arts of language may have been carried, in the first place, in the nation in general, in the next place, by the legislator in particular. It is to a sense of this difficulty, as it should seem, that we may attribute the caution with which most legislators have abstained from subjecting to censure, on the part of the law, such actions as come under the notion of rudeness, for example, or treachery, or ingratitude. The attempt to bring acts of so vague and questionable a nature under the control of law, will argue either a very immature age, in which the difficulties which give birth to that danger are not described, or a very enlightened age, in which they are overcome. For the sake of obtaining the clearer idea of the limits between the art of legislation and private ethics, it may now be time to call to mind the distinctions above established with regard to ethics in general. The degree in which private ethics stands in need of the assistance of legislation is different in the three branches of duty above distinguished. Of the rules of moral duty, those which seem to stand least in need of the assistance of legislation are the rules of prudence. It can only be through some defect on the part of the understanding if a man be ever deficient in point of duty to himself. If he does wrong, there is nothing else that it can be owing to but either some inadvertence or some missupposal with regard to the circumstances on which his happiness depends. It is a standing topic of complaint that a man knows too little of himself. Be it so, but is it so certain that the legislator must know more? It is plain that of individuals the legislator can know nothing. Concerning those points of conduct which depend upon the particular circumstances of each individual, it is plain, therefore, that he can determine nothing to advantage. It is only with respect to those broad lines of conduct in which all persons, or very large and permanent descriptions of persons, may be in a way to engage, that he can have any pretence for interfering. And even here, the propriety of his interference will, in most circumstances, lie very open to dispute. At any rate, he must never expect to produce a perfect compliance by the mere force of the sanction of which he is himself the author. All he can hope to do is to increase the efficacy of private ethics by giving strength and direction to the influence of the moral sanction. With what chance of success, for example, would a legislator go about to extirpate drunkenness and fornication by dint of legal punishment? Not all the tortures which ingenuity could invent would compass it, and, before he had made any progress worth regarding, such a mass of evil would be produced by the punishment as would exceed 1,000-fold the utmost possible mischief of the offence. The great difficulty would be in procuring evidence, an object which could not be attempted with any probability of success, without spreading dismay through every family, tearing the bonds of sympathy asunder, and rooting out the influence of all the social motives. All he can do, then, against offences of this nature, with any prospect of advantage in the way of direct legislation, is to subject them, in cases of notoriety, to a slight censure, so as to thereby cover them with a slight shade of artificial disrepute. It may be observed that with regard to this branch of duty, legislators have, in general, been disposed to carry their interference full as far as is expedient. The great difficulty here is to persuade them to confine themselves within bounds. 1,000 little passions and prejudices have led them to narrow the liberty of the subject in this line, in cases in which the punishment is either attended with no profit at all, or with none that will make up for the expense. The mischief of this sort of interference is more particularly conspicuous in the article of religion. The reasoning in this case is of the following stamp. There are certain errors, in matters of belief, to which all mankind are prone, and for these errors in judgment, it is the determination of a being of infinite benevolence to punish them with an infinity of torments. But from these errors the legislator himself is necessarily free, for the men who happen to be at hand for him to consult with, being men perfectly enlightened, unfettered, and unbiased, have such advantages over all the rest of the world, that when they sit down to inquire out the truth relative to points so plain and so familiar as those in question, they cannot fail to find it. This being the case, when the sovereign sees his people ready to plunge headlong into an abyss of fire, shall he not stretch out a hand to save them? Such, for example, seems to have been the train of reasoning, and such the motives, which led Louis XIV into those coercive measures which he took for the conversion of heretics and the confirmation of true believers. The groundwork, pure sympathy and loving kindness; the superstructure, all the miseries which the most determined malevolence could have devised. But of this more fully in another place. The rules of probity are those which in point of expediency stand most in need of assistance on the part of the legislator, and in which, in point of fact, his interference has been most extensive. There are few cases in which it would be expedient to punish a man for hurting himself, but there are few cases, if any, in which it would not be expedient to punish a man for injuring his neighbour. With regard to that branch of probity which is opposed to offences against property, private ethics depends in a manner for its very existence upon legislation. Legislation must first determine what things are to be regarded as each man's property, before the general rule of ethics on this head can have any particular application. The case is the same with regard to offences against the state. Without legislation, there would be no such thing as a state, no particular persons invested with powers to be exercised for the benefit of the rest. It is plain, therefore, that in this branch the interference of the legislator cannot anywhere be dispensed with. We must first know what are the dictates of legislation before we can know what are the dictates of private ethics. As to the rules of beneficence, these, as far as concerns matters of detail, must necessarily be abandoned in great measure to the jurisdiction of private ethics. In many cases, the beneficial quality of the act depends essentially upon the disposition of the agent, that is, upon the motive by which he appears to have been prompted to perform it, upon their belonging to the head of sympathy, love of amity, or love of reputation, and not to any head of self-regarding motives brought into play by the force of political constraint. In a word, upon their being such as denominate his conduct free and voluntary, according to one of the many senses given to those ambiguous expressions. The limits of the law on this head seem, however, to be capable of being extended a good deal farther than they seem ever to have been extended hitherto. In particular, in cases where the person is in danger, why should it not be made the duty of every man to save another from mischief, when it can be done without prejudicing himself, as well as to abstain from bringing it on him? This, accordingly, is the idea pursued in the body of the work. To conclude this section, let us recapitulate, and bring to a point the difference between private ethics, considered as an art or science on the one hand, and that branch of jurisprudence which contains the art or science of legislation on the other. Private ethics teaches how each man may dispose himself to pursue the course most conducive to his own happiness, by means of such motives as offer of themselves. The art of legislation, which may be considered as one branch of the science of jurisprudence, teaches how a multitude of men, composing a community, may be disposed to pursue that course which upon the whole is the most conducive to the happiness of the whole community, by means of motives to be applied by the legislator. We come now to exhibit the limits between penal and civil jurisprudence. For this purpose it may be of use to give a distinct though summary view of the principal branches into which jurisprudence, considered in its utmost extent, is wont to be divided. Section 2. Jurisprudence, its branches. Jurisprudence is a fictitious entity, nor can any meaning be found for the word but by placing it in company with some word that shall be significative of a real entity. To know what is meant by jurisprudence, we must know, for example, what is meant by a book of jurisprudence. A book of jurisprudence can have but one or the other of two objects: one, to ascertain what the law is; two, to ascertain what it ought to be. In the former case, it may be styled a book of expository jurisprudence; in the latter, a book of censorial jurisprudence, or, in other words, a book on the art of legislation. A book of expository jurisprudence is either authoritative or unauthoritative. It is styled authoritative when it is composed by him who, by representing the state of the law to be so and so, causeth it so to be, that is, of the legislator himself; unauthoritative when it is the work of any other person at large. Now law, or the law, taken indefinitely, is an abstract and collective term, which, when it means anything, can mean neither more nor less than the sum total of a number of individual laws taken together. It follows that of whatever other modifications the subject of a book of jurisprudence is susceptible, they must all of them be taken from some circumstance or other of which such individual laws or the assemblages into which they may be sorted are susceptible. The circumstances that have given rise to the principal branches of jurisprudence we are wont to hear of seem to be as follows: 1. The extent of the laws in question in point of dominion. 2. The political quality of the persons whose conduct they undertake to regulate. 3. The time of their being in force. 4. The manner in which they are expressed. 5. The concern which they have with the article of punishment. In the first place, in point of extent, what is delivered concerning the laws in question may have reference either to the laws of such and such a nation, or nations in particular, or to the laws of all nations whatsoever. In the first case, the book may be said to relate to local, in the other to universal jurisprudence. Now of the infinite variety of nations there are upon the earth, there are no two which agree exactly in their laws, certainly not in the whole, perhaps not even in any single article. And let them agree today, they would disagree tomorrow. This is evident enough with regard to the substance of the laws, and it would still be more extraordinary if they agreed in point of form, that is, if they were conceived in precisely the same strings of words. What is more, as the languages of nations are commonly different as well as their laws, it is seldom that, strictly speaking, they have so much as a single word in common. However, among the words that are appropriated to the subject of law, there are some that in all languages are pretty exactly correspondent to one another, which comes to the same thing nearly as if they were the same. Of this stamp, for example, are those which correspond to the words power, right, obligation, liberty, and many others. It follows that if there are any books which can, properly speaking, be styled books of universal jurisprudence, they must be looked for within very narrow limits. Among such as are expository, there can be none that are authoritative, nor even, as far as the substance of the laws is concerned, any that are unauthoritative. To be susceptible of an universal application, all that a book of the expository kind can have to treat of is the import of words. To be, strictly speaking, universal, it must confine itself to terminology. Accordingly, the definitions which there has been occasion here and there to intersperse in the course of the present work, and particularly the definition hereafter given to the word law, may be considered as matter belonging to the head of universal jurisprudence. Thus far in strictness of speech, though in point of usage where a man, in laying down what he apprehends to be the law, extends his view to a few of the nations with which his own is most connected, it is common enough to consider what he writes as relating to universal jurisprudence. It is in the sensorial line that there is the greatest room for disquisitions that apply to the circumstances of all nations alike, and in this line, what regards the substance of the laws in question is as susceptible of an universal application as what regards the words. That the laws of all nations, or even of any two nations, should coincide in all points, would be as ineligible as it is impossible. Some leading points, however, there seem to be, in respect of which the laws of all civilized nations might, without inconvenience, be the same. To mark out some of these points will, as far as it goes, be the business of the body of this work. In the second place, with regard to the political quality of the persons whose conduct is the object of the law, these may, on any given occasion, be considered as either members of the same state, or as members of different states. In the first case, the law may be referred to the head of internal, in the second case, to that of international jurisprudence. Now as to any transactions which may take place between individuals who are subjects of different states, these are regulated by internal laws, and decided upon by the internal tribunals of the one or the other of those states. The case is the same where the sovereign of the one has any immediate transactions with a private member of the other, the sovereign reducing himself, pro re nata, to the condition of a private person, as often as he submits his cause to either tribunal, whether by claiming a benefit or defending himself against a burden. There remain then the mutual transactions between sovereigns, as such, for the subject of that branch of jurisprudence which may be properly and exclusively termed international. With what degree of propriety rules for the conduct of persons of this description can come under the appellation of laws, is a question that must rest till the nature of the thing called a law shall have been more particularly unfolded. It is evident enough that international jurisprudence may, as well as internal, be censorial as well as expository, unauthoritative as well as authoritative. Internal jurisprudence, again, may either concern all the members of a state indiscriminately, or such of them as are connected in the way of residence or otherwise with a particular district. Jurisprudence is accordingly sometimes distinguished into national and provincial, but as the epithet provincial is hardly applicable to a district so small as many of those which have laws of their own are wont to be, such as towns, parishes, and manors, the term local, where universal jurisprudence is plainly out of the question, or the term particular, though this latter is not very characteristic, might either of them be more commodious. Thirdly, with respect to time. In a work of the expository kind, the laws that are in question may either be such as are still in force at the time when the book is writing, or such as have ceased to be in force. In the latter case, the subject of it might be termed ancient, in the former, present or living jurisprudence. That is, if the substantive jurisprudence, and no other, must at any rate be employed, and that with an epithet in both cases. But the truth is that a book of the former kind is rather a book of history than a book of jurisprudence, and if the word jurisprudence be expressive of the subject, it is only with some such words as history or antiquities prefixed. And as the laws which are anywhere in question are supposed, if nothing appears to the contrary, to be those which are in force, no such epithet as that of present or living commonly appears. Where a book is so circumstanced that the laws from which the subject of it, though in force at the time of its being written, are in force no longer, that book is neither a book of living jurisprudence nor a book on the history of jurisprudence. It is no longer the former, and it was never the latter. It is evident that, owing to the changes which from time to time must take place, in a greater or less degree, in every body of laws, every book of jurisprudence, which is of an expository nature, must in the course of a few years come to partake more or less of this condition. The most common and most useful object of a history of jurisprudence is to exhibit the circumstances that have attended the establishment of laws actually in force, but the exposition of the dead laws which have been superseded is inseparably interwoven with that of the living ones which have superseded them. The great use of both these branches of science is to furnish examples for the art of legislation. Fourthly, in point of expression, the laws in question may subsist either in the form of statute or in that of customary law. As to the difference between these two branches, which respects only the article of form or expression, it cannot properly be made appear till some progress has been made in the definition of a law. Lastly, the most intricate distinction of all, and that which comes most frequently on the carpet, is that which is made between the civil branch of jurisprudence and the penal, which latter is wont, in certain circumstances, to receive the name of criminal. What is a penal code of laws? What is a civil code? Of what nature are their contents? Is it that there are two sorts of laws, the one penal, the other civil, so that the laws in a penal code are all penal laws, while the laws in a civil code are all civil laws? Or is it that in every law there is some matter which is of a penal nature, and which therefore belongs to the penal code, and at the same time other matter which is of a civil nature, and which therefore belongs to the civil code? Or is it that some laws belong to one code or the other exclusively, while others are divided between the two? To answer these questions in any manner that shall be tolerably satisfactory, it will be necessary to ascertain what a law is, meaning one entire but single law, and what are the parts into which a law, as such, is capable of being distinguished, or, in other words, to ascertain what the properties are that are to be found in every object which can with propriety receive the appellation of a law. This, then, will be the business of the third and fourth sections. What concerns the import of the word criminal, as applied to law, will be discussed separately in the fifth. Footnote 27. Here ends the original work, in the state into which it was brought in 5 November 1780. What follows is now added in January 1789. The third, fourth, and fifth sections intended, as expressed in the text, to have been added to this chapter, will not here nor now be given, because to give them in a manner tolerably complete and satisfactory might require a considerable volume. This volume will form a work of itself, closing the series of works mentioned in the preface. What follows here may serve to give a slight intimation of the nature of the task which such a work will have to achieve. It will at the same time furnish, not anything like a satisfactory answer to the questions mentioned in the text, but a slight and general indication of the course to be taken for giving them such an answer. What is a law? What are the parts of a law? The subject of these questions, it is to be observed, is the logical, the ideal, the intellectual whole, not the physical one, the law and not the statute. An enquiry directed to the latter sort of object could neither admit of difficulty nor afford instruction. In this sense, whatever is given for law by the person or persons recognized as possessing the power of making laws is law. The metamorphoses of Ovid, if thus given, would be law. So much as was embraced by one and the same act of authentication, so much as received the touch of the sceptre at one stroke, is one law, a whole law and nothing more. A statute of George II, made to substitute an or instead of an and in a former statute, is a complete law. A statute containing an entire body of laws, perfect in all its parts, would not be more so. By the word law, then, as often as it occurs in the succeeding pages, is meant that ideal object, of which the part, the whole, or the multiple, or an assemblage of parts, wholes, and multiples mixed together, is exhibited by a statute, not the statute which exhibits them. Every law, when complete, is either of a coercive or an uncoercive nature. A coercive law is a command. An uncoercive, or rather a discoercive law, is the revocation, in whole or in part, of a coercive law. What has been termed declaratory law, so far as it stands distinguished from either a coercive or discoercive law, is not properly speaking a law. It is not the expression of an act, of the will exercised at the time. It is a mere notification of the existence of a law, either of the coercive or the discoercive kind, as already subsisting, of the existence of some document expressive of some act of the will, exercised not at the time, but at some former period. If it does anything more than give information of this fact, viz. of the prior existence of a law of either the coercive or the discoercive kind, it ceases pro tanto to be what is meant by a declaratory law, and assuming either the coercive or the discoercive quality. Every coercive law creates an offence, that is, converts an act of some sort or other into an offence. It is only by doing so that it can impose obligation, that it can produce coercion. A law confining itself to the creation of an offence, and a law commanding a punishment to be administered in the case of the commission of such an offence, are two distinct laws, not parts, as they seem to have been generally accounted hitherto, of one and the same law. The acts they command are altogether different. The persons they are addressed to are altogether different. Instance: let no man steal, and let the judge cause whoever is convicted of stealing to be hanged. They might be styled, the former, a simply imperative law, the other a punitory. But the punitory, if it commands the punishment to be inflicted, and does not merely permit it, is as truly imperative as the other, only it is punitory besides, which the other is not. A law of the discoercive kind, considered in itself, can have no punitory law belonging to it. To receive the assistance and support of a punitory in law, it must first receive that of a simply imperative or coercive law, and it is to this latter that the punitory law will attach itself, and not to the discoercive one. Example: discoercive law. The sheriff has the power to hang all such as the judge, proceeding in due course of law, shall order him to hang. Example of a coercive law made in support of the above discoercive one: let no man hinder the sheriff from hanging such as the judge, proceeding in due course of law, shall order him to hang. Example of a punitory law made in support of the above coercive one: let the judge cause to be imprisoned whosoever attempts to hinder the sheriff from hanging one whom the judge, proceeding in due course of law, has ordered him to hang. But though a simply imperative law and the punitory law attached to it are so far distinct laws that the former contains nothing of the latter, and the latter, in its direct tenor, contains nothing of the former, yet by implication, and that a necessary one, the punitory does not involve and include the import of the simply imperative law to which it is appended. To say to the judge, cause to be hanged whoever in due form of law is convicted of stealing, is, though not a direct, yet as intelligible a way of intimating to men in general that they must not steal, as to say to them directly, do not steal. And one sees how much more likely to be efficacious. It should not seem, then, that wherever a simply imperative law is to have a punitory one appended to it, the former might be spared altogether, in which case, saving the exception, which naturally should seem not likely to be a frequent one, of a law capable of answering its purpose without such an appendage, there should be no occasion in the whole body of the law for any other than punitory, or in other words, than penal laws. And this perhaps would be the case, were it not for the necessity of a large quantity of matter of the expository kind, of which we come now to speak. It will happen in the instance of many, probably of most, possibly of all, commands endued with the force of a public law, that, in the expression given to such a command, it shall be necessary to have recourse to terms too complex in their signification to exhibit the requisite ideas, without the assistance of a greater or less quantity of matter of an expository nature. Such terms, like the symbols used in algebraical notation, are rather substitutes and indexes to the terms capable of themselves of exhibiting the ideas in question, than the real and immediate representatives of those ideas. Take, for instance, the law, thou shalt not steal. Such a command, were it to rest there, could never sufficiently answer the purpose of a law. A word of so vague and unexplicit a meaning cannot otherwise perform this office than by giving a general intimation of a variety of propositions, each requiring, to convey it to the apprehension, a more particular and ample assemblage of terms. Stealing, for example, according to a definition not accurate enough for use, but sufficiently so for the present purpose, is the taking of a thing which is another's, by one who has no title so to do, and is conscious of his having none. Even after this exposition, supposing it a correct one, can the law be regarded as completely expressed? Certainly not. For what is meant by a man's having a title to take a thing? To be complete, the law must have exhibited, amongst a multitude of other things, two catalogues, the one of events to which it has given the quality of conferring title in such a case, the other of the events to which it has given the quality of taking it away. What follows? That for a man to have stolen, for a man to have had no title to what he took, either no one of the articles contained in the first of those lists must have happened in his favour, or, if there has, some one of the number of those contained in the second must have happened to his prejudice. Such then is the nature of a general law, that while the imperative part of it, the punctum saliens, as it may be termed, of this artificial body, shall not take up above 2 or 3 words, its expository appendage, without which that imperative part could not rightly perform its office, may occupy a considerable volume. But this may equally be the case with a private order given in a family. Take, for instance, one from a bookseller to his foreman. Remove from this shop to my new one my whole stock according to this printed catalogue. Remove from this shop to my new one my whole stock, is the imperative matter of this order. The catalogue referred to contains the expository appendage. The same mass of expository matter may serve in common for, may appertain in common to, many commands, many masses of imperative matter. Thus, amongst other things, the catalogue of collative and ablative events, with respect to titles above spoken of, will belong in common to all or most of the laws constitutive of the various offences against property. Thus, in mathematical diagrams, one and the same base shall serve for a whole cluster of triangles. Such expository matter, being of a complexion so different from the imperative, it would be no wonder if the connection of the former with the latter should escape the observation, which indeed is perhaps pretty generally the case. And so long as any mass of legislative matter presents itself, which is not itself imperative or the contrary, or of which the connection with matter of one of those two descriptions is not apprehended, so long and so far the truth of the proposition that every law is a command or its opposite may remain unsuspected or appear questionable. So long also may the incompleteness of the greater part of those masses of legislative matter which wear the complexion of complete laws upon the face of them, also the method to be taken for rendering them really complete, remain undiscovered. A circumstance that will naturally contribute to increase the difficulty of the discovery is the great variety of ways in which the imperation of a law may be conveyed, the great variety of forms which the imperative part of a law may indiscriminately assume, some more directly, some less directly expressive of the imperative quality. Thou shalt not steal. Let no man steal. Whoso stealeth shall be punished so and so. If any man steal, he shall be punished so and so. Stealing is where a man does so and so. The punishment for stealing is so and so. To judges, so and so named, and so constituted, belong the cognizance of such and such offences, videlicet stealing, and so on. These are but part of a multitude of forms of words, in any of which the command by which stealing is prohibited might equally be couched, and it is manifest to what a degree in some of them the imperative quality is clouded and concealed from ordinary apprehension. After this explanation, a general proposition or two that may be laid down may help to afford some little insight into the structure and contents of a complete body of laws. So many different sorts of offences created, so many different laws of the coercive kind, so many exceptions taken out of the descriptions of those offences, so many laws of the discoercive kind. To class offences, as hath been attempted to be done in the preceding chapter, it is therefore to class laws. To exhibit a complete catalogue of all the offences created by law, including the whole mass of expository matter necessary for fixing and exhibiting the import of the terms contained in the several laws, by which those offences are respectively created, would be to exhibit a complete collection of the laws in force, in a word, a complete body of law, a panomion, if so it might be termed. From the obscurity in which the limits of a law, and the distinction betwixt a law of the civil or simply imperative kind and a punitory law of are naturally involved, results the obscurity of the limits betwixt a civil and a penal code, betwixt a civil branch of the law and the penal. The question, what parts of the total mass of legislative matter belong to the civil branch and what to the penal, supposes that diverse political states, or at least that some one such state, are to be found, having as well a civil code as a penal code, each of them complete in its kind and marked out by certain limits. But no one such state has ever yet existed. To put a question to which a true answer can be given, we must substitute the foregoing question some such a one as that which follows. Suppose two masses of legislative matter be drawn up at this time of day, the one under the name of a civil code, the other of a penal code, each meant to be complete in its kind. In what general way is it natural to suppose that the different sorts of matter as above distinguished would be distributed between them? To this question the following answer seems likely to come as near as any other to the truth. The civil code would not consist of a collection of civil laws, each complete in itself, as well as clear of all penal ones. Neither would the penal code, since we have seen that it could not, consist of a collection of punitive laws, each not only complete in itself, but clear of all civil ones. But the civil code would consist chiefly of mere masses of expository matter. The imperative matter, to which those masses of expository matter respectively appertained, would be found, not in that same code, not in the civil code, nor in a pure state free from all admixture of punitory laws, but in the penal code, in a state of combination, involved, in manner as above explained, in so many correspondent punitory laws. The penal code, then, would consist principally of punitive laws, involving the imperative matter of the whole number of civil laws, along with which would probably also be found various masses of expository matter, appertaining not to the civil, but to the punitory laws. The body of penal law enacted by Empress Queen Maria Theresa agrees pretty well with this account. The mass of legislative matter published in French as well as German under the auspices of Frederick II of Prussia, by the name of Code Frederick, but never established with force of law, appears, for example, to be almost wholly composed of masses of expository matter, the relation of which to any imperative matter appears to have been but very imperfectly apprehended. In that enormous mass of confusion and inconsistency, the ancient Roman, or, as it is termed by way of eminence, the civil law, the imperative matter, and even all traces of the imperative character, seem at last to have been smothered in the expository. Esto had been the language of primeval simplicity. Esto had been the language of the 12 tables. By the time of Justinian, so thick was the darkness raised by clouds of commentators, the penal law had been crammed into an odd corner of the civil. The whole catalogue of offences, and even of crimes, lay buried under a heap of obligations. Will was hid in opinion, and the original esto had transformed itself into videtur in the mouths of even the most despotic sovereigns. Among the barbarous nations that grew up out of the ruins of the Roman Empire, law, emerging from under the mountain of expository rubbish, reassumed for a while the language of command, and then she had simplicity at least, if nothing else, to recommend her. Besides the civil and the penal, every complete body of law must contain a third branch, the constitutional. The constitutional branch is chiefly employed in conferring, on particular classes of persons, powers to be exercised for the good of the whole society, or of considerable parts of it, and prescribing duties to the persons invested with those powers. The powers are principally constituted in the first instance by discoercive or permissive laws, operating as exceptions to certain laws of the coercive or imperative kind. Instance: a tax gatherer, as such, may, on such and such an occasion, take such and such things without any other title. The duties are created by imperative laws, addressed to the persons on whom the powers are conferred. Instance, on such and such an occasion, such and such a tax-gatherer shall take such and such things. Such and such a judge shall, in such and such a case, cause persons so and so offending to be hanged. The parts which perform the function of indicating who the individuals are, who, in every case, shall be considered as belonging to those classes, have neither a permissive complexion nor an imperative. They are so many masses of expository matter, appertaining in common to all laws, into the texture of which the names of those classes of persons have occasion to be inserted. Instance, imperative matter. Let the judge cause whoever, in due course of law, is convicted of stealing, to be hanged. Nature of the expository matter. Who is the person meant by the word judge? He who has been invested with that office in such a manner, and in respect of whom no event has happened, of the number of those to which the effect is given, of reducing him to the condition of one divested of that office. Thus it is that one and the same law, one and the same command, will have its matter divided, not only between the two great codes or main branches of the whole body of the laws, the civil and the penal, but amongst three such branches, the civil, the penal, and the constitutional. In countries where a great part of the law exists in no other shape than that of which in England is called common law, but might be more expressively termed judiciary, there must be a great multitude of laws, the import of which cannot be sufficiently made out for practice, without referring to this common law for more or less the expository matter belonging to them. Thus, in England, the exposition of the word title, that basis of the whole fabric of the laws of property, is nowhere else to be found. And as uncertainty is of the very essence of every particle of law so denominated, for the instant it is clothed in a certain authoritative form of words it changes its nature and passes over to the other denomination. Hence it is that a great part of the laws in being in such countries remain uncertain and incomplete. What are those countries? To this hour, every one on the surface of the globe. Had the science of architecture no fixed nomenclature belonging to it, were there no settled names for distinguishing the different sorts of buildings, nor the different parts of the same building from each other, what would it be? It would be what the science of legislation, considered with respect to its form, remains at present. Were there no architects who could distinguish a dwelling house from a barn, or a side wall from a ceiling, what would architects be? They would be what all legislators are at present. From this very slight and imperfect sketch may be collected not an answer to the questions in the text, but an intimation, and that but an imperfect one, of the course to be taken for giving such an answer, and, at any rate, some idea of the difficulty as well as the necessity of the task. If it were thought necessary to recur to experience for proofs of this difficulty, and this necessity, they need not be long wanting. Take, for instance, so many well-meant endeavours on the part of popular bodies, and so many well-meant recommendations in ingenious books, to restrain supreme representative assemblies from making laws in such and such cases, or to such and such an effect. Such laws, to answer the intended purpose, require a perfect mastery in the science of law considered in respect of its form, in the sort of anatomy spoken of in the preface to this work. But a perfect, or even a moderate insight into that science, would prevent their being couched in those loose and inadequate terms in which they may be observed so frequently to be conceived, as a perfect acquaintance with the dictates of utility on that head would, in many, if not in most of those instances, discounsel the attempt. Keep to the letter, and in attempting to prevent the making of bad laws, you will find them prohibiting the making of the most necessary laws, perhaps even of all laws. Quit the letter, and they express no more than if each man were to say, "Your laws shall become ipso facto void, as often as they contain anything which is not to my mind." Of such unhappy attempts, examples may be met with in the legislation of many nations, but in none more frequently than in that newly created nation, one of the most enlightened, if not the most enlightened, at this day on the globe. Take, for instance, the Declaration of Rights, enacted by the State of North Carolina in convention in or about the month of September 1788, and said to be copied, with a small exception, from one in like manner enacted by the State of Virginia. The following, to go no farther, is the first and fundamental article: that there are certain natural rights, of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Not to dwell on the oversight of confining to posterity the benefit of the rights thus declared, what follows? That, as against those whom the protection thus meant to be afforded includes, every law or other order divesting a man of the enjoyment of life or liberty is void. Therefore this is the case, amongst others, with every coercive law. Therefore, as against the persons thus protected, every order, for example, to pay money on the score of taxation, or of debt from individual to individual or otherwise, is void, for the effect of it, if complied with, is to deprive and divest him, pro tanto, of the enjoyment of liberty, videlicet, the liberty of paying or not paying as he thinks proper, not to mention the species opposed to imprisonment, in the event of such a mode of coercions being resorted to; likewise of property, which is itself a means of acquiring, possessing, and protecting property, and of pursuing and obtaining happiness and safety. Therefore also, as against such persons, every order to attack an armed enemy in time of war is also void, for the necessary effect of such an order is to deprive some of them of the enjoyment of life. The above-mentioned consequences may suffice for examples, amongst an endless train of similar ones. Leaning on his elbow, in an attitude of profound and solemn meditation, "What a multitude of things there are!" exclaimed the dancing master Marcel, in a minuet. May we now add, and in a law. End of chapter 17. End of an Introduction to the Principles of Morals and Legislation by Jeremy Bentham.